suspended my license, and I was like on the internet finding out, hey, I don't need a driver's license anyway. So
we'll get into that later. We're worried about your
I printed out a whole bunch of documents, basically, traveling around.
Right, whatever. That's irrelevant. All right, so Mr. Max. All right, sir, you've been charged with driving without a driver's license. Seems that you neglected to bother to come last time. How do you plead?
Well, I don't believe I can make a plea until I have further evidence, right?
Well, I have all the evidence. You've got the ticket, sir. You've been charged now. You neglected to come and give the court respect to show up here for the last time, and your driver's license was suspended. So now you're here to pay the piper or face the whatever, and charged. You've been charged. Don't laugh, sir. Okay. I want a response. How do you plead?
Objection. You're not ready to proceed. The prosecutor is definitely not ready. Wait, is that off track?
No, that's good. But you made statements in that comment.
Okay.
Yeah.
Did I? Mm-hmm. So I got to ask just questions.
Well, the way you presented it is like you already know this, and you're saying to them, "Yeah, it's a statement in a sense." No, you don't want to do that. Just keep asking questions. So let's keep it in a question form.
So, Mr. Swanson, again, how do you plead? I mean, I'm becoming very impatient. The prosecutors brought these tickets. I have all the information I need right here. Proceed. How do you plead?
I can't plead until I have a few questions answered.
Well, I'm not here to answer your question, sir. I'm really here to get a plea from you, and you're really trying my patience.
Oh, am I presumed innocent until...
yes.
I don't...
and I am one of the fairest judges here, and I'm going to give you every opportunity at your trial. Did you want to continue, and did you want a trial, sir? Did you want me to enter a plea of not guilty so you could deal with this at your trial?
No, I believe jurisdiction is a question that could be answered at any point of the hearings.
Well, Mr. Prosecutor, do we have jurisdiction?
Is that a statement?
Yes. He says that Mr. Prosecutor just assured me we have jurisdiction. I don't quite understand what your question is.
Oh, well, does he have proof
Not seen any facts to prove that's the case yet.
Yeah. Does he have any evidence of jurisdiction?
Well, I'm holding these tickets, and you've already shown that you wouldn't come to court before. I mean, there's a lot of evidence here that we have jurisdiction. He's showed me that he said he has plenty. So how do you plead, sir?
Objection. Non-responsive. Move to strike. Is that is that something?
That's a good way to end up in jail.
Okay.
But do it with laughing. Yeah. Say what?
You can say it. You can say it on your way to jail. Yeah.
Okay.
No. You're the kid.
Okay.
Now you're on the right track to a point.
Yeah. Oh, you're on the right track. That's right. Yeah.
You really have
some more fighting for your game, but.
So, Matt, are you reading the script at the moment? Then.
I've got them in front of me. I read them a couple times today.
All right.
Yeah, there's missing pieces there apparently, right?
Well, because it has so many different.
Yeah. Told me not to use the second script and use just the third one, but I'm finding that I'm at least going to need to use page 2 of the second script just to get through the.
You'll understand. You'll understand by the end of tonight, hopefully, exactly what all that means. So it becomes less of a script and more of an understanding of why you're saying it. Right. You know what I mean?
Right.
Yeah.
It's a concept more than anything else. Once you get this concept down, you'll be able to keep continuing this thing until they threaten to put you in jail or go home. That's that simple. It is not complicated. It is not about that script. It is about the ideology of asking them how this applies to me and where's your evidence.
Okay, because there's like unlimited questions I can ask, basically.
Yeah, because again, Gary.
Well, yes and no, but you won't get through unlimited questions. You'll have a list of a couple questions you like, and you'll just be hammering at those same questions over and pointing out that they're not answering them.
And Gary,
you're not answering my question.
Hold on. This guy's never heard this, and this is important. Max, get this drilled into your head. They are not questions. They are points of clarification. If you keep asking a judge or anyone questions, they will shut you fucking down faster than shit. You have to come back with point of objection, point of clarification. Is that what you're stating?
Now, Tom, you're saying that, and he doesn't yet understand the difference between a point of clarification and a question.
Well, they're both the same thing, but don't use the question.
They're not quite the same.
Can I be Max?
Can I get a few more clarities on Max? How did he get for arraignment? Was he arrested or this happened through the mail? How did it go from he didn't fix his head like his license was suspended to now he's getting arraigned?
Right. It's a
suspended license.
Computer-generated charge. It's a computer-generated charge.
So it came in the mail, and now this is the first time you're going to the courthouse?
Right.
Right?
Yeah, the second time after I paid my ransom.
Oh, so he already paid.
The ransom for the headlight or the ransom for the suspended license?
The arrest, yeah.
Oh, so you were arrested. So you were driving and you got arrested?
So he's...
Yes, yeah.
And he bonded himself out, and now you're going for the arraignment after the bonding out, correct?
Okay, all right, now I got it. Okay, thanks.
Holy shit.
Okay, so they've got a bond against you, is what you're saying.
I'm not sure if they do, because I got arrested in August of 2013, and I had to go to court after there, and I walked in there with a big stack of papers. I ended up basically, I think I pled not guilty. That's why I'm concerned that I'm doing an arraignment again, because that obviously means that I need to... Huh?
Well, if it was like half a year ago.
2013 is not relevant to the charges at hand.
Wait. Okay, so you appeared in court, call it that, before on this issue. Is that what you're saying?
Yes.
Okay, and you brought a sack of paperwork, and you're not sure if you pled not guilty at that point?
Well, no, I did plead not guilty, but why am I having to plead again then?
Okay, they might be rearranging you because there might be something they're trying to get squared away, or they amended the charges, perhaps?
Yeah, something doesn't add up.
Huh.
Okay, so maybe they amended the charges? Do you have new charges?
I don't think so. Yeah, I'm driving while license suspended. Doesn't look like new charges to me.
Okay.
So the last time you were there, what were the charges the last time you were there when all this sort of kind of got dropped?
It was still driving while license suspended.
And they just now scheduled the second follow-up thing this much later?
Yeah.
From 2013?
It's the second one. It's not the first one. You have to have two of them. So it's your second arraignment. You got arraigned on the first. It sounds like you have two of them. Something isn't adding up.
There are no two arraignments, Matt.
For two separate charges.
Yes, there's two separate.
With a suspended license, there would be.
Where are you getting up the second charge from driving with suspended license, though? The first one was a taillight problem, and the second one's now this driving. The incident. When did the incident happen that this is based upon?
The 16th day of August,
Last
2013.
Year.
So you were handed a ticket. Well, you got stopped for the light being out. They handed you a ticket for driving with a suspended license also, correct?
No, that was what suspended my license because I didn't show them my headlight.
Okay. So this is the proceeding. This is the continuation of a proceeding from almost 2 years ago.
Yes.
They consider that you probably waived your speedy rights, your speedy trial rights. Is that correct? Did you ask for continuance back then?
No. All I did was just plead not guilty, I think, and I wanted to trial by jury, is what I said.
Okay. So you're not aware of asking for a continuance?
No.
So why did it get continued for 2 years? Did they ask for a continuance?
They didn't ask me.
Okay. So from what you understand so far, they left 2 years go by while their evidence became stale or possibly fabricated or whatever, so that you could no longer have access to evidence from 2 years ago.
Yeah.
Right? Now, here's the trouble with that. Here's the legal and, well, I'm not going to address the legal, but here's the philosophical trouble with that. The reason that you have a right to a speedy trial roots itself in the idea that if someone's going to falsely accuse you, more time gives them more time to fabricate evidence against you and more time for the evidence of their fraud to go away, to evaporate. Okay, that's why the speedy trial rights are so regarded. Is there's a history of fighting that concept. So for a change, part of your attitude maybe you might want to consider is your concern about this passing of 2 years when you yourself aren't the one that asked for continuance. They just failed to address their issues for a couple years, maybe hoping that you'd forget why they were wrong, or maybe that you'd forget or lose track of people who could show that they were lying, anything like that. That's kind of the option, I guess you'd say. Is that,
so how do I voice that concern?
I think you'll understand that as we get through a little bit. But
who's the witness that you were driving with a suspended license? Who's the witness? So the witness is a 2-year-old witness that pulled you over for a bulb?
Oh, wait, no.
The bulb has nothing to do with it.
Who is the witness that you were driving with a suspended license for this charge?
John Daniels of the GSP, and I was given no badge number when I asked about him.
Okay, that's not really too relevant, but is this guy
still... They have to have
employed
2 competent witnesses. It sounds like they don't.
They have to have... What makes you think they have to have 2 competent witnesses?
Because some people I studied law with, that's what I've found out.
So I agree that there are some people who have opinions.
Stephen John Miller is the man.
I agree that there's people who believe that, but the question becomes are there people convicted in jail right now without 2 competent witnesses? And there are.
Yeah.
So by their own consent.
Bullshit.
The question is, the reason I brought that up is I was saying maybe he could attack and discredit the witnesses. And it sounds like he has a good possibility to do that.
Don't talk about consent in this situation, because there's no such thing as consent in a violent scenario. It's like he
shows up in court and speaks to the judge. That's consent.
Bullshit. When there's a gun in the room,
if you utter anything other than a question to them, that's consent. If you acknowledge any statement by the
when there's a gun in the room,
there is
no consent. Bullshit. That's like saying that a rape victim consents when there's a knife to her throat. That's bullshit.
No, that's different.
Room, consent is not relevant.
That's different. This is a contract. It's a hidden contract.
It's not. There is no such thing as invisible contract when there is force and threats of violence involved.
Well, the way I look at it, either you attack the prosecutor or the witness. It sounds to me like the witness is 2 years old. That sounds like a good way to go from my point of view.
I agree, but that invisible contracts bullshit is no relevance here, because we're not talking about invisible contracts. We're talking about violence. We're talking about violent subjugation and violent imposition upon people. Nothing to do. Your consent is not sought, required, requested, nor relevant. They're going to impose upon you whether you consent or not.
Well, my understanding is that's what the whole gist of this arraignment is, to get your consent to have this bar get involved in this case.
What makes you think you can stop this by withholding consent?
I didn't say that. I was looking to focus on discrediting either the prosecutor or the witness. In this case, from what I've heard so far, it sounds like discredit the witness would be a good venue. What?
Then why did you bring up contract and consent? I didn't bring it up.
So what you were saying about comparing it to a rape, it's different. There's no contract hidden with a rape victim.
I did that because you brought up the absurdity that a forceful of arraignment has nothing to do with contracts. That's like saying that rape has to do with lovemaking. That's my point. It is. It's ethically identical. That's my point. One. Okay, so let's leave contract ideas and biddable contracts and agreements completely out of this, because when there's a gun in the room, agreement isn't an issue. That's like saying that they're giving your wallet. Okay, so.
Well, not for nothing. Whatever happened with the headlight thing? That's been fixed? Are they aware that was been fixed? It's got you have to notify, and then through an affidavit, the court would get noticed.
But he still had a suspended license.
Because maybe this was done in error because you actually fixed the license, and you may blame it on them that they didn't get you notice that you notified them that you fixed it. So that might be another card to try to look at.
Well, it was suspended, I presume, under the auspice that it was a failure to appear.
Yeah, and then I ended up having to pay money and get a license back. So, because I have to show them that I got a new headlight or whatever, and I wasn't able to make it that day. So.
So you didn't actually fix your headlight in time?
Well, I did. They didn't see it, but.
Yeah, you would have had to bring it to a police officer, and then he would have sent the affidavit. Okay, so then that's not a credible way to go. Then, it's still a 2-year witness from 2 years ago. Who knows what notes?
No, I mean that's the question of evidence of jurisdiction guts pulls that right there.
Yeah, and you want to tie it in so that they have a scapegoat of the timeliness problem.
Because the argument, I'm not here to argue, and I'm not, in a sense, disagreeing with the code or the acts. I'm asking for evidence of jurisdiction that the Constitution of USA or Canada applies to me or anyone else in this room, and the acts and codes apply. That's all I'm asking.
That's a lot to ask. You should simplify that. That's way too much to ask.
Well, they claim they've got it. They claim they have that evidence, so it's not out of the question to ask it.
It's at the basis of everything they do. I was going to say, hi, Max, Gary, Tom, Dan, Vin, Keith, Scott, guys.
Oh, it's great.
Hey.
How you doing, Fabrice?
Yeah, it sounded like you were getting the end of the questions there, Max. I think if you can do that without making so many statements and load those up as questions, like what I call the inner Forrest Gump. It's just like
I heard that just the other day. I was
like I don't quite understand. I just want to know what evidence the prosecution has given you of jurisdiction.
Yeah.
Doesn't that?
Yeah, that sounds much better. Yeah.
It's a baby confession you're trying to get out of them, which is a very simple, not what is there in the universe and what evidence exists. It's have they got any of it given to them as of this moment? It's a much smaller question. It's like, well, okay, of all the money in the world, do you have even a penny of it right now? So it's of all,
like, in other words,
that might exist.
Gary, I like Gary's question of, is there any, does the prosecution have less than zero or zero burden of evidence? Is there anything other than the zero burden of evidence? I mean, that really boils it down to the simplicity. And if he says, well, yeah, he's got some, okay, where is it? What is it? And let me see it.
Yeah, I like that.
Let me clarify that a little bit there.
Plan. Who said that? I like that.
Gary said that.
He's really attributing it to me, but I want to clarify a little bit how he phrased it, because there was a little change there. But as of right now, in order to even do an arraignment, what is the level of proof that he needs to have given you of jurisdiction? Is it anything other than zero? Is it something other than zero that he needs to have as of right now?
And has he given you something?
Let's not get into bonds, please. Let's not get into monetization of birth certificates or any of that. For right now, let's focus on the arraignment issues.
Yeah, that's completely irrelevant. Yeah.
Gary, can I suggest that a good question to start out with is, what's the burden of proof here today?
Yeah.
That's good.
Yeah, and it's here today.
Does have the burden of proof.
And it's here today. It's not in the whole. They'll try to take it as they want to hear it. Like, you ever ask somebody a question and they hear what they want to hear and answer that question instead? The question that we asked him is, right, for this thing that we're doing right now, what's the burden of proof to begin this? And they want to basically go to zero, but if they confess that they have zero burden of proof on the prosecutor, then you can go for interlocutory issues that they don't want you to be able to go for, right? So they're trying to say, oh, yeah, he has a burden of proof to make sure he's got his ducks in a row to even start fucking with you, but we're not going to bother with it.
Yeah.
And that's the dichotomy. That's the problem we're trying to wedge, is that they're trying to say that that the prosecutor has the burden of proof to make sure that his ducks are in a row.
And they will tell you that they have it, and they're going to try to get you to go to a trial and prove that they don't. That's what you want to try to avoid at all costs. You cannot let them get you past arraignment. Once you've gotten past arraignment, it's over. So it's all about the arraignment and not backing down until they're either hauling you away or I don't know, cut a deal, I guess. I mean, that's always what I look at it as. It's all about damage control. And, if you piss them off enough, they will start heading your way with handcuffs, or they'll definitely start. Every time I've been in there, within 2 sentences, 4 sentences, judges already threatened me with contempt of court.
Really?
Last one, he told me, you get over in there in that box right now. And I didn't move. I just kept asking questions. They're going to intimidate you. You want to try some role play? Again, like we were doing earlier?
Yeah.
Okay. You're going to get called up. Judge is going to state, okay, you're being charged with such, and such. We really don't give a fuck what the charges are. It doesn't matter. This contract shit, none of that. I don't care. Okay. I've brought charges against you. Me and my buddies here. I wear a robe, my buddy's got uniforms on, and we say you violated the law. What do you say, sir?
Well, I'm going to need a few points of clarification.
Such as what? And I'm very impatient.
Well, what is the burden of proof?
I don't quite understand your question, sir.
Does the prosecutor have a burden of proof?
Yes, and he's presented the ticket. I'm holding it right here. You didn't show up last time. It's very disrespectful. I'm going to try to be patient with you, sir, but you're really trying my patience. I have all the proof I need right here. They presented it. Now, how do you plead?
Well, oh man, I don't know. I'm getting stumped again.
Okay. Now, what you say to that? Oh, sir, you have the ticket? Does the evidence on that ticket, can you show me the evidence on that ticket that meets the burden of proof here today?
Well, I mean, it's right here. I mean, he did such and such. He drove without a license. His license was suspended, and it's all I need. It's right here. Here's the ticket.
Objection. That's not what I asked you, sir. I asked you, can you show me the evidence on that ticket that meets the burden of proof here?
Sir, it sounds like you wanted to go to trial so that you can argue your.
No, sir. I'm not. I'm just asking you the question. You just said that you had the ticket and the evidence was the ticket. Is that correct?
Yes, it is.
Okay, so can you show me the evidence on that ticket that meets the prosecutor's burden of proof here today?
Well, I don't quite understand what you're saying. Are you don't understand English, sir? I'm holding the ticket right here, and it sounds like you really want to argue this at trial and have your fair day in court. How do you plead? I really need to plead.
No, sir. I totally intend to cooperate. I've got an unsigned plea of guilty right here. See, I just want you to show me the evidence on that ticket that you just claimed was on that ticket that provides the burden of proof for this prosecutor to bring me here today.
Well, see, you have a copy of the ticket in front of you, right?
Yes,
the officer signed it. The prosecutor verified it. It's warranted. It's a legitimate ticket. Now, how do you plead? I mean, this is ridiculous, sir. How do you plead?
Oh, I'm sure. No, I'm sure. Well, show me the evidence that you claimed was on this ticket that provides the burden of proof that the prosecutor has today.
Just ask them, please answer yes or no. Is the ticket evidence of a crime? Yes or no? Just ask them that.
If I were a legitimate judge, I couldn't answer that legally, right? So now I would have to go. So, Max, you can see they're going to try to go a lot of different angles on you.
Yeah.
And that's all
the ticket is evidence that somebody's accusing you of something. It's not evidence of anything more than that.
Yep.
It's evidence of an accusation. It's not evidence of a crime. It's not evidence that the law applies yet, any of that. But what they're trying to do is they're trying to put you into a situation where that's as good as a given, just simply based on the fact that you've got a ticket against you.
Yeah, and if you don't like it, we have guns. I like to get. I know this is Crash Course, Gary, and I love the 1, 2, 3. Gary's got a 1, 2, 3. 1, the unsigned plea of guilty. Have you got that, Max?
Yeah.
Okay. So you walk in. You know, I fully intend on pleading.
Wait, you haven't explained to him what the point of the 1, 2, 3 is.
Hold on. Well, I'm going to go.
There are segues to get back on topic. But there are segues.
Yeah, but he doesn't have a lot of time, man.
Segues to get you back onto your question. Okay, but giving him weird information that doesn't relate to anything isn't going to get him forward.
Well, this is how he's going to have to keep this thing circling tomorrow. I mean, this is how I see it. The concept is, okay, you, as I just said to him, I'm wearing a robe. Me and my buddies over here just said that you broke our law and you're going to pay us. I mean, it comes down to that fucking simple. Literally. So now, you are going to say to us, following our own rules, hold on a second. Yeah.
Okay, if I just came back,
you and I just spar a little bit. Super slow motion.
Say again.
Oh, sorry.
Sorry, Gary, my fault. Max, I've just dropped in some notes for you. Hopefully, you've got a Word document and you'll be able to, or you've got Word on your computer and you can open them up. But I've just dropped in a few little notes and a small script for you to help you along.
Awesome, thank you.
The script,
so how about this, Tom?
Yes.
You and I, how about we go through a little bit of a role play, super slow motion with some breaking the fourth wall and explaining what we're about to do kind of thinking so that you can see, like, I don't know, a slow-mo back and forth with explanation of why we're saying things, okay?
Okay.
So you'll be the judge, of course.
Yep.
Your goal is to keep me, is to make me think you've answered my question, and my goal is to make sure I actually get my question answered. Right?
Yep.
Okay.
Thanks. So you start out with we'll take it as given that the judges went ahead and denied whatever motions. He's read the basic charge. He's ended with how do you plea? And my first thing is I'm going to say, just like the video with the plea of guilty, I have an unsigned plea of guilty right here. I just have some clarifications. Do I have the right to know the cause and nature of these proceedings? Let's start with that question. It's just a random one.
Perfect. Mr. Capps, you understand. You have the ticket in front of you. It's all been explained. You violated the law. How do you plead?
I'm just trying to clarify here. Do I have the right to be informed of the cause and nature of these proceedings here today?
Well, absolutely, sir. You've been informed. You've got the ticket. It's explained all right in front of you.
Thank you, sir. Making note of that, circling my question and checking it off as yes. Excellent. Am I presumed innocent of this accusation here today?
Of course, sir.
Outstanding. Am I presumed innocent of every element of this accusation here today?
Sir, I'm not here to hear your colloquially, and if you want to fight this, I suggest you take this to trial. I'd just like to get your plea. Do you plead guilty or not guilty?
My intention is to plead guilty here today. In fact, I'm trying to clarify some things here. Current clarification, I'll read that again. Am I presumed innocent of every element of the accusation here today?
Absolutely, absolutely.
Is jurisdiction one of the elements that I'm presumed innocent of here today?
Oh, I see where we're going with this. Yes, and we have jurisdiction, I assure you.
Thank you. So yes, jurisdiction is one of the elements that I'm presumed innocent of here today, correct?
Sir, move on. I just told you we have jurisdiction, and I really want to get your plea right now. You're really trying my patience.
I mean, perhaps I'm just trying to make sure I didn't mishear you. You said that I'm presumed innocent of jurisdiction here today. Is that correct?
Sir, I've explained to you that we have jurisdiction, and it sounds like you really want to go to trial with this. And to be fair, I think I'm going to enter a plea of not guilty for you, sir. When does
intention is to plead guilty here today? I have here an unsigned. I'm sorry, I didn't hear you. My intention is to plead guilty here today. In fact, I even have an unsigned plea of guilty right here in my hand. I just have the clarification that I just asked, which is...
Sir, I can't take a conditional
to clarify what
plea.
you just said.
I can't take a conditional plea, and I really need you to plea. There's people behind you right now, and they would like to move forward. It's very clear. We have a ticket right here. This officer issued it. The prosecution has verified it. How do you plead? I'm getting very impatient.
I see that you are. My intention is to plead guilty here today. I'm just trying to clarify a simple point that I just asked. Is just what to see if I heard you correctly.
Did you say you wanted to plead guilty?
Innocent of jurisdiction today.
Wait a minute. We could cut right to the chase.
In fact,
Did you say plead guilty, sir?
It's my intention to plead guilty here today. I have an unsigned plea of guilty right here in my hand.
Well, then we could all
clarify what you just said.
We should I just enter a plea of guilty, sir? I mean, we could all go home and make this very simple.
Well, I'm just trying to clarify the point that I just asked, which is, did I hear you correctly in saying that, yes, I am presumed innocent of jurisdiction here today?
Sir, we've gone over this jurisdiction. I've ruled on it. I've read your motions. I've ruled on those. I'm not going with this again. I'm not going through this again. That you can argue that at trial.
I'm not asking to argue anything at the moment. I'm just trying to clarify what you'd said, and if I heard you correctly. Did I hear you correctly in saying that I am presumed innocent of jurisdiction here today?
Sir, I've told you.
I'm so sorry if I misheard you.
I explained to you. You're presumed innocent. Now, how do you plead? It sounds like you really want to go to trial so that you can have your day in court, and the prosecutor can face the prosecutor. You may want to hire an attorney.
Yeah, the answer to that question I heard you just fine on, and I have notes of that, that I'm presumed innocent. Yes, thank you very much for that. My question, clarification was, am I presumed innocent of jurisdiction here today? And that answer, I'm just trying to clarify if I heard you correctly. Maybe my hearing was faulty at the time. You seem to be not wanting to restate what I maybe misheard. Am I presumed innocent of jurisdiction here today?
Well, now I'm going to go a little out of character. Now this is again, Max. He's listening.
Mm-hmm.
Right? You can push this to the point where the judge will say, I've made this decision, and we're gonna continue here in a minute because I want to go through the 1, 2, and 3 of Gary's 1, 2, 3.
Hold you in contempt, young man.
That's so. Yeah, exactly. If you mention this jurisdiction thing one more time, sir, I really want to get a plea from you. I've decided the jurisdiction, and I'm about to hold you in contempt of court. So if you mention jurisdiction one more time, I'm going to have you arrested.
Just one more time.
How do you plead, sir? No, this shit can happen. Ask
sir.
His son.
Hold.
Yeah.
All right, hold on for a moment while I make note of the topic that I'm no longer permitted to clarify safely. I'll write that down. No longer permitted to safely to clarify this topic.
Now,
right,
Max, listen to what he's saying. This is very important. Mark does this when he does his calls of shame. If you listen to some of his calls of shame, he'll say things. Hold on, let me write that down, and he'll repeat it as he's writing it down. That's very effective.
No, I won't say jurisdiction. Yeah. I won't say jurisdiction because he said if I mention jurisdiction again, I'll be held in contempt, and I'll take him at his word for that. And now what I'm doing is I'm turning that around on it, and I'm saying, here is a topic that I am no longer safely permitted to clarify. I am basically telling him that I'm making note that he forbid me from clarifying the cause and nature of the proceedings. And I'm going to bring that up if he says, if he asks me if I'm ready to proceed. I'm going to go straight back to that and say, well, there's a topic I'm not permitted to clarify. If you want to permit me to clarify it, then maybe we can get on with the plea, you know.
You're begging to them.
So I'm going to go.
Well, I was going to say, I mean, at this point in time, it seems like the prosecution's right out of the ballpark. They were sitting in the bleachers. We got to focus back.
Sure, the prosecutor has.
Well, we got to go back to the prostitution.
So the questions I chose were rather random.
Okay.
What do you mean?
Okay, there are better questions, but it got to a heart of something he didn't want to talk about, which is, well, the evidence of applicability is probably a better question than are you presuming jurisdiction?
Well, let's get back to the.
Agree?
Let's pretend that there is a biased opinion with the judge, and that's what he's there for, right, Max? Or for the balance being the scales of justice, so to speak. Well, are you aware that the conflict of interest lies in that the prosecution, the cop, and the judge are paid by the same so-called city or entity? Are you aware of that?
Mm-hmm.
So you're aware of a contradiction in justice, if pretending that there's.
Now that's a different line of question.
Well, it is part of the understanding in the role play. I think it's important.
Say that again, Keith.
The conflict of interest lies in the three parties, so to speak.
Yeah, the conflict. I'm sorry.
Conflict of interest, very important to get a fair trial. If so that's just another avenue. It's a very good one, very effective one, actually.
Oh, okay.
Well, again,
hold on, Gary.
Trial, but even
Gary, just give me 1 second. Just 1 second. Here's what we're talking about. This thing, Max, is you should be able to go round and around and around if you take the topics that are in the motion to dismiss. Did you file the motion to dismiss?
I haven't yet. I'm going to do that tomorrow.
Okay, it doesn't matter. You have those.
He can bring that in with him. Yeah.
Yes, exactly. And those are the topics, just as Keith just brought that topic up, that once he gets done and threatens you, he says, I have jurisdiction. Okay, just put that one on the back burner and move on to the next topic. Now let's talk about standing.
Oh, that's bad advice there, Tom.
Why would you say that?
You just said, put that on the back burner as soon as he says, I have jurisdiction, and that's real bad advice.
Not as soon as.
It's making note on the record.
That's what you just got done saying.
It's just evidence on the record that he admits to that. You can't change it. You just move forward to the next question because
I know,
right.
But that's not right. You don't want to as soon as, because he'll do that rather early, and you know it. I know what you meant, Tom. But what I just don't want Max to take away from this is as soon as he assures him that he has jurisdiction, move on.
No,
that's not right.
No,
that's not good advice.
Look how you and I went around. When it gets to that point, when I tell you, Mr. Caps, you mentioned one more word about jurisdiction, all I want to hear is how you're going to. All right, so now this is where I'm saying he can relieve and move on to another topic and come back to it later. That's what I mean.
And this is why I mentioned very specifically, I am making note that I've been threatened with violence if I continue clarifying this topic.
Point number 2.
I can clarify other points.
Yes.
But I've been threatened with violence, and that's number 2, the gun in the room.
Yep.
When I need to come back to a topic, I said I'm only here by threats of violence, and I'm even under threats of violence not to clarify your own statements if they're on a certain topic. And the prosecutor's assertions if they're on a certain topic.
And the threat of violence is where they use the, you have a license, Max, Mr. Max card, right? I used to have it if I want.
So we have jurisdiction applied for a license.
Right. Well,
and you begged us for a license and so forth.
Right.
Or any threat of violence. Always try this one, too. It's been successful for me, Max. As soon as a judge says, I didn't do it the last one, I just ignored him and kept talking. But anyway, as soon as he says, I find you in contempt of court or I'm going to find you in contempt of court, I popped out with, are you threatening me, sir? And they will always go, oh, no, I'm not threatening you. They want to make sure that record is clean.
Really?
I like the other form, which is it contemptible to ask relevant and unanswered questions about the cause and nature of these proceedings? Because that's what they're trying to imply, is that you're going to be held in contempt for asking a question, a relevant and unanswered question about the charges, about the cause and nature of the very proceedings that they're saying you have a right to be informed about. See, they're trying to say you have a right to be informed about these things, but they're trying to, at the same time, pressure you not to ask any damn questions about it.
Yeah.
And that's exactly the game that they're playing. They're saying you have the right to be informed. Yes, it's all good and proper, and we don't do anything half-assed here. But ask a question, and then they start poking you in the ribs, right?
Mm-hmm.
And they want to make it look like you abandon your questions. They want to make it look on the record, on the written transcripts or whatever, or in retrospect, they want to make it look like you abandon your questions and you were morally persuaded to drop your bullshit questions. You know, and they didn't threaten violence to get you to drop it. You just went on to a new topic. By George, it's on you. Now I understand that whole agreement versus.
Gary's last statement, when you and I were just playing, and I got you to the point where I said, I want to move on, I have jurisdiction, and that answer you gave, those are the script things you want to have. That answer that Gary gave right there was a good one before you move on to the next topic for safety purposes and keep the thing going. When you said that, Gary,
the attitude is behind that is, I am doing this because it's not because it's right to do this, but because it's the only safe thing that you're permitting.
Exposing the gun in the room.
You see, they want to make it look like you moved on because it was right. They want to make it look like you moved on because it was the right thing to do. I'm clarifying, it has nothing to do with right and wrong. It has to do with you issuing threats of violence.
Yeah, it's no longer safe to ask that question, right?
Right.
It's no longer safe. It's no longer safe to address that issue that we were just, and I wouldn't even say jurisdiction. I would not say the word jurisdiction.
Right.
Yeah, that's a good one. It's no longer, I feel it.
But I would ask.
No, that's good, man. That gets it into the record that it's a threat. I no longer feel safe to ask the question. Oh, that's a beauty. That's even better than, are you threatening me? I like that.
So who's got ownership over me here today then, sir?
And you missed it at the role play because you were, kind of focused on what you needed to say. But I said that. I mean, I said it's no longer safe for me to address that topic,
right,
and clarify that topic and the prosecution's assertion on that topic. So then I'd say I'm making note and I'd say it aloud and I'd make a motion to strike the whole damn thing and recuse that judge over it. But that's aside the point. I'd go on and clarify some other things as well. Since we have them here, we have other things other than phrasing it as jurisdiction. There's other things we can address.
And here's another one
that I can avoid the word jurisdiction.
Something that these guys that I've noticed, and by listening to others and just things that have happened to me, they'll pop up with, "I don't understand your question, sir. Move on. What's your next question?" They'll act like they're stupid that they don't understand the question of what you mean by jurisdiction or how the code applies or the laws or the Constitution and all the shit.
But you notice how he said, he didn't say rephrase it, he says, ask a different question.
It's plain English. I don't know. And I always reflected that motion to dismiss because that is your defense, in a sense.
Yes.
So now, let's get that back on the table. And even if they deny it, you ask on what grounds, and they'll say because we have jurisdiction and we own the frickin' planet. Too fucking bad. And, and then he says, okay, do you have any facts or evidence to back your accusation? Is that still not a legal opinion? I mean, right? It's not facts or evidence. It's this gibberish garbage we go up in circles.
Hold on. So first off, I mean, we're all presuming that he understands the difference between an opinion and a fact, and that's something that really gets a lot of people messed up. And a lot of people think that a fact is an opinion that's really, really strongly held, and a whole lot of people think that. So a fact, roughly speaking, is something that a physicist would tell you is actual, something part of the manifest real world, an event or an object in the manifest real world. That is factual information. A scientist can measure it, deal with it, things like that, right?
And literally, listen to me. That's a good one to have. No, hey, listen to it. That is a really fucking good thing to have in your holster, because when the prosecutor looks at you and says, "What do you mean by fact?" I've had him ask that. That's a good one right there. I don't understand. What do you mean by fact?
We don't need those stinking witnesses.
No, that's not what he meant. He was He believed the words. No, dude, I'm serious. He looked at me. He was absolutely dead sincere. Looked at me and said, "The words are right here. It's in the code. I mean, I don't understand. What facts do you want from me?" That's what he said to me.
Oh, that's different. That's different. He was just trying to do. I mean, if he just actually said, "I don't understand what you mean by facts," I would have asked for that to be in writing, because
No,
I would make that a motion to dismiss this complaint on the fact that this prosecutor didn't know the difference between opinion and fact.
Well, he had the code right there and was waving it and saying it's right here. I don't understand your question. It's right here. What is it that you don't understand?
Facts don't matter.
That's
Facts don't matter. It's presumption and assumption.
That's the written legal opinion.
Okay, all right. Let's play this one. Let's play this one. The prosecutor just slammed down the code book, explained to Mr. Capps that the facts are right here. It's written right here, and I'm the judge. And I look at Mr. Capps and say, now, how do you plead? He just showed you the facts. What is it that you do not understand? There they are, right there.
Well, what was the question? In this hypothetical, what was the question I just asked
The
about?
hypothetical was, the facts are, you asked for facts.
It's like going back to the website in taxes. So that's the fact.
No. Stop. No. What fact did I ask for? Did I ask for evidence of jurisdiction? Is that what you mean?
Yes, I have the codes right here say that this applies to all the citizens right here in St. Clair Shores. And are you above the law, sir?
The jurisdiction.
So the hypothetical is, I asked for evidence of jurisdiction. Okay. And so my question is, okay, you're saying that the evidence of jurisdiction of this court, in particular, about this clause and about this proceeding, is written in that book there.
That's right.
Is that what you just said?
Prosecution has showed it to you. It's the code.
Now, he's shown me the book, and if you intend to give me a copy of the book and maybe some direction about where these facts are.
Sure, the copy of the book is on the internet, and you said you wanted to something that a physicist could physically show you, and he just showed it to you. It's right here. Here, I'll let you have it. You can take this and look up this code, sir. Now, how do you plead?
Okay. Now you've just contended that the evidence of jurisdiction is written within that book there. Obviously, there's a lot of extra information in that book, so it'd be much quicker if you could limit it to a page or two to begin with.
Well, sir,
what page is the evidence on?
It sounds like you really need to hire yourself a licensed attorney. He can explain all these things to you, sir.
Oh yeah.
How do you plead? How do you plead?
I see. So will the prosecutor's case be stated for him by this attorney that you propose I hire?
The prosecutor's case is stated, sir, you're really trying my patience. I think you may want to go for a psych evaluation. You don't seem to understand.
There's another point, Max, where the judge will say you should seek legal advice.
Or a psych evaluation, because you don't understand.
Hire a lawyer to answer these questions.
That's a good idea, though. You can get by.
Well, you did two things at once there.
So I say, are you practicing, what the hell do I say? I said, you practicing law from behind the bench, sir? Or no, sorry, are you giving a legal opinion?
No, that's
what I say. Oh, I am not.
Okay.
Yeah.
I've tried that one. It gets you nowhere, really.
Okay. Yeah, it's one of those little circular things that doesn't really gain you any bonus points, really. It doesn't look bad on him.
Yeah,
the 1, 2, 3 works best.
You don't really want to buy time. You don't want to buy time, though. I heard mentioned, but you really want to get an answer. You don't want to buy time. You're there to get an answer. Mm-hmm. I mean, the prosecutor's the only one who can use time.
Well,
it's his move. There's
time
no
to
buying
get an attorney is what I was going to say. Time to get an attorney so he won't have to plea to tomorrow.
Again, my angle was clarifying that if I hired an attorney, would this attorney be the one who's clarifying these answers that the prosecutor is supposed to see? They're implying that I should hire an attorney to get answers from the prosecutor.
All right, I'll say yes. I'm the judge that says yes. He'll clarify all that for you, sir. Now, please, how do you?
Okay, so the prosecutor's assertions will be confined to the answers that I get from this attorney that you propose I hire?
Sir, your attorney will explain this. The law can be very complicated, and we really want you to have a fair chance and a fair trial. And I'm the fairest judge you can ask anybody. And sir, you really, really should plead not guilty and have a trial and seek an attorney. It'd be much, much better for you.
Well, your advice is noted, but for the moment, my intention is to plead guilty here today, and perhaps the burden of stating a case should be on the prosecutor and not upon me to pay an attorney to state his case for him, which is why I have the question. What's the current question? Is there any evidence of jurisdiction that's been provided to the court as of yet?
Well, again, I've explained to you the ticket is all I need, and I have jurisdiction, Mr. And I'll even play really nice, Judge. Mr. Capps, look what happened to I can't remember his name. He was on a while back with the drinking and driving, and the judge is a woman, and she says, Max, listen, I've seen people go through this, and they get this stuff off the internet, and it's just not going to help you. You should just take the plea, pay the fines, and just do what you need to do. So, how do you plead, Max? Come on. I heard
the nicest I've ever heard Tom ever.
Gully Guff.
Let me make note that your standard of proof is met by this ticket and something within it that I'm trying to discover here. So your burden of proof was met by some evidence that's within this ticket. Is that correct?
Sir, I don't know what else to explain to you. I really think you need an attorney. Yes, we have all the evidence we needed. It's right here. It's in the code. I mean, you asked for physical evidence, something that a physicist could show you, and I've showed you this.
Now I'm confused. You're going back to the code.
Are you sure you're not a judge?
Now you're going back to the code. Is this evidence that you're
I'm just good
in the
at this,
ticket or in the code?
Yeah, I'm more like a judge than a mechanic.
I know, dude. This is like I'm a psychopath. I can tell. This is easy. I've been through these. I've had these guys.
All in the code,
dude. Everything that I'm throwing at you, I've had thrown at me. No shit. That's what I'm trying to tell you. They'll fuck with you and try every angle to get you to plead tomorrow. And the thing is, as a crash course,
those weapons of mass destruction must be somewhere.
Listen, the crash course is 1, 2, 3. I intend on pleading, sir. You do not need to plea. Every time he says, "Listen, I'm just going to enter plea objection," I intend on pleading. I'm fully ready to plead. I have it right here. I just need to understand. I know.
Ready to plead.
Careful with that word. I agree. I need to be informed. I need to see the evidence that the prosecutor has presented to have that this court has jurisdiction over me, and that the code applies, that these laws apply, just because I'm physically standing here. And then until when they get finally fucking fed up with that, and literally threatening you, Gary, I like to use all of the things in the motions, the standing, the corpus delicti, and just keep fucking rotating them, man, forever until they say, fuck this, go home, or go talk to the prosecutor in the hallway. That's what's coming. You go out there.
Go. That's what's coming.
And that's what you want.
Because they're promising you that you'll be informed, and then they're punishing you or threatening you every time you try to clarify something. And until you say, oh, well, I just don't seem to have any choice but to plead not guilty and move on. That's the point. They're trying to make you feel like you have no alternatives but to go with their trial.
To threatening, to literally
your alternative.
Good point. Yeah.
Well, they'll offer him something. There's no offer until after they arraign him.
No.
Well, I mean, they'll offer him something in the sense that they'll send him to the hall. The judge can't offer something.
And that might be his best
option.
And the judge doesn't have a past history of suspended licenses.
But that's plea bargaining. That's like making deals with the cokehead in the fucking alley.
So, Keith, listen.
Well, it beats hiring a lawyer.
Well,
you don't have to hire a lawyer.
There's no winning.
He could buy some time by saying that's what he wants to do and not even plea at all and say that he needs time to hire an attorney. He just doesn't understand.
Then ask the judge right now, on the record, does the prosecution have evidence of jurisdiction to apply the act or code or / Constitution of Canada / Constitution of America to me or anyone else in this room here today? That's it.
I'd start leaving the word
Constitution. And one of the things...
When you start throwing that word in there, laws, codes, and shit like that, ordinances. But when you start throwing Constitution in, the first thing the judge goes, I know where we're at. I've had him say that. I get it. Quit the Constitution shit, because the first thing they did with every time Mark's on, I'm not a constitutional scholar. I'm not arguing the Constitution. Fuck the Constitution. Don't even say that word.
Right.
I just want to know how these codes apply to me. That's it. That's where you're at. They're codes. And stop with the Constitution.
Okay, then use the, just because I'm physically located in so-called Canada, America.
How do these codes apply to me just because I'm standing?
It's a jurisdiction that you apply the code. Yeah, you did that way. Yeah.
And is it only force? Are your codes only applicable to me?
Okay, can I just add something quickly, because I can't stay on much longer because I've got to get up for work in the morning. But the thing is, Max, is just try and get as many questions in there as you can. It's all going to probably be over within 10 minutes or so. You ain't going to have very long. Just get in as many questions as you can. Don't worry if you cock up and you miss things, or you don't get everything in there that you want, or you might realise afterwards you shouldn't have said something. Don't worry about it. You'll probably get forced into trial anyway, and the judge will plea for you, not guilty. From that point on, that's when you can ask to have the plea vacated. You might be able to have the case kicked out by then anyway, because they're going to screw up during the arraignment. So all you're trying to do is you're trying to put the groundwork down to have it kicked out on appeal. If not, you want to try and get it kicked out before it even goes to trial. So that's all you're doing. You're getting them to show their cards, basically. Screw up, prove they're not going to listen to anything you got to say, prove they're not going to give you a fair hearing, and that it's completely arbitrary, and that's basically what you're trying to get out of them.
Listen, I have to argue that, Vin. There are a couple of guys that have successfully. Paul was one, and there was another one just recently, a newbie. Both brand new fucking guys literally have arraignment number 2 coming up. That blows my mind. So don't always assume there's going to be a trial. Don't do it.
Well, okay, that might not be. All right, that might happen, but he's only got a day to prepare. If he had longer, then we might be able to get him prepared for something like that. He's only got a day left to prepare, so chances are he's going to get forced into trial. But like I say, what this is all about is establishing he can lay grounds down where he can write into the court and say, I never gave a plea, the judge did that for me, they wouldn't answer my question.
Yeah. Where you
jurisdiction,
at, Matt?
Blah, blah, blah.
Objection.
You can rack up a shit list against them before you even go to trial. Sorry?
Gary.
So like I say, that's all you're trying to do. You're trying to build a shit list up against them of things that they're going to do wrong as far as an abuse of process is concerned, and then you might be able to get it kicked out beforehand. That's all we're trying to do, and that's the best in a lot of cases. That's the best we can hope for. So you're just laying that foundation. You're not trying to get it kicked out. You probably won't, not straight away anyway. You're just trying to lay that groundwork to get them to show that right from the get-go, right from the beginning, they never had a valid case, and they're prepared to break basically every rule they're meant to stick to in order to get you into that trial and get you convicted. And that's what you're trying to prove. And it's not very hard to do, because like I say, that's what these questions are all about. It's all about getting them to expose themselves.
Thank you, Vin, for clarifying. That's exactly it, Matt.
I like it. Yep.
So like I said, I've got a knock off, so you lot can carry on helping Max. And
I'm gonna get some dinner myself.
I've got to get some sleep.
Good night, Ben.
It's midnight where you are?
Yeah, it's 10 past 12 midnight for me, and I'm up at 6, so I'm only going to get a few hours.
Oh, man.
Yep, I know the feeling, brother.
That's all right. It's been a bank holiday, so I had the day off. I went fishing today and had the day off work, so...
yeah.
And I saved the fish as well, which I was happy with.
All right, boys, I'm going to get something to eat, so I'm going to end the call, and this is
okay.
I don't like wishing good luck, Max, but you'll do well.
Thank you.
Stick to the strict.
Like I say, I've thrown a few little notes in there, and I've added a few little bits in the text box there as well for you to look at. If you're wondering about what logic is all about, what the principles are, and all that, there's only 4 of them. Have a read through them. Hopefully, you can understand them. They're not too difficult to get your head around. And I'll say there's another one that I've sent you, another little path with a killer. It's called the killer question. It was a question I came up with that I've used in court a couple of times myself now, and it does screw them up a little bit because all you're trying to do is, irrespective of the burden of proof, when somebody's trying to prove something, they should just simply be able to prove it beyond contradiction, shouldn't they?
So you have to choose your questions wisely. You won't get to ask them all.
You might not, but you may find, however that it goes, you may find that you might be able to fit it in there somehow.
Well,
it just depends on how it goes.
The record as contradictions. That's
it. Yeah, that's all you're trying to do. You're just saying, well, whatever the burden of, because if you get stuck on the issue of the burden of proof, and he says, well, it's beyond reasonable doubt and all that, and he tries explaining it to you, that's not going to make a lot of sense to you, especially the way they do it in legal reasoning. So it's just basic logic, the way a layman on the street would understand it. If someone's going to prove something, well, then you shouldn't have. Well, then you won't be able to contradict it. If it's true, there's no way you can contradict it. So that's just basic logic. Yeah,
that's right. It goes for any accusations that's made or hearsay or argument.
Exactly. Yeah. If someone's going to prove to you it's an apple, they're not going to go putting a pear in front of you and trying to convince you that's a pear.
It's not even a matter of a script. It's a concept. When you enter this thing, it is literally the Socratic method of eliminating false hypotheses. It's that simple.
Yeah. But like I say, that's why I put up those 4 principles of logic, because that's what covers it. And the fourth one, where it says law of sufficient reason, think of that as justification as well. It's all about justifying what they're doing. And the way they're supposedly having to justify themselves is based on the facts that they're saying you violated somebody's rights, therefore there's a victim, therefore that justifies what we're doing because you created a victim.
Right.
Can I ask you a few questions?
So that's why you're asking for evidence of that. Yeah. Sorry, go on.
Before you go, are you in the rush to leave, Max? Or can I just ask you a few questions? What is your goal here? Are you looking to use this as a case to learn from, or are you just looking to get your license back as quick as possible?
Well, let's see. I already have a license. The thing is, if
you have a license, so it's not suspended anymore?
But if I plead, then they're going to suspend it again.
All right, well, here, if this were me, this is how I'm looking at it, because it's been so long. You're saying it's been 2 years. That's pretty damn long, okay? If you have your license, why not just drag it out longer? So, and you can do that by saying tomorrow, I can't plea on now. I'm confused. I need let me get an attorney, and we'll come back. And that needs some more time.
No, Scott, man, you're really new here, aren't you, Scott?
No, I've been here for years.
Huh? Because you don't seem to get the gist of this thing. Are you kidding me?
Well, his license is not suspended right now. If he gets arrested for contempt tomorrow, he's looking at them suspending. I see. Why not buy more time? Is my point. If it's been 2 years, why not go another year? That's what I was trying to explain. Even though I'm very wordy in my explanations.
But here's the thing: if I were a judge in that situation, and you'd said that to me, I'd simply say, "Great idea. I'm entering a plea of not guilty. You go hire yourself a lawyer."
Yeah. That's my point. Why would you do that? That's why I asked you, Scott. Is this day one? What the fuck?
But he's not agreeing to that. He's asking a question.
He doesn't need to agree to that. He just said he needs time to hire himself a lawyer. I'd be like, fine. I'm entering a plea of not guilty. I'm setting in trial for a month from now, so you have plenty of time to find yourself a lawyer. Have a nice day.
Can I say at all that I need time to review the discovery? And
okay,
well, you can say you need time for anything if that's what you. That was my point. I was thinking it's been 2 years. If you
ask for time, you're waiving your right to speedy trial. They don't even. They've given them what they're looking for in that case. They're looking to kind of get you to waive this speedy trial bit. I'm sure they'll do something to try to get you to waive speedy trial, because here they are. They've waited for fucking almost 2 years on it. Okay, and that's a bit of a problem they need to kind of fix.
You might need to do a little check on whether the corpus delicti is still used in the courts in Georgia, in your area, because in certain states around America, it's been that principle's been dropped.
Really?
And it is.
Yeah.
Wow. it's dropped and not dropped, just like every other legal principle is. You know, it's both at the same time. Because the underlying point is not dropped, but the ceremonies are dropped. So that's how they get around that.
It's California, though. If you mention it, I think it's California, if I'm correct. But if you mention corpus delicti in California, they just say we don't use that.
It's been dropped.
Really?
Yeah, and that's true. Well, and the same thing with habeas corpus, right? Because the fundamental principle still exists. They just have a ceremony that they concocted around it, and then they got rid of the ceremony. So does that get rid of the underlying point or not? You know?
No.
Yeah, well, absolutely, yeah. I mean, the corpus delicti is basically bring the victim to the table, sort of thing, isn't it?
Yeah, you know, victimless crimes need to be identified as such, and if there's a victimless crime accused, you have to prove jurisdiction through another means, right?
Yeah.
But that still exists. We talk about it all the time. But if you say corpus delicti, they'll be like, "Well, that was a form that we made up a couple years back and then got rid of, so that doesn't apply anymore." Well, bullshit, because the underlying principle still exists.
Yeah, well, I know what you mean, but it's just that terminology. They may not use that terminology anymore, but yeah, you're right. The principle still exists, as it still does in this country. I mean, corpus delicti in this country still means the same thing. They just don't use that term. You know, if you turn around in the English courts and say, is there a corpus delicti element involved in this case? And they'll go, "What bloody hell are you talking about?" See, in this country, it's more to do with murder. It means show the body, prove somebody was murdered.
Prove the victim.
You know.
Yeah. Well, and again, the idea of malleum, that goes to malleum in se, and they'll say, well, you know, and they won't be so clear as to say malleum prohibitum. You know.
Well, that's what it is. It's a statutory code bullshit.
It's a malum prohibitum statutory. There are malum in se statutory reflections too, but in this case, it's a malum prohibitum. You're accused of disobedience, which again points straight at the fact that there should be evidence that you should have obeyed, and that's the burden of proof is applicability of the code or decree or whatever it be. Which is what they're trying to avoid talking about.
Yeah.
So they won't say this is a malum prohibitum, because then you'll say, well, okay, how does, malum prohibitum requires more than an injured party. It requires a duty, evidence of duties, and then evidence of disobedience and injury.
That's it. Well, that's the thing with it. It's a matter of it wouldn't be a crime if there wasn't a statute that existed as such. So if they're going to say the only reason you're being accused of a crime right now is because a statute says so, well then they have to therefore prove the statute applies to you. That's why it's important that you attack that.
There must be a check before there's a duty of allegiance or anything.
Yeah, that's why it's important that you ask that these laws apply to you. It's not the fact that you're saying, I can do as I please, and you can't prove that I've done something wrong, sort of thing. There isn't a statute against murder, but everybody still knows it's a crime. Why? Because everybody inherently knows that is a crime in and of itself. But speeding or not having a license isn't a crime in and of itself. It's simply a crime because somebody dictates it's a crime, in the sense of we invented it as a crime. It wasn't a crime before because it was something that people naturally would do as a harmful effect. It's only a crime because we say it is. Otherwise, if we never invented that statute, nobody would think twice about it. And that's the point, and that's the reason why you're challenging them having to prove that statute applies to you.
Yeah, like your sign there, Vin. You got a bird there. I'm sure he can fly pretty fast. What's the speed limit, right? I like that one.
Yeah. Anyway, lads, I've got to drop off. So thanks for the call tonight, and I'll good luck with it, Max. Let us know how you get on, and we'll try and help you through it. If you end up obviously going through another trial or another arrangement, we'll hopefully have a bit more time to help you through it.
It's in the chat there, Max.
Yeah.
See how you did. Yeah.
So, Max, are you a little bit? I mean, what did you gather out of tonight? Are you more aware, and how are you going to attack this thing tomorrow?
I'm not sure yet. I'm thinking I'm probably going to try to buy more time without getting another
How?
trial.
How do you want to do that? Because he's going to.
Well, just say that I'm not
best
able to plea because I haven't looked through the evidence in the discovery yet and figured out, you know, which way I
Max,
should
just
plea.
try and do the best you can, mate. Try and learn what you can from the scripts and what they're showing you here, and just give it your best shot, mate.
So they've given you discovery.
All right.
Yeah,
well, I've got to drop off. all
No,
right?
no, I just
Good
gave
night,
them the
Vin.
discovery
Hope you catch you
papers
soon.
on Friday.
Talk to you later, Vin.
You know, discoveries
Okay.
from them.
Bye, Vin.
Bye, Vin.
You're
Thank you very
defendant.
much. Good night.
Yeah, discoveries from them. You're the defendant. So
Yeah,
And you got discovery. That's interesting because here in Michigan and many states, they've done away with discovery in misdemeanor cases. So that's
Really?
did they give you something? And when did you get that?
Not yet.
see, that's a civil
on
criminal
Friday.
charge.
On Friday, I printed out the discovery and mailed it to the prosecutor. So
You wait. Discovery. You filed a discovery request motion.
yes.
Okay. They haven't given you discovery.
No, but they said they would whenever I got there. At least
Did you say you mailed it to the prosecutor? Is that what you said?
well, that's how the paperwork was set up. I changed it all now for what is it? Hand delivered instead of being mailed, but
Oh, they'll get it. They'll get it.
yeah, and I know I even put it.
They'll get it. They'll get it. They get it.
Yeah.
Yeah, no, I gave them 2
it doesn't
copies.
matter. Max, I'm telling you right now, literally, as you're walking up to the fucking gate, the judge will address all your motions, and before you even close the gate, he will say they were all denied. Now, identify yourself for the record, sir. What's your name?
He's such a brutal judge.
Dude, I'm not for this
Oh,
shit.
brutal. Okay, good. No, perfect. No, go.
It's the way it is. I've read all your motions. They're all denied. Now, how do you plead, sir?
Okay, well, I'm Maxwell Swanson, and I have an unsigned plea, and I need clarification to sign this.
Well, it's right here. The tickets are what they are. You're being charged with this, that, and the other thing, and you didn't show up before. And how do you plead? I mean, I don't want to. Are you want to sign your plea of guilty or not? I mean, I can't take an conditional. I can't take a plea with a condition on it, sir.
Well, do I have a right to be informed of cause and nature of these proceedings today?
Yes, absolutely, and it's been informed. I mean, the complaint, the ticket you have in front of you explains it all. What is it that you do not understand? Do you understand English, sir?
Back to the motion. Got to stuff the motion back in there. Keep that motion. Stuff that motion. Dismiss.
How do I stuff the motion back in there?
Just throw it back in his face. Keep. They didn't.
Well, they haven't seen it. They haven't seen it yet, Keith. But yes, it's a good.
That's the first thing you'll want to address.
Yes, and the jurisdiction. Start out with the question of what has a prosecution brought forth for evidence that this court jurisdiction.
Remember that according to their sacred writ, that motion is your defense. In a sense. That's all.
And if you do file the motion in the morning, I'm not sure how that works. I've never done that. But now, always remember this.
I've heard it done.
They're going to ask you, Max. The judge is going to pull this. Every fucking one has done this to me. Mr. Swanson, how do you please argue your motion? Or I'm calling it argue it.
The judge may want to jump ship, you know, and say, oh, hang on, we're going to have to come back. No one's prepared for this.
That's possible, but let's say he wants to put pressure on Max, and he says, okay, I've got your motion.
Yeah.
Argue your motion. All right. Have you read? Let me ask you this, Max. Have you read that motion, and do you understand it and what the arguments are in it?
Yes, I've read it, and I do believe I understand it.
So that's what you have to stick with.
So when a judge asks you this, I've had this happen to me every time. They will try to turn the table on you because always remember, you want them to make assertions. You want to ask them questions on their assertions. And they want to do the same thing. They want to turn the table around and make you make assertions.
And they wrote the book, and that paperwork is on their sacred writ and how they operate, and that's where it holds them against the wall.
Yeah. So your motion is you filed your motions. All your arguments are in those motions. You want to say point of clarification, Your Honor, or don't call him that. Judge, ma'am, sir. I call him
sir. I just call him sir. He calls me sir, I call him sir.
That's it.
Yeah.
Sir, I can explain anything that you have a question in my motion. It's all my arguments are in my motion, sir. They are presented in clear form right there. What is it that you need clarification upon, sir? That's how you gotta do that. They'll every fucking time say, okay, I read it. I read all your motions. I denied them, but you want to argue them? Argue your motion. Here you go. Have at it.
Okay, you denied him on what grounds?
You told him it was in the code.
Yeah, and they'll say, literally, Keith, I've had them say, I don't need to even give you a reason. I can just say, I have this in transcript. I can say that I've read your motion and denied it. I don't have to explain anything to you.
Oh, so what kind of trial are we at then?
So that's where you bring your motion back up and say, well, since you've denied my motion, what is it that you did not understand in my motion? These arguments, Max, our goal here, my goal is a little bit different than most, all right? My goal is to take up as much time every fucking time they get me in that court as I can. I'll come back 52 times if you let me. I'm not kidding you, dude.
We want to limit damage.
Yeah.
So, when they deny your motions and all this stuff, and you say, okay, before we move ahead, can you show, sir, on the record that the prosecution has jurisdiction over me today? Can you show that on the record as it stands right now? That's another good one.
Sir, I've explained it to you. I have it right here. I'm waiving this ticket right here. I don't quite understand what it is that you don't understand. They'll make jokes, and the people in the background will laugh, and the prosecution will laugh. You'll feel like a total fucking dick.
That's like
they'll almost accuse you of being retarded. What is it? Do you understand the English language?
Okay, so as I understand it, sir, that for every accusation there must be facts and evidence to prove the accusation. Does the prosecution have evidence or facts today to show that the Constitution of Canada and the acts apply to me or anyone else in this courtroom here today?
Sir, I'm not here to argue constitutional. If you really want to argue the Constitution, you're going to need to take this to trial, sir. So, does Friday sound good for you?
Objection. That's not the question. Objection. That's not the question.
That's good that he's laughing.
Yes.
Yeah.
He's getting it, though. He's going to hear it all.
But he's not you, so he's not going to try to be there as long as possible. He wants to be there as short as possible.
That's right. That's called damage control.
No, it is. No,
you don't want to be in dishonor. You don't want to be in their courts at all. I try to stay out entirely.
Yeah, you want to be out in the pot. You want to be out being productive and enjoying life. You don't want to be in there.
I agree to an extent.
However, if he's looking to really get the experience,
right,
it's a good chance.
Yeah. Exactly. Yeah. You're in there for the education.
How do you think? Yes. How do you think I can be such a dick judge? Oh,
I've seen so many.
It seems to come natural to you.
Because he fucking stays in there all day. Yeah.
I've been there, and I've dragged this shit out. I've had cases that I'll fucking...
You're hilarious.
Yet one of his buddies had like 37 arraignments. A guy, just a couple guys just here recently, like you, Max, brand newbies, got arraignment number 2. I'm not saying that's good. It means kind of they failed. But they didn't fail and have a trial scheduled. Oh, no. They had arraignment scheduled. So
that means they got more time. And even to get another month will certainly help.
You don't want to...
I mean, it'll be the night and day. And if it's on Friday,
if I just had 4
it still
days,
gives them a week.
All this stuff, I could get it down.
You don't want to be an entertainment puppet where it's like, hey, man, this fucking guy recused me. And fuck, you got to go in. You know, when they're playing golf together, the judges, they go, you got to go in. We'll arraign him again, man. You're going to bust your gut. You got to see this cat. His name's Max. He fucking shit. Fuck.
Yeah, but if you get arrested for contempt, you're going to be taking 3 steps backwards instead of any forward.
You all get careful. You go in. We all get paid. It's okay. We just go through the puppy mill. You know, it's cookie cutter system. Yeah, this Max guy, man, he'll entertain you all fucking day. Yeah, no, guy Tom. That's his name, Tom. Yeah. He'll entertain all day. No.
But the funny thing is, hey, after I am, Max, just so you know, okay, I am 3 for 4 using the Marcratic method. And the one that I lost, I literally had a judge say, I heard you say you wanted to plead guilty. at the beginning of this, after arguing with her for 15 minutes, after 5 or 6 visits, and she said, I'll take that. And I let her get away with it. And I'm not done yet. So I'm 3 for 4. I've lost 1.
Oh, man.
Well, I'm 1 for 1, and I think the last time in October is the longest I spent in a courthouse, because I guess maybe it's alphabetical because of my last name, the O. So.
Well, I try to come back as many times as I can. It's experience.
I want the fuck
dude, I'm serious. Listen to me. One day, these cocksuckers are going to steal all the money out of your bank accounts, or who knows what, or claim you owe more money. Or hey,
those people.
I just want to be ready. I am so unafraid when I walk in right now. I've been threatened with contempt so many times that, granted, they could haul me away. And I'm not making light of it because they did it to Terry. There's a gentleman that lives north of me here.
Yeah, Terry.
And the rural areas here in this country, that's getting scary, dude. These judges are becoming absolute evil.
Well, they're throwing their egos around. It's all about their ego. I mean, this guy's not complying. I'm going to show him. You wait. I'll show him. I'll put him in a cage. And that's all. It's ego and superpowerness bullshit. These cross-dressing faggots. You know.
Yeah, well, did you hear what I said? In the rural areas, in the country where people
to do with drink, smoke, and have sex.
Yeah, they used to feel safe there, and now the judges are becoming so fucking tyrannical. It's worse than in the big cities. Terry and his son are going through.
Headshot.
It's fucked up.
Headshot.
Max, what is in your motion to dismiss? Are you able to understand what's in there, or is it something you got from somewhere and you don't really follow what it is?
Oh, it's
do you really have any faith in that?
It's Mark's motion to dismiss. It sounds good. It's about the elements of the crime, right? And
well, it's not about how it sounds. It's about how you perceive it and how you see it. I mean,
if I was the judge, I would.
I would try to stand on that if it were me. And anything that they get off of that, you would just act confused and I'm confused. I don't understand why you couldn't accept this this motion to dismiss. If you're not going to dismiss it, then you can go with your plan B. Like you're so upset that they didn't dismiss it, that it's my belief that I'm going to have some time to, somehow, whatever you see. If you're going to go in with that motion, if they blow it off, try to enforce that a little. Like how can like you're shocked? It's against your belief. You don't accept this. You're being in dishonor, not accepting this. I spent a lot of time on this. This is what I believe in. How can you not? That, and just stay there because you're a novice, and then you can play it.
But according to their sacred writ, the motion is all he has. It's like being naked in the Arctic, man, and you have a loincloth.
So he could act, and how he's so upset that they didn't take this loincloth and take it seriously.
No, that's nothing to do with acting. Fuck.
Yes, absolutely. It's all acting. They're acting and we're acting.
Oh, well, no, you're in their theater. They made you part of their reality.
And it's going to help him because he still has a sense of humor. He's not scared of them. He's acting. It's all acting. And he's acting. If you can actually maintain that sense of humor in the morning, man, it's going to be amazing, okay?
Yeah.
And
if you go in there acting, they're going to nail you on something.
Yeah.
Yeah, but when you have a sense of humor, it throws them off their game.
Yeah,
most people are scared, shaking in their boots.
Dry.
Yeah, no. I might be scared shaking in my boots, but I will still have a smile on my face. That's for sure.
Well, that's rare. They're not used to that.
Yeah.
Cut and dry.
I'm telling you, they're not used to that.
Threat, though. I mean, don't lose awareness of the threat and act like you're not under threat. You're under threat, and don't lose sight of that.
And always remember, every time I've ever been to court, I've mentioned this I don't know how many times on here, every single time, I've got my keys with somebody. My house is, everything's prepared that I may go to jail or don't, be careful, brother.
You might not come back, but that's a worst case scenario.
Yeah, luckily I live 2 blocks away from the courthouse, so I'm just walking over.
Quite regularly.
Okay.
Yeah, I agree. Yeah, I agree. But it's like
that makes it easier.
Because once a judge reads that motion, it's going to change everything.
Yep, and the pressure's going to come down on you hard. because they want, especially if they were dumb enough. Listen, if they are dumb enough to schedule you early in the day and there's a fucking whole boatload of people behind you, they've done that. Right? I've been through all of them. I've been through them where they waited to have me by myself with fucking 4 cops armed all by myself as a school. And I've been in where, oops, we didn't realize this guy was going to do this. Okay.
It's intimidation.
So be ready.
Well, don't make a mistake that I made. I brought so many papers with me that when it was time to find my questions, I couldn't find them. Just bring exactly what you need and that you're going to stand on.
Keep it simple, yeah.
It hurt me. And you can even hear in the recording, I was like going crazy looking through my papers and you couldn't hear what they were saying.
13
So just
pieces,
bring just the simplicity that you want to stand on. And don't. I had like this because I was prepared for a lot of things, but in the meantime, when I needed my questions, I couldn't find them.
Yeah.
Hey, that's why you have to walk in this knowing it's not about fucking looking at a script.
Well, that was when I was a beginner. Now
I know that, but I'm telling you, and I sucked at it too at the beginning, and I'm so envious.
And I was scared
like
too.
Paul.
I was scared too. I wasn't laughing.
There's been a couple of guys on here in the last fucking this month that have just fucking jammed. I mean, right off the bat. It's about understanding these questions. How do your rules apply to me and why?
Yeah, that's why if you have just a couple of little things in your hand, you don't have all the stuff. Because I remember I actually had a problem because I brought too much stuff. That I keep kicking myself in the ass. It would have gone a lot differently if I didn't bring so much stuff. But that's how I am. I'm very meticulous.
Want to try it again, Max, a little bit?
You know, I do. I'm just wondering where to even start. You know, because is this one day that I've been getting all this information, so it's hard to like.
It doesn't matter. We're gonna hammer it. You walk in tomorrow morning, you're facing the same thing. This is what's gonna happen. Always guaranteed. Judge is gonna say, "Sir, this is what you're charged with. How do you plead?"
Well, I don't have a wait. I don't know.
Remember the concept. Remember that you're walking in and you just want to have this group of people that are saying that their rules, some mysterious way, and their fines apply to you. And all you want to do is ask them how this can be.
Did you not get the paperwork that I filed before the court?
I got your paperwork, sir. I've read your motions, and I deny them.
On what grounds do you deny my motions?
I don't need to give you grounds, sir. I've read them, and I'm telling you I'm denying them. We have jurisdiction. Please move ahead. And how do you plead?
Objection. You're ruling arbitrarily now. What are the facts you rely on to overcome the motion?
I don't need to give you facts, sir. I just told you. I don't even need to give you any reason. I've read your motions. I've denied them. And how do you plead?
Okay, well, I'm writing down now that it's unsafe to ask why my motions have been denied.
Well, no. Now you want to actually ask something. You want to ask some of the points in your motion. You have those motions. That's what I would use as my script. Okay. The fact that you want to plead, say, sir, because he's going to constantly ask you to plead. You said this is an arraignment that you're confident of. Yeah. So they're going to ask.
And we need to turn off the assertion. You got to really watch assertion. So you just came out of left field with that. I'm not safe. You came up with that. Me reading the transcript, I'm going to look at you and say you're an idiot. You thought it was unsafe just because he said, "Hang on."
You got to make the judges say it, yeah.
Yeah, because again, when I used that earlier, it was because he said, "I will hold you in contempt if you ask about that thing." I waited till the threat was actually verbalized rather than just hinted at or thinly veiled or whatever.
Yeah. So does that mean that Does that mean that I can ask him, "Am I safe?" to continue asking this question?
No. You have to be somewhat assertive. Wrong word, but you have to be somewhat assertive and your best word. I don't care how many fucking times you use it. Get used to using the word objection.
Mm-hmm.
Objection.
And there's only one objection that's relevant here. The only objection really I'd say that relates to an arraignment is point of clarification. Objection, point of clarification. what do you mean by blah, blah, blah? Or how is this true in light of that? Or, whatever it
No,
be.
that's perfect.
The
No, Gary, don't glance over that. Literally, he's on a crash course, and this
always
is
says every word out of a bureaucrat's mouth is a lie.
Yeah, this is really important. Gary's statement was very important. Objection, I'm trying to understand what it is that you're explaining to me.
Well, and again, you rephrased it. The objection, for the formal objection is literally called objection point of clarification. It's not that I'm making a sentence up. It is an objection type. It is I object to that statement because it is unclear on a point, and this point of clarification is necessary. And that is ultimately everything we're doing is one big clarification anyways. We're just getting more and more resolved about.
That explains why I've never been shot down. Is that literally an objection?
Yes.
Well, Jesus. Every time I've asked questions, I got shot in the ass. So I started using objection point of clarification, and I never got shot down. And I was always wondering why.
Yes. Yes, you are literally making a point that you are objecting to the lack of clarity in what was just said, and you seek to make it clear as to two different possibilities of what it could be meaning.
Well,
or more.
I look.
Yeah, you luck into some questions once in a while, right?
Every squirrel gets lucky.
Okay. Yeah, where the hell were we now, right? That's the process, isn't it? It's a lot to process. So
it's a lot to learn.
So again, so you recall the basics is that the judge is trying to keep you from asking these embarrassing questions. He doesn't like them. They hold up his job. They hold up the prosecution of you. They hold up profits. They have no good outcome, right?
And they're trying to get you to make statements. They're trying to make you make statements.
Yes. Because once you've made an assertion, that indicates that you're done needing information. Once you switch from gathering information and making an assertion, that means you've been informed enough to take a position. Now you've taken a position. Now it's time for trial.
And it's hard to put things in question form instead of a statement unless you have it in your hand that you're looking at, that you know. It's easy to slip up and you're actually making a statement rather than a lot of the ideas during this call could be question form instead of statement form, which they are on the call. Yes. And that's why you got to see it in your, look at it. This way, you stick to the thing and you keep repeating it's in threes. So
when you
did you not receive my answer to this court? And you say it again and they say this and you say, I answered this court. Did you not get my letter? Would you like a copy? I have a copy. And it's the same thing. Oh, go have a seat over there. Did you not answer this court? I believe I answered this court. Did you not get? And you just again and again, you're going back to the same thing because you got it in your hand. This way you don't get distracted because that's the massive distraction.
Earlier, Max.
Are you referring to the motions, Scott?
What?
Scott, are you referring to the motions?
No, I'm referring to when he's standing there, and in the essence, he's standing there so they can simply get a not guilty or a guilty plea. And that's something that takes a millisecond. So we're doing all this rehearsal, basically.
Now, hold on. You're missing the point here. We never want to get past that, Scott. That's the point. We never want to get past arraignment. Do you understand that?
Yeah, but they're just going to enter a plea for you, no?
No. Okay, here's. Let me explain what entering a plea for. Something. Yes, let me explain what entering a plea for somebody means. Okay, if I put a roof on your house for you, have I done you a favor?
Yeah. If I need a roof, yeah.
I've done you a favor. It was for you. Now, in the alternative, if I take your mailbox off your house and put it on mine for you, did I do you a favor? Was it really for, or is that a lie?
Well, that wouldn't be a favor, though the joke answer would be yeah. But
well, okay, yeah, I know. Okay, so to do something for somebody, to do something for somebody is literally the opposite of something that's to their detriment, right?
Mm-hmm.
Okay, if I do something that is to your detriment, and you turn around and fuck up and instantly say I did it for you, to a judge, to a logic professor, to an English professor, they're going to think you're an idiot because you just said that I helped you out. Why would you say he entered a plea of not guilty for me when it's for the prosecutor? The prosecutor's the only one smiling.
That's a big.
And this is literally true. I'm not making a joke. I mean, this
I
is
still didn't
literally
follow it. I'm
true.
sorry. I still
Okay.
lost it. Yeah.
When they enter a plea of not guilty, it's not for your benefit. It's for the prosecutor's benefit. He's the one that's smiling.
Yeah, that's what the whole arraignment is about. They're trying to get, it does the same thing, guilty or not guilty. To them, it's the same thing.
Yeah, but it's quick, one slow. But you're skipping over the main point.
Yeah, I always miss the main point. Yeah.
Yeah. You have your next assertion. You got to watch it. The main point that I had was they don't really care. The prosecutor benefits from any one of the following: a guilty plea, a not guilty plea, you standing mute, you taking any assertions whatsoever and arguing about,
Boy, you got that right. Boy, that's really makes it clear.
He benefits from any of those. What you benefit from is clarifying fine point details about his accusation. That's where you benefit.
That's where the Mark Stevens comes in. Yeah. Okay.
All
right.
So you benefit from point of clarification until they lose their temper and say, fuck you, we're not even going to pretend to inform you anymore. We're just going to steamroll. And then we're going to threaten your safety for objecting to it and yada, yada, yada. And then you've made him look so much like a sham, he's going to look back at that and go, oh, fuck, look at how this reads. This reads like shit. We need to just go ahead and end this. That's the hopes.
And that's the hope. That's the hope when they go out and talk to the prosecutor.
That's exactly. They think back on how it's been looking, and they're like, "Oh fuck, we didn't even make it look like an arraignment. This just looks like us telling him he has the right to be informed, and then bitching about him asking questions."
That's pretty interesting. I never looked at it that way. I got to think about that a bit. But yeah, that opens up a couple of doors.
This is your first time really kind of dealing with us on the role play here, I think.
Yes, absolutely, yeah. After all these years, I didn't do Skype back when I used to listen to Mark. Yeah.
Yeah, we've been hashing through a lot of these finer points and brainstorming a lot of this for a while now. And I've been trying to whittle it down to a couple days, and here we are trying to whittle it down to a couple hours. But
it doesn't take that long, Gary. It's a concept. And I'm starting to see Mark's shows getting more and more to the point of getting this concept whittled down in words. One of those like that Fabrice's show. Fabrice's show was fucking awesome.
Understanding chess only takes you about 15 minutes, but understanding all the fucked up moves they can point at you, and would it really have to make you think about, okay, what kind of situation does this get?
Agreed, but in a crash course, when he has a court date tomorrow morning, the ideology of what's happening here right now will get him to where he needs to be.
Okay.
He's handling it very well.
Yes. Here's the other part. Sometimes they'll answer your question and get you to fuck up and think they didn't, so that you'll argue about it.
Of course.
There's two. This one first. So let's say I ask you, you ask me, do you have a dog? And I say, I have a German retriever. Or German shit, what am I looking for here?
German Shepherd. Retriever is even better.
Don't
get that. Hurry up, come on.
You say, I have a German Shepherd. Now, I couldn't say, hey, it was yes or no fucking question. Tell me if you have a dog or not, because I answered you more specifically than yes. Now, you could say, do you mean the German Retriever dog, or do you mean a German guy who gets you stuff? Or not German Retriever dog, a German Shepherd, a German guy who herds sheep, But that would be a little absurd. But you see, I gave you more than a yes answer.
Okay.
Right. Yeah. It's all wordsmithing. In court, it's all wordsmithing.
You gotta pay attention Because if you start bitching about the fact that he didn't answer your question, he's going to hold you in contempt, and he's going to look right on it. He's going to throw you in jail and have a reason because you were arguing about not getting an answer when he gave you an answer.
Yeah,
right?
sometimes you can. The one I found quite useful with that, Gary, is just to be sure. So do you have a dog? Yes, I have I have a German Shepherd. So it's that yes, you have a dog. Just so I'm sure.
Exactly. And if you were hurt, if you were on earlier, I don't know, when I was doing a little bit of role play, I did just that, where it's like, okay, I didn't hear the yes in that. Was it a yes? Or if he gives you a speech, you can sometimes come back and say, was that a yes answer to my question? Like, if you asked, is there evidence of jurisdiction, and he tells you about duly formed courts and whatever the hell history and blah 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 and elections, you say, it's like, I'm sorry, there was a lot there we can address later. Was that a yes?
So I think I got where you're coming from. What you're saying is everything is a point of clarification, and it's never clarified.
Yes, they don't want to clarify.
That's what you just explained, correct?
Yes.
All right, I like that. I never looked at it that way. Yeah, that's good.
Yes, that is very much what's going on. And that's why I started with the question, do I have the right to be informed of the cause and nature of these proceedings? Because they'll say you have the right to, but they kind of mean just the Cliff Notes version. They don't mean to the particular level. That's like saying, okay, do I have the right to be informed of the, you go to a class about a book, right? War and Peace. And you say, do I have the right to be informed about War and Peace? And they said, yes. And then they give you the Cliff Notes and say, all right, class is over, you're done. And it's like, wait a minute, I paid for this class. And they say, well, you've been informed of War and Peace. There's the Cliff Notes. And it's like, well, there's details that I need clarified. And they say, well, and they say, do I have the right to Well, and you see the difference between being informed in the vague sense and being informed in a particular sense. And you can't say I've not been informed because they gave you the Cliff Notes. You can't say I've not been informed of what I'm charged with because they read you the vague summary of the charges. So it's wrong for you to say I've not been informed. That's a lie. He can hold you in contempt for that in theory.
And it's a statement also.
And well, yeah, it's assertions. I mean, there are some assertions that are okay. I'd say the ones that are okay is when they.
Oh, the call just dropped. Oh no, I thought we lost the call.
I think. Well, Gary, we lost Gary.
Well, you're still there. Well, last time everybody dropped. Anyway,
Gary tends to pop in and out. He's always mobile. He's crazy. He's one dedicated dude, man. That fucking guy puts in more time with this than anybody I've seen yet. That is one fucking dedicated man, and one smart motherfucker too.
Yeah, it's getting dark here. I didn't go do my water pump. I'm on the phone with you guys. I've been putting that off.
He'll pop back in. I don't see him. He faded out. Oh, I see Stahl. Stahl, you out there? Oh, there's Gary.
Sorry about that. Every time I get in a rant, I hit a dead spot or someone tries to call me. Sorry.
Well, so
there was one more thing that they can nail you on if you ask a question. If they ask you a counter question to clarify your question, you don't answer it, if you don't answer that clarification, you've abandoned your question. It's a back and forth like that. So they made an assertion. You've asked a question to clarify it. They ask you, what do you mean by blah, blah, blah? If you say, fuck you, answer my question, you can be held in that's a contemptible thing. That's a lack of decorum. You're wrong, basically, for doing that. You need to clarify your question. Now, it can be as simple as saying, oh, sorry.
Oh, I was just saying, is it possible that they can get me like cornered into making a statement at that point, where they can just say, well, that statement doesn't matter, so the question doesn't matter? Like,
well, they'll try to say the question is relevant. Yeah, they do that all the time. Very common. They'll say that that's an example.
Gary, easy.
Okay.
Facts. Mr. Swanson, you keep asking about jurisdiction. We've told you we have jurisdiction. What do you mean by jurisdiction?
I don't know.
He stumped you, didn't he? He stumped you. Yeah, it's a good one. And a lot of questions you
By
ask, you'll be stumped
jurisdiction,
if
I
you're
mean
what the hell you mean.
the burden
I
of
mean, a lot of
proof for the
questions you'll ask.
prosecutor.
No, that's not what's jurisdiction.
Well, there's where you could have gone to the Mark Stevens thing. What evidence of jurisdiction?
No. He asked you. He said.
The
judge just said, "Sir, I've heard your objections, and I've told you we have jurisdiction, and you don't seem to understand. So, what is it that you mean by jurisdiction? What do we need to prove to you to have jurisdiction, sir?"
He's asking you about to clarify your own question.
Okay,
no, you're not answering his question.
I know. If you ask me, I'd go back to the simple thing. Well, in this instance, you know, your authority to bring me in here when the prosecutor hasn't provided, you know, me with any evidence of the applicability of the law, any evidence of a complaining party here. And
that's very fair. Yes.
You know, in terms of jurisdiction, I want to see, you know, the nuts and bolts, the facts and the evidence, so that we can move forward with this. Or
yeah. Now you're being very clear and specific, and you're educated about what jurisdiction actually means. There are other questions where they might ask him, and he might not know what the answer really is. He might not know what he really asked about. Right. In those instances, here's an approach that I found to be to have good potential. Let's put it that way. If you're not making anything, the only thing you're doing is clarifying the prosecution's assertion. Right. He has basically asserted by dragging in a bunch of things that he has jurisdiction. Now, you're not introducing any new topics at all. Keep in mind that we're not introducing any new topics yet. We are investigating the topic of his assertion. So if he asks you, what do you mean by jurisdiction? It's simple. I only mean by jurisdiction whatever the prosecutor asserts that this court has as jurisdiction. That's it. I don't mean anything. I'm not introducing my own definitions at all of anything. Of constitutions, of statutes, of rights. I'm not introducing any definitions yet, because to do so would be to put words into the prosecutor's mouth, and I don't want to do that. I'm asking what the fuck he's saying.
And where is the evidence? It gets back to that. Does he have any more than zero evidence?
And evidence of yes. And any evidence that it's true of what he's saying. So that's what we're clarifying. We're clarifying his accusation, and we're clarifying if he has any evidence of its truth.
I've had that thrown at me. What do you mean by jurisdiction? I mean, dude, the more court cases that I hear, not only my own, but others, it's like they operate on a fucking script or something.
Right.
They must
do
pass
the same thing over and over.
Yep.
Yeah.
Well, you guys have been so helpful. I can't believe how overwhelming the support is here.
Yeah. Well, I mean, there's a lot more details because we always come across it. People come back the next day and it's like, here's what happened. And it's like, oh, we meant to cover that and we didn't, you know.
Yeah.
One step at a time, Max. One step at a time.
Yeah.
Yeah.
So,
hey, listen, go back to listening to, have you seen it? Paul just posted today, I believe. Paul, what's his last name? Starts with an M. Anyway. Yeah. Yep. If you go back and listen to his recording, and when you get into the pressure zone, of course, everything you've rehearsed, and he was one of the best I've seen here yet, he kind of fell apart a little bit because guess what? It's moving on to a trial. So Paul did not have a second arraignment, did he? I can't remember.
I haven't heard it.
No, I think it's actually moving into a trial, but it's really never a trial until you let it be. It's always an arraignment because they still have never.
Because if you have, it is not past arraignment until you no longer have the right to plead guilty.
Right. Okay. Yeah, that's really important.
That is the key difference. If you no longer have the right to plead guilty right then and there, and you no longer have the right to be informed of the cause of nature in order to make an informed plea of guilty, then you still have an opportunity to be arraigned. To be informed, I should say, to ask these questions and to make these points and to show that they shouldn't proceed at all. They should just let you go home, and simple as that, you know.
And it sounds to me like you got stuck on a few questions that you didn't dig, because he's got some good questions. He's a great judge. That's the same kind of thing a judge would do at you. So if you find yourself in that thing, just ignore what he said and repeat yourself and do it again, because that's what they do to us.
Well, and again, you can also say, "I'm sorry,
they ignore it and slap this on you." So you can do the same thing back to them. If you do get lost and you're trying to think, instead of opening your mouth and saying something wrong, just go back to what you already said. You can't get hurt from saying the same thing again, and stick with those rules of threes like I was doing. That would have been how I would have dealt with one of the traps that he set, and he got you. Even though he's saying that if you don't answer the judge's question, blah, blah, blah. So what? You're still staying on your original question. You didn't hear his second question because you didn't get the answer to the first question. Anyway, that's just something I can point out that I see. If you're stuck, better to not open your mouth and get in trouble. Better to open your mouth and say something you already said. You know?
That's a good one, because
like a record skipping. You know?
One of the things that we tend to do is go too fast.
Yeah, well, that's what they use against us.
Hold on. Get an answer. Somebody's buzzing. What's gone out?
It's just you. Everyone else sounds good.
No, it wasn't me. I guarantee it wasn't me. Always, like, you're going to be under so much pressure, and all these things are going to come to your mind, and you're going to want to fire these questions out there. You have to control the speed of the fight. And if you walk in and start firing questions, they're going to expect you to also come back the same way of firing questions. They're going to fire questions at you. You want to control this fight and fire questions slowly and deliberately, and not get too fast. Start out slow. Like Mark always says, "Hey, I'm not a lawyer. I just don't understand, and I've got some points of clarification."
Yeah, you are an idiot. There's no problem saying you're an idiot and you don't understand. Say that a lot. That's great. And that can buy time because they try to steamroll you. And then that's not one guy trying to steamroll. It's three freaking steamrollers coming from three different directions.
Yeah, and like I said, that inner Forrest Gump, it's the same thing. It's just talk to yourself while you're writing a note to yourself so that you get that. And then you can start on with the next question. And when you take things slow and steady, it makes it much harder for them to try and take that initiative away from you. And you actually find that after a little while they stop trying. So, that's always worth thinking.
Yeah,
and you seem like you got the smile thing sorted out as well. So,
They go for the low fruit. They don't want the tough, the stick of bushes with bees.
Well, yeah, that's why I'm so surprised I even got this letter in the first place. I thought I scared him off in the first time, but
Well, no, they're going to test you. It doesn't work that way. They're going to keep testing you. That's why I've been so busy since July. They started testing me in July. It's almost July again.
Yeah, and as I think I heard earlier, as Gary mentioned, I think about the fact that actually it has been a long time since the offence itself, and to deal with this matter as well. Again, if you, if you keep that slow and simple approach, and I mean I don't know how long you've been asking the prosecution for the disclosure of that information, but if you can ever pin down the prosecution to a time when they have to give you, their evidence of jurisdiction, that can be a good way to get it to time out. But again, I'm not. I don't know too much about the courts in America, but I know they do try and push it forward. So, but yeah, like I say, you keep your own pace. Gives you every chance of them not being able to steamroll you so much.
Yeah.
And you know, if you're going in, I think Vin gave you some bits in one of the files that he popped up for you.
Yeah.
Okay, some of those are really, really great. They are the kind of things. I mean, it'd be great to get Gary to give them a look over at some point, but they're pretty well honed. And some of those are the things that you kind of that you want to say that aren't always easy to find. I think there's one called plea hearing opening address.
Yeah, there is.
And you know,
number 2.
yeah. Well, it's the evolved version, I think. So you can see there. So they're often quite good if you want to, you know, go through and change a couple of words so that they fit into your language, because those can be quite interesting little bits to have. You know,
write it with your own writing, what you like.
Yeah, so you know, we have a little bit here. If the bench freaks on you, okay.
Whatever reflects
now that's
in you
if you're going slow and steady, and they're getting really angry with you, you know, like Tom was a little earlier, when he was playing the you know, the grinding judge, who just wants to grind you down and to do that. Yeah, you know, you can just say, you know, I'm just here so that I can understand the cause and nature of the charges of this hearing against me. I want to enter a plea, but you're scaring, you're intimidating and threatening me, right? And I don't really wish to take any part in these proceedings today, you know. And you can do that if they are, you know, threatening you, if they are, you know, doing some of those things. You can find out where your level is. To you know, for the way in which you'd like to respond to that, so that if they say, you know, Mr. Swanson, I'd strongly suggest you take legal advice. You know, you're not helping yourself, and this could end up costing you hundreds or maybe even thousands more dollars than it would be if you got some proper advice here and now. I can arrange an attorney to speak with you here. Yeah. It's good if you can say, right, actually, I'm not asking for legal advice. I just want to understand the cause and nature of these proceedings. I just want to see the evidence that the prosecution has put out, so that I can make a knowing plea. We can find a resolution to this matter one way or the other. And then repeat your last question. Yeah. And if you have whatever it is that you'd like to say, those can be quite handy to have there. So yeah, that might be useful just to print out and have a little look at.
Yeah, thank you very much. Well, this is a cool little community that y'all have, huh?
Oh yeah.
Yeah, there's lots.
It's the hey, listen, Max. Listen, a lot of guys come here and they get through their shit and they leave and they never come back. Try not to do that.
Not just here, all of the communities the same way everywhere. Doesn't that suck?
Yeah, well,
yeah. I mean, we have quite a few come and then they go and they come back every now and then, which is good. But actually, once people really get it and they see that actually you can have an impact, you can make a difference, not just in individuals' lives, but in communities' lives, in the way in some communities that people in authority will behave with you. You can move that conversation forward. It's a very strong and powerful way to do that. And so the people who are here, who you know, who are really superheroes, they share their knowledge. You know, if I'm not sure about something, I'll go find Keith, I'll go find Gary, and bounce it with them. You know, and it's great. I mean, I have a little list, you know, as and when I catch up with people who I can pick on to, you know, to help me understand a little more. Because when people come and find me, then, you know, for me it's just showing people options. They have options of asking questions and empowering themselves, And if you can show that that option is quite successful, it works in lots of occasions, and people learn a lot from it that they can take forward in other places in their life, then usually that's an option that I'll thank you for, even if they just want to go and hire a solicitor and get it, you know, sorted for however much they get stung for. You know, eventually...
A solicitor. A lawyer.
a liar, yeah. Solicitor, what do you call it? Attorney. Yeah.
That's why I was asking you if you were here to learn, you're using this case to learn, or you just wanted to get, because there's two kinds of people here. There's the people here that have a problem and they just want to fix it and move on. And then there's the people here that are here to learn and to participate and help others learn, and they're here to learn in a nutshell. And with a problem, they're not here to learn. They're just here to fix their problem. It's totally different than trying to learn it.
And then there's the third option. There's the third kind of person like me, the judge, who just loves fucking going to court. And if I can drag a court case out 52 dates, I will. Because that keeps the cop off the street, it keeps the lawyer busy, it keeps the fucking judge busy from raping the next guy.
Yeah, well, that's how the lawyers are. They want to drag it out. They want the controversy.
Yeah, it's bad for their kind of business as well, because in the end they don't actually get to, you know, to fleece anybody, and sometimes it makes their head think in ways that they don't usually expect. So it's and you know, the bottom line is, you know, Tom, if they weren't there interfering in your life, my life, or everybody else's life, you know, they wouldn't be doing it to themselves, and sometimes they don't like it when, you know, a few questions makes them feel bad.
So which one are you, Max? Are you here to learn, or you just have a problem?
I might be the fourth one. Y'all are... This is all based in defense, right? This is all from being...
So you can have your own show then next month.
Well, have any of y'all tried suing these people yet?
Tried what?
Suing them? For instance, like for kidnapping and holding for ransom?
Nah, I don't think you're going to get far with that. If there's any suing to be done, it's like my last case was dropped after 5 visits and almost a year. You might want to try to sue their bonding agency, but again, I haven't done it because I work full time to actually go ahead and do all this shit. Jesus, you know, how much time do you want to put into this? You know, and when you do sue someone, now you're making assertions, and you have to prove them.
Yeah.
Well, they have to prove theirs also. That's why I was saying it's so old. How are they going to prove this? How did that officer probably don't even remember you?
Yeah, I mean, here in England it's a little bit different, but yeah, I mean, there's a certain amount that you can do here. And actually, he says you're about to shamelessly plug his radio show on Wednesday. I got a guy who launched the first private prosecution against the Metropolitan Police or any police force here for over 130 years coming on my radio show on Wednesday. A guy called Michael Doherty. Nice. And that, you know, he'll show you. I mean, they picked him up, they arrested him out of his house, they tried fitting him up a couple of times. And he's just an aircraft engineer who reported that there weren't some not good people harassing his 14-year-old daughter on her computer. But yeah, he's one hell of a guy. And the way it seems here is that if you do a really robust job, a really efficient job of getting disclosure from the other side, as well as not taking a position, that actually you can get enough to, if they're not going to incriminate themselves, and they always have liability to get out of it, that actually you can get some blood out of that particular state stone, which again doesn't help the good for business equation.
Well, yeah,
but the problem is that in this country, as soon as you do that, you've got to make sure you have the necessary stuff around you. I mean, cameras to record when they come and harass you, people who you can get to come and witness stuff, because, you know, they're the biggest, baddest, best armed gang on the streets. They got a monopoly of violence, and they can fit you up. So actually, you know, trying to take a piece out of them is something you really got to think about carefully.
What I want to prove basically is just that they're private contractors, and that all security should be privately contracted.
There's no such thing. What's the difference between public and private to you? What is the factual difference between public and private? As in, I could ask a physicist now to tell me the difference between them.
Anybody can use something public and
without using abstractions that have no physical thing. What is the difference between public and private? They color different, mass is different. What?
I don't know. What's different?
There is no physical difference. That's my point. It is purely arbitrary difference. It is a difference that is dictated by somebody who just chose to call it a difference.
And your point?
And your point is that he's hinging his difference on public versus private, and that there is no such thing. You can't prove a difference between public and private because it's an arbitrary difference.
Okay, well then how do I make like my own police force or my own social security, something like an alternative to social security that people could use for jobs or
you're welcome to do so. You're welcome to do so. The difference is you're not welcome to opt out without punishment.
To opt out?
Opt out of theirs without. I mean, they'll punish you for trying to defy.
Well, I know that's where this whole disconnect thing is going now.
Okay, so that aside, just a warning about that whole suing the government people.
Oh, I'm waiting until I got a lot of money.
There's someone who used to be part of the group, who is now in federal hardcore prison and will be for a very long time. The week that he filed lawsuits against some high-level politicians and judges, that very week they stormed into his house and discovered an external hard drive full of kiddie porn.
Oh, I'm sure that it's probably theirs, huh?
I don't know. I sincerely don't know, because there's so much weirdness about it that there's no way to tell whether or not. I mean, he might have been a kiddie porn collector. I don't know, but the fact is, he was prosecuted and jailed for it immediately after filing his suits.
Yeah.
So that's all I've got to look at.
You know, I know plan on starting locally.
His arraignment. They had him in a different room with a microphone with a switch on it. They turned it on when they wanted
it. Oh my God!
Yes, and it's in the record as such.
Well, exactly. Yeah, I want to be able to build a multimedia organization before I do something like this. So I got people that can video, write newspaper.
Well, and they knew exactly what accusation. If they set him up with the very accusation that causes everybody else to stand away from him. You know what I mean?
Yeah.
So again, I don't know if he's quote unquote guilty or innocent or whatever, but it's something to consider. Is it a lot? It's hardball. Yeah. But you're just dealing with the driving unsuspended deal. So your accusation
from a headlight.
Right. Hey, I spent a week in jail on a contempt over tall grass that had long since been mowed.
What?
Yeah.
Hey, this is an opportunity. Max, you look like a pretty young guy. This is an opportunity for you to actually really get yourself some balls in front of these people and go, you know what? They just wear pants like I do, and they're just fucking criminals.
I just got rid of my business partner like last week, and that's when I got this letter in the mail. As soon as I got home, I got the letter in the mail. I'm like, damn, I got another fucking option to stand up for myself. You know, like
that's the way to look at it.
Yeah. That's exactly what I was thinking.
Yeah, man. I wouldn't trade my adventures for nothing. I'm 54 years old, and I have no regrets. I've had a lot of challenges in my life, brother, and things that you would think were tragic, but I wouldn't trade it for.
Same here, but yeah, that's the way to live. That's the only way to live.
That's it, man. You learn from life.
Yeah.
And see, when he's being the asshole judge, he really is quoting his past transcripts.
I'm sure. I can hear it. I know.
I'm not a fucking. I mean, I literally had a judge say, "I'm not a lawyer." You lying fucking bitch. Bullshit. I mean, you know, I heard everything.
You hear it all. I had a black female judge tell me she didn't know what the word prejudice meant.
Oh yeah.
So I mean, they'll come on left field with this absurd crap. I'm like, I don't know what prejudice means. It's like you're a black female judge, and you've never heard the word prejudice. I basically it wasn't relevant to what I was doing. So I'm just like, well, good luck to you then. Is all I said.
Yeah.
But that's a good example of they will throw out everything. When I had an example here at work the other day. When you corner someone and you're right, the only thing they have left is violence. That's it. When you corner someone, unless they're a real man or woman on the other side that says, you know what, you're right, I fucked up, the only thing they have left is violence. And that's what you're facing. You're facing psychopaths that when you back them into a corner, they will fuck with you hard. Be careful.
All right.
Anyway.
I was going to say, one of the weirdest ones that I saw was in an English Crown Court with the Right Honourable QC. And first question my client asked was, am I entitled to a fair hearing? And he said, he wrote that down and he said, okay, I've got that. I'm not going to answer that. Your next question?
Wait, do what now?
That's a tactic.
Yeah, the silent judge, Gary. It's a very rarely used tactic. I think Mark came across it once. And when I came across it, man, it was fucking horrible and devastating. And the bloke who did it is one of the 100 most senior judges in the country. He's a hitman for the Queen, as I call him.
So now that we've brainstormed this one before, and I think what came out was, you're basically trying to kick them into something where they're just itching to answer you. Like I have, things like, well, evidently I don't have the right to be any right to be informed of the cause and nature of the proceedings. Is that correct?
Yeah.
You know what I mean? You're goading them into admitting that you have the right to be informed. They're just not doing it.
Yeah. That's it.
And then you're saying, well, I'll just make note that you just sat there and stared at me in response to that question. I'm presumably because you couldn't come up with anything that didn't show your biases,
Yeah.
But then you're trying to.
Those are very difficult questions to come up with, Gary. You just came up with a good one. Those baiting questions like that, no matter how they answer that, they're fucked, are very hard to come up with off the cuff.
Well, and how do you make one that is difficult to not answer? You know what I mean? That's as damning for the silence as it is for anything. That's right.
Yeah.
That's an epic thought right there.
It's like, how do you devise a question that's as damning to not answer as it is to answer? And that's the challenge with the silent treatment, with the I'm not answering your question, next question, or I'm sorry. When they
objection, non-responsive. That's what Mark Stevens would do for that.
No.
Yeah.
Well, again,
and he would do it again and again and again and again.
Well, non-responsive is a silence. Is you just wait. It's like, well, do you need more time to think about that? Maybe if he's actually giving you silence, it's like, well, if you need more time to think about it, then do you need more time? Do you need to come back to this another day? Maybe we should all go home and reschedule this after the prosecution has provided evidence of jurisdiction.
Yeah.
And that's one of the main problems when you're standing there in court and you actually get them in a position where they don't know what to say, and there's 5 seconds goes by, 8 seconds goes by, and not a fucking word said. It is so tough to shut your own mouth.
Yeah.
Because you want to fill that. When you've cornered them, you got to relish in it. And it's so fucking hard.
Think about what they're trying to do. They're trying to make it clear on the record, like in writing, what would this look like? It looked like you asked a question and you went on to another point before even anything was said.
That's sort of like if you bid a job or something, the next one who opens their mouth is the one who loses,
Yeah, right? Well, yeah, and in essence, you're thinking about the transcript, and they're thinking about the transcript, and if they don't like the question, they might wait for you to say something else. They might that might be their best tactic, is to wait for the next line on the record to be you putting your foot in your mouth. Or asking a different question.
Well, silence is also acquiescence, so you can use it against them.
Imagine 18 seconds
but you can't acquiesce to a question.
18 seconds of fucking silence. Imagine the stress you're going to have to open your mouth. I had it. I counted it out. I've got the transcript. 18 seconds. Dude, it's like fucking an eternity.
Yeah.
Really? In a courtroom, yeah.
Yeah.
And they know it. I mean, they're using that strategy to get you to take the question back.
Well, maybe I didn't mean it.
Well,
No, you meant it, but you're so uncomfortable, you'll just jump on another question.
Yeah.
It's like, and another thing, you know, instead
Although,
of saying,
is that a point to write down a note and say, well, you know, like how you were talking about earlier, Gary? Like I didn't feel safe to answer the question. Is that something where you should say another thing like that?
I guess the difference is, in this scenario we're talking about, you asked them a question and they gave you the silent treatment, right? They're just waiting for you to say something else so that that's what's on the record as last statement.
Well, yeah,
so you're just leaving it sit there. You're just leaving it to rot right where it sits. The question's asked, and they might say something like, "Hey, we've already talked about that plenty. Move on. What, do you have any other questions, or what's your next question, or something like that?" And here's the thing: your next question depends on the answer to this one, doesn't it? If they were to say, well, we don't have any, you're right, we don't have any evidence whatsoever, so you should go home. If they answer that, no further questions are necessary, right? So your next question really sincerely depends on the answer to the one that you just asked. Yeah, you might have other questions, but you really need the answer to know which next question is best. It's not just that you have a list of questions and yes and no and whatever, it's that you're building knowledge and clarifying points. It's not just that, oh, what's your next question? It's not, here's all my questions, fill them out and bring them back to me. It's here's this next point that I'm trying to clarify, and whatever you answer, I'll be clarifying that too.
Yep.
Yeah. So.
Anyway, I think we covered this pretty good.
I think that you could do several more days worth, but there's always things. No, I'm sincere. We always think in retrospect about little tactics that we've heard from judges, like let me brainstorm and come up with a good one. Tom, help me out here. Can you think of anything that it's a normal great sidestep from a judge?
I've hit quite a few of them.
I'm thinking about.
You know what though? It doesn't matter, Gary. It literally is. This is what we got to get through to Max. That it literally is a mindset of the 1, 2, 3, and we haven't finished explaining that, and that is very key here. All right, one.
I just thought of a sidestep that they use here sometimes is when you ask for evidence of jurisdiction. The judge will turn to the prosecutor and go, Mr. Prosecutor, have you got everything that's in order? And the prosecutor will turn around and go, yes, sir, yes, Your Honor, I've got everything that I usually have here. I've got the charge sheet. I've got the citation from the officer about the broken headlight. We're all good here, sir. And judge go, well, it appears everything's in order here. So what seems to be your problem, Mr. Swanson? That's a typical sidestep.
So did you? So he answered the question that you didn't ask. He answered the question he wished you'd ask. You didn't ask, do you have all your paperwork in order and the way you normally have it? That's not what you asked. And you didn't ask him, do you have jurisdiction? Right? Those are questions they want to hear. You instead asked, has the prosecutor provided any evidence that you have jurisdiction?
Yeah.
So they'll hear in their mind, they'll just internally translate it to, do you have jurisdiction? Because that's their mindset and that's their ego. and just like what are you saying? It's like, do you have your paperwork in order? Well, yes, I've given you all the normal stuff. Well, then that's good enough. Well, it's good enough for the judge. Is it good enough for you? And why is it good enough for the judge? It becomes the question, right? Why? Well, is that a burden? Did you put any burden upon him proving anything, or did you just ask that he asserted it? Do you have any reason to believe that assertion's true?
I'm so glad people are talking about this kind of stuff, and we're actually trying to find a way through the problems we got ourselves into,
Oh no, we didn't get ourselves into these fucking problems, and it's very important. Gary, you know what? The more I hang around this fucking Gary guy, man, I swear to God, words mean everything, man. It's just like they found me guilty. Bullshit. No.
Yeah, like they discovered it. Yeah, people act like that. They'll come back and they say they found me guilty. It's like, really? They discovered that you were guilty all along? You've been lying to us when you were saying that you did, you know? It's like, oh, if you were guilty and they discovered it, then fuck off, right? So they found me guilty. They pled guilty for me. They helped me cross the street. I wasn't even going across.
For me, they pled it for the prosecutor, right?
It was to your detriment. It wasn't for you. To your detriment is the opposite of for you. Yeah, I screwed your girlfriend for you. Well, thanks. You know. What? It's to your detriment, and we got to change our language, because we go in there saying, well, that judge last week pled guilty for me, and I have a problem with that. It's like, well, if it's for you, what problem could you have with it?
Well, so what is the best way y'all see in implementing these long-term changes so that they stop trying to be sneaky and they just want to be honest and say, well, you know, I'm a judge and I think I do good work. And then
hog
you're like,
up their time. Hog up their time. 52 visits, bitch. Let's go.
Yeah. And make yourself bad for business when you do. You know, take up that time, lots and lots of time. Make sure they get nothing out of you that's productive for them. The more people that they see do that, the more times people can go into, you know, their local city hall, or, you know, the next city along, because, you know, it's often safer that way, and embarrass the people who are elected, who spend thousands and thousands and thousands on publicity and TV adverts or something. If you get a good score of some of those guys making themselves look like Kermit the Frog's biggest Jupiter brother, then, you know, those kind of things can, well, they get out there, you know, people become known for them. That's all about making it bad for business for them. The more it's bad for business, you know, the less they can, you know, feel that they can run their extortion rackets without anybody, you know, questioning them. And it is, their public relations is their Achilles heel. So, you know,
I know, that's why I wanted to build a multimedia organization before I tackled any of this stuff, you know?
Yeah, well, you know, the best way you can do to show people is to say, hey, you know, these are the results that we've got when people have stood up, and here's how, you know, and that then encourages more, you know, more people to do that. You know, if you go to your city hall and you ask them, you know, some of those questions, where's your actual evidence? Where's your factual evidence?
Have you ever hold on one second, Fabrice. Max, have you ever seen Mark at the city hall meeting in his city?
No, I haven't.
That's what he suggests for practice, because there's no real pressure. They're not going to put you in jail. Yeah. Ask these questions. Go to your city hall council meeting, you know, every month or every whatever, and then ask these questions. How does this apply to me? And it's, watch his video, man. It's really good. It's good practice.
Which one is it? I'm on YouTube right now. What should I type in?
Oh, Mark Stevens, Tempe City Hall.
Yep.
What city hall?
Yeah, TEMPE.
Yep, Tempe.
TEMPE. Okay.
Yeah, Arizona.
Now, one of the things that's designed to help you kind of get over is, we have this like social conditioning. We have this social habit. When someone is asked, when we ask somebody an uncomfortable question and they make it clear that they're uncomfortable with it, we tend to find a new question. We tend to change the topic. We have a strong desire to avoid uncomfortable topics for other people.
And we just talked about that. At 18 seconds of fucking pause. Shut your mouth. Yeah. Wait. And just relish in it.
Well, it's like borderline personality disorder. That person's problem becomes your own, you know? Like,
yeah. Lawyers have a reputation of not giving a shit about that, right? And rightly so in this case. You're being accused. You need to kind of leave that at the door a bit. Now, obviously, safety first. You know, keep that in mind. Your safety, and there is a threat of violence.
You know, I've got enough money to pay this off right now. You know, I just don't want to. Like.
I mean safety first in the sense of you don't want to get brutalized and thrown into a jail cell for the next 40
I mean, I got enough money to take care of anything like that too, but it's just,
No, I mean, I'm saying they can throw you in jail for the week and you're just shit out of luck. I've been there.
Yeah.
Contempt. Be
I mean,
careful,
they
Max.
fed me, but some people they don't.
Yeah.
You know, there are
You
instances
know-
of people dying in there, but I mean, you know, not like
Hey, Max, do you
Yeah.
have a clue? Just take a little shot in the dark. What is the longest jail hold for contempt in history in the United States? Now,
Life.
contempt. What's that?
A life.
No, but it was 12 years.
Okay,
12
that's
years,
still pretty
12
long. Yeah.
years with no charge, so be careful.
Yeah.
I thought there was somebody that was still in for contempt that was longer than that, but maybe not.
Bad sign.
Yeah, still, I mean,
Damn.
yeah.
Right.
So I mean, again, there's no right reason. There's no sense of any justice in the contempt powers. So again, you know, you're being very calm. You're not. You got to watch with any argumentative things. All your questions need to be relevant and unanswered. Yeah, and they need to be relevant questions and they need to be unanswered questions. Because if you re-ask a question deliberately or obnoxiously, that can be contemptible. If you're asking irrelevant questions, like, you know, something other than is your mother a whore, but you know, there are other questions that aren't relevant. Or if they're trying to say it's not relevant and you keep asking, you're not addressing the point they made. They made the assertion that it's not relevant. And you say, well, okay, you know,
I need to go further back
so
and get the relevance.
well, yeah, it's like, well, wait a minute. This pertains to the cause and nature of these proceedings,
Exactly.
right? How
yeah.
is that not relevant? You know, how is it not relevant? If it has anything to do with the cause and nature of the proceedings you're in, it's relevant.
Yeah,
Yeah,
Gary,
right.
can you give me a hand working this one out, Gary? If the prosecutor says, you know, it's like, yeah, we've already given you everything you need to know about jurisdiction, and you ask the prosecutor if it's that their first day on the job, is that contemptible?
Uh-oh.
Well, I mean,
Hey, wait
again,
a minute. Hold on. That's what I asked.
you'd be risking it.
Yeah.
I could be risking it. Yeah, right. Oh, that was a Tom
Max
dig.
didn't hear that one. Max, I had literally asked that one.
Really?
And they'll tell you that you have enough to plead, and that's true. If I give you the cliff notes to War and Peace, you have enough to understand War and Peace, but you don't have it to the specific levels.
Yeah.
I mean, if you have no further question, then that's all you care about, and you've got enough information, and that's true. That can be true.
Mm-hmm.
And basically, when they say you've been given enough information, I say, well, I mean, I ignore it because it's their opinion. They feel that you've been given enough information. That's their feeling on it. That's fine. I'm not going to argue with them about it, but I don't feel that way. I have a clarification. My intention is to plead guilty. And they'll say jurisdiction's an issue for trial. That is completely true.
Oh yeah, I got that written down somewhere.
Here's the funny thing.
It can be challenged at any point, right?
It's completely true. It's an issue for trial, and it's an issue for arraignment, and it's an issue for sentencing.
That's hilarious.
See, they're telling
so what they
you
said wasn't a lie; it just wasn't the whole truth.
Exactly, it's completely true and completely misleading. So the question is, well, if it's an issue for trial, I see that. Is it an issue for arraignment? Is it not an issue for right now? See, they're giving you information to distract you. You know,
I know. I'm so easily distracted. You know.
Right? It's like, well, thank you very much. I'll make note that jurisdiction is also an issue for arraignment. The question is it an issue for now, or you know,
I didn't even
or
think
do I have
that.
the right? Right. It's there's a lot of things that they do that's a distraction like that, where it's completely true and misleading, and you know, all the tricks.
Max, you're gonna have a lot of fun.
No, I'm sure.
Nope, that's how I look at it. And before I even went in my last one, and that one was on Mark's show, I said to everybody, it's going to be Christmas morning tomorrow morning. And it was. It's up to you, brother.
What else? What are other little lawyer tricks? We need to come up with something that rhymes with Jedi.
Especially on especially on May the 4th be with you.
Yeah, right.
May the 4th be with you. It is May the 4th, isn't it?
It is. It is. What are other lawyer judgy distract you from your question tricks? Oh, we never did the 1, 2, 3. We've never actually done the 1, 2, 3. Okay, so 1, 2, 3 is 1, 2, 3 is three. There's three things that are always true. And if you find more, great. These are just kind of like my take on kind of categorizing things that are a segue to get you back on point of the question that you're trying to get answered. Right? Because they'll give you a big old distraction shit. And then one of these three segues tends to me to get you back to the question that you had and show why the question matters. Right? So
wait, hold on. Max, this literally is everything.
And Tom can never let me say this without.
This is it, dude. 1, 2, 3 is everything. You got to listen very carefully.
Tom really loves
three
the
things
1, 2, 3.
always true. What's the
well?
first
They are
thing?
always true. They are always true. It's just you're bringing them up to show that the question should be answered. Okay. Right? That's the point of the segue to get back to your question. It's to get you back. You need a yes or no to that because of number one. They're always usable. You can use any of them at any point. They're always applicable. It's which one is the best is kind of the question.
To keep the circle going forever until they send you home.
For 52 hours.
No, yeah, seriously. This is literally the 1, 2, 3 is the secret to keep this thing in arraignment, or for them to drop the charge or send you home. It's this important.
I need to know.
It's the way to do the holding pattern. It's the way to turn that circle, circle that plane back around and line it back up for that runway right again. And then it's they'll shove you past the runway and you'll circle back around. Okay, so number one, my intention is to plead guilty here today. I have an unsigned plea of guilty in my hand. It doesn't have to be handed to anybody. I don't give a shit if you stapled it to the wall. It's a discussion point. The fact is, you can no longer say he can't figure out what the hell you're trying to do because you're announcing it, right? So I have this unsigned. I'm just trying to clarify what I'm pleading guilty, what I'd be pleading guilty to. I have a clarification, blah blah blah, whatever it is, right? Your speech, your number one speech, brings you all the way back around to. So I need it answered. Do I have the right to do I have the right to be informed of the cause and nature of the proceedings, or whatever question you're on? Okay, so that is the circle that you've probably heard of many times, where it's like, hey, I'm just trying to plead guilty here. If they start, it's most useful if they start talking about things that you could do during trial. It's like, hey, if you got an argument, you can bring it up during trial. Hey, number one speech. Trial's not relevant. My intention is to plead guilty. Why are you talking about trials?
Yeah.
Right? Or they'll say, he'll bring all that evidence at trial. My intention is to plead guilty. So your discussion about trials really doesn't matter to what we're doing here. Now you can say, do I have the right to a fair trial? Or so forth. That's just a hypothetical if you chose to go that way. That doesn't really bind you down to, you asked about a trial, you got one,
Oh my God.
Yeah. As a matter of fact, be careful with that statement.
Yeah, it's like, can I get one? Can be taken as let's go to trial. Do
if
I have
want
that?
It, yeah.
Gary, Gary, listen, dude, this guy's the first day here. You're way too complex. Max,
no, it's not. We're not into the push.
I just want to ask something very quickly. Max, do you understand what 1, 2, 3 is so far at this point?
No, he's only got through one.
Things that are always true. And my first is my intention is to plead guilty.
Not.
I have
They're not things that are always true. These are the things that you're going to go round and around with for the 52 fucking visits, if so it takes.
Well, it's true, though. Right. Number 1, number 2, and number 3 are all true.
So yeah, but it's not like it's not that concept he just said is not good. They're the questions. Go ahead.
I disagree, but okay. we can let Max decide if it's a good concept or not. How about that? So that segue speech gets you back to your question, and you read it, I'd say verbatim. You have your questions listed.
Well, I was about to say, my intention is to plead guilty. I have an unsigned plea of guilty, blah, blah, blah. What's after that?
Hold on. My intention, I would say make it future tense. My intention is to plead guilty here today. Because if you don't make it future tense, Tom will interject instantly and say, hey, they'll say, I heard you wanted to plead guilty. Done, slam.
Yep.
Because he's experienced that. But
okay. Yeah, thank you, Gary.
They're not supposed to. They're supposed to confirm that you intended to plead guilty and not just take it like they misheard you and said fuck you and I heard something that sounded like guilty. Screw off. But anyway, so I would say, for Tom's sanity's sake, make it future tense. Make it clearly in the future. I have an unsigned plea of guilty here. It's not. I intend to plead guilty here today. I have a question. The question is blah blah blah. Right. Mm-hmm. So the fact is that you're making your intentions clear. You have, in fact, an unsigned plea of guilty. If they were to show you that they have jurisdiction and that the codes are applicable, guess what? I'd plead guilty if I were you. Good luck with that, right? It'll never happen. But okay, that's number one.
They're gonna start making some shit up after this. Honestly, I mean, if they see it enough, they will probably figure out a way to do that.
Oh, they do. Oh, they've already thrown a lot of wrenches in, and people get bound up because they get distracted and they don't think, oh wait, what's my 1, 2, or 3? Which one's best? And go there. They try to say, well, he said the question wasn't relevant. I don't know how to answer that. And he said it was an issue for trial. And okay, it's an issue for trial. So in order to address this, I have to go to trial. And and people come back and say they forced me to plead not guilty. And my first question is, do you literally mean they put a gun to your head, or do you just mean you felt pressured to plead not guilty?
Oh, it's totally the pressure, yeah.
Well, and is that pressure really on the record, or is it just something you put into it? You know,
it's not on the record, that's for sure.
See, so you willingly, quote unquote, voluntarily and knowingly pled guilty, right? Or not guilty, whatever the hell. Anyways, on to number 2. Number 2 is the gun in the room.
Okay.
It's a fact that you're not there by your voluntary agreement. Your voluntary agreement is not relative. You're there, I presume, because if you don't go, someone will drag you somewhere and threaten your life, or your life will be in a very, very great danger from police and so forth. Right?
Yeah.
I mean, correct? That's true, right?
Absolutely.
Okay, don't lose sight of that fact. You are not there because you wanted to go and have some sense of civic duty to resolve a matter. I mean, yes, you can be there. It's like, well, if you have a matter, I'm here to resolve it. But the only reason I can see that I'm here is so far is because of threats of violence, right? So that's the approach.
Absolutely.
That's and it's true. It's just keep it in mind and don't gloss over it when you're there. And it's like, well, I guess I came here, so he has jurisdiction, right?
Yeah.
That's when they say we have jurisdiction because you came here to have this resolved. They're changing the topic into something called in personam. That's aside the point. The point is, I just came here because it wasn't safe to not come here. That's the only reason I came here, not any sense of anything. You know,
I'm just
and not
participating. I'm only participating here today.
Yeah, so that's number 2 is the gun in the room, the violence. You know, if he says, we're gonna have you come in here again next week, you can say it's like, my intention is to be guilty here today. I'm only here today, even to address and to mitigate this violence. I want to end this violence today. Mm-hmm. I don't want to be under threats of violence for the next week. Just to give
or next year or 2 years,
just so you can give the prosecutor more time to come up with an answer that he should have already given you.
That he needs to have right now.
That he should have had before you got me here. See, Here's the thing they're trying not to confess. You're trying to get him to confess that the prosecutor did not give him squat evidencing jurisdiction, and yet he still dragged you into court. He won't confess it because he knows better.
Excuse me, we just lost you for the last second. You said, and still he does blah, 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 in the court.
Sorry about that. So he doesn't have any evidence from the prosecutor that the prosecutor's right that they have jurisdiction. He didn't care. He presumed it.
He's assuming it, right? Yeah.
He just presumed that, of course, he has jurisdiction. Everybody has jurisdiction.
The prosecutor always has jurisdiction.
Yeah. always has jurisdiction,
and they'll make fun of you. They'll literally make fun of you in court and have the people behind in the peanut gallery. They're laughing at you. Don't underestimate them. I've had it.
We've had it. Other judges actually laugh and nicker and shit like that. It's weird. It's almost like the jester. The job of the court jester has moved to the attorneys that are in the just around, and they do it. And it's weird because you'd think that
and the lawyers in the courtroom will chuckle also, whether they may be chuckling with you or against you. They will get the people. Dude, I'm serious. When I started questioning jurisdiction and is this an adversarial court, you wouldn't believe the shit I went through.
Would y'all explain to me what adversary means real quick? Because that's the one thing I hadn't looked up earlier that I read.
I'll get it. Okay, I'll get it. So there's adversarial and there's inquisitorial. Okay, and adversarial means that one side makes an assertion, and the other side can challenge that assertion, and the burden of proof stays with the assertion. Okay, and once it's proven, the defense can then show mitigating circumstances or flaws in the evidence. Right? That's adversarial. There's two parties going against each other. There's an assertion. There can be a counter assertion, or there can be a challenge. It's called, right? And they don't like challenge; they want counter assertion. So you're in adversarial positions, opposing positions, right?
Mm-hmm.
Inquisitorial is one in which the accused is just punished. It is not there is no right to
yourself innocent. In an inquisitorial court, you have to prove yourself innocent.
In inquisitorial, you don't even have that right. In inquisitorial,
well, you know what? Listen, Gary,
the court is just deciding to punish.
It doesn't matter. It doesn't matter. You are in.
Ask the damn question, Tom.
I know.
It doesn't matter.
Goddammit. Listen, it's getting late. This guy's only got one night. It's really simple.
Okay.
You're being accused of something. So you are in an adversarial court, and when you ask that question, and that's another one. Again, once you just this is the thing I want to try to get into this guy's head tonight.
So wait a minute. The only reason to ask if you're an adversarial court is if there's evidence of an opposing party.
I understand that. All I'm saying is that's another direction. Remember what I said, Max. After you piss them off enough where they go, look, we've got jurisdiction and we're not going there. And you need to now keep this fucking thing going around and around and around the 1, 2, 3. There's another avenue right there. That's all I'm saying. You have to find all kinds of fucking things to ask them. And that's one of them. That's all I'm saying, Gary. And it's important.
Fair enough.
Because
but you have to know where you're going. Because if you ask, is this an adversarial proceeding or inquisitorial, you have to know that the next follow-up question is, okay, if it's adversarial, then do you have evidence?
What if they say no? I've had a judge.
Damn it! No. Let's do the yes. Yeah, let me finish the yes one before you ask about the no one. The yes one is. The next question is, okay, has the prosecutor provided evidence that he has a client?
Right. And that
there is that evidence of an adversary.
Right. And remember what I said, and you were arguing with me earlier. When we have these motions, and he has them, okay, Max has these motions. And part of this motion is standing and corpus delicti and all that shit. Okay. And it deals with the adversarial court. That's why I brought it up. Because this is, listen, once this judge shoots you down, I'll be the judge and I'm shooting you down and say, Max, listen, we've decided jurisdiction. And if you say one more word about it, okay, now you need to go on to another topic.
Yeah, that's the point I'm trying to make. Jurisdiction anymore.
Right. But you're still not through arraignment. You ain't through arraignment. And you will not be through arraignment if you have multiple things to go to. That's all I'm saying.
And when you do that, now, you plead of guilty, you just have some questions and you say, and not even addressing the topic that I've been forbidden from addressing, or I'll be punished from addressing. I have these questions. this question here or whatever.
Mm-hmm.
Yes.
So we're on to number 2, though, the gun in the room. So it's
Yeah.
useful when they're trying to reschedule you. It's useful when they're saying, you know, it's just in the senses of when they're eluding threats, you know, or when they're trying to say that you're there of your own free will or something. They sometimes like that out of their ass. I mean, they'll say absurd shit like that, like, well, you know, you brought this matter here, so, you know, we have jurisdiction. It's like, again, the gun
or
in the room.
it could be used. It could be used. The gun in the room can be used in any question that you ask when the judge starts threatening you with contempt. Remember that. That's the most important time I found it.
Okay.
And I've directly asked, as I've said, "Are you threatening me?" And there's the gun in the room. Oh no, I'm the most fairest judge I've had at all. I've been the most literally, I am the. You can. She says to me, "You can ask anyone that's been in my courtroom. I am the most fairest judge." My point is, you bring that up. There's
and you're
number 2.
And this is a segue, though. You're segueing back to the original question you had and reading it again verbatim. I'd say without altering the phrasing at all, because you're pointing out that you're asking the same damn question. You're not rephrasing it. You're not doing it. You're asking the same question, and I almost want to be like, I don't know, repetitive about it. In the sense that this is like the 8th time I've asked this question.
Rephrase that question.
Restate
it. Exactly. Sorry.
Yes. Okay, so that's point number 2 is the gun in the room. Point number 3, the prosecutor's failures. Okay. The prosecution, the whole point that we're making is the prosecutors failed to state a case. That's what they would call it if you were in the opposite seat. If you had accused a government person, folk, of something, they would turn to you and say, "You failed to state a case. We're going to give you about a second to make up for your failings, and after that, we're going to send you home." It's called it's called failure to state a case. That's what a demur is. That's what a motion to dismiss is all about.
Yep.
Your point is that he has failed to state a case upon which relief can be granted. He's alluded to one, and boy, the judge really thinks that's just swell. But to state a case would be he has to accuse you and state that there's reason to believe that these codes were applicable. Not just that they were, that this is he feels that they are. He'd need to say that they were applicable because of some condition, some situation. Not just, well, because everybody knows. You know? Not something like, you know. So the point is the prosecutor's failure. It's not the judge's failures. It's not, you know, the politician's failure. The prosecutor has failed here. Sometimes he even failed to show up. He didn't care enough to even come to make sure that someone was here to clarify the charges to get through an arraignment. He just figured, oh, the arraignment will go nice and smooth because he figured no one would give a shit about asking for any clarification or anything of him beyond what he'd already been gracious enough to write down. And you'll notice that prosecutor will probably have very little to say, if he's even there. She, he, whatever.
She, yeah, this case.
Doesn't matter.
The judge and the yeah.
Sometimes they'll. The one time where the prosecutor and the judge will get into a chat, and I've used it in role play and so forth too because it's effective, is when you leave it without a question. You like make a statement, right? I'm going to turn to that prosecutor and start having myself a conversation with them about shit like scheduling, about when trials would be good for, and all this. I'm trying to piss off that quote unquote defendant, right?
Good point. Very good. That's a classic too, dude.
It's a classic mindfuck, right? So I'm trying to goad you into interrupting because that is contemptible.
Dude, that's
contempt for the judge.
See, the judge just turned to the prosecutor and started having himself a chat. You had finished your sentence, right? I turn to the prosecutor and start having a chat with him about what he's got paperwork-wise, what he's got scheduling-wise, how his fucking wife's doing. I don't give a fuck what. Right?
Yeah.
You're sitting there just antsy. I mean, you're cranked up to 10, right? And And you were just in an argument with this guy, kind of one of those question arguments, Socratic, whatever. And he's having a chat with the fucking other lawyer about when to have your trial when that's a completely off page, right? I'm goading you, and you're going to start interrupting me, talking about, I don't want to go to trial, blah, blah, blah. I didn't ask you about trial. I'm asking the prosecutor about what's good for him, hypothetically. And
you sure you're not a judge, Gary?
Wow, that's crazy.
Hey, it's a psychological game that really works.
Yeah. I just have such a hard time with that.
And it has a lot to do. I got thrown in jail for a week, like I told you, and come to think back on that event, he did that to me.
Really?
Well, but he went on collecting testimony and shit like that, right? Right? He's asking a cop about and a lawyer about what all evidence they have and what the cops what the cops' opinion is and shit like that. Again, it's not. He wasn't doing things properly. We were in the hall of a damn court, of a damn government building, But again, when I started saying, "What the fuck are you up to?" kind of things, I didn't say that, but it's like, are you even a judge here? I mean, we're at a card table out in the hallway. Again, that's where he fucking threw me in jail, But
in the hallway, not even in a courtroom.
They had no courtroom. We were in the hallway at a card table. He was in sneakers. We were in the hallway of a damn, a city, fucking revenue officer, whatever the hell they call him. Which led me to the question: is this anything like a court, right? But yeah, never mind that. But again, the strategic move that he had, and the strategic move I'm bringing up is where you're getting, you can say, objection, point of clarification, because their conversation actually is going on the record, and their assertions, if they're lying or have a problem, anything that's said, if you don't say objection to it, or you don't have an objection that you voice, it's as if you said, I wholeheartedly agree. Everything that's said, it's as if you followed it up with, I wholeheartedly agree. If you say nothing, if you skip a sentence, it's as if you said, I wholeheartedly agree. Unless you come back and say, well, wait a minute, there was something you said earlier that he has some trouble, blah, blah, blah.
Yeah. That's why I said earlier, learn the word objection and say it fucking to every word that comes out of their mouth. And literally.
Well,
it comes
and if objection's harder, you start off with stop, objection, the point of clarification.
Yeah.
You can just say stop, because you know what that is, and then clarification.
Yeah.
And they can get that if you think objection is too hard.
Well, over here, objection's far more common. I think than in Britain. Apparently, over there, the word objection is very, very like archaic or something. I don't know. It has a different feel.
Yeah. Yeah. The other thing that I wanted to repeat what you just said, Gary, is when especially they do it here, the judge and the prosecutor start having a conversation, and like you said, I wholeheartedly agree. Unless you bring it up, or unless the next opportunity you go straight back to it, they will take that as I wholeheartedly agree. So if the judge is saying to Mr. Prosecutor, well, everybody knows that it's the law of the land, that statutes apply to everything. Don't you agree, Mr. Prosecutor? Yes, Your Honour. It didn't take me all 4 years of my law degree to learn that, Your Honour. Shall I see you at the golf club? Yes, certainly. Thank you very much. We'll see you there. You can buy me drinks.
Yeah.
And then they proceed on to the next. Unless you say right there and then, actually, Mr. Prosecutor hasn't presented evidence to show that, they'll take that as, like you said, I wholeheartedly agree. So it's one to watch for, Max.
Yep. Yeah, that brought up another tactic. Sometimes they will look at the prosecutor and ask a question that, in writing, looks like it might be to you. Let me explain. he'll look at the prosecutor, for example, and says, you know, will anybody have any trouble going to trial, or will you have any trouble going to trial on Thursday? I don't know. This is a weird example, but there's better ones. But I'm just coming up with something. He's looking away from you. He's looking at the prosecutor, and he probably just got done having a conversation with the prosecutor, right? If he's really, you know, conniving. And he'll say, do you have any problems going to, you know, do you have any problems being here for trial on Thursday? Now, what does that read like in a transcript?
Like he's talking to me, huh?
He looks like he said you, everybody. Right?
Yeah.
So he's thinking about how it reads, and you've got to think about how it reads as if you were blind. If he's looking at the prosecutor, he might be trying to play a trick.
Okay.
So if he said you know, and you know, again, I would take it as a question for me as well. You know, I'd say, well, I have trouble with that because I still don't know. I still have some clarifications about the cause and nature of the proceedings, and I have an unsigned plea of guilty right here. I'd rather plead guilty here today. You know, that kind of thing. Oh,
yeah, I was going to say that's a good one to be aware of, especially if it's a recorded court. Because you can play dumb, because even if he is looking at the prosecutor, well, aren't you and the prosecutor supposed to be the same? So, you know, just to be sure, you know, if he's asking the prosecutor, he should ask you. It's kind of, he's asking both of you, isn't he? Unless he's addressing one or the other.
That's a good point. Did I miss any good ones like that? I was on a phone call for about 10 or 15 minutes.
A little bit. Well,
yeah.
We'll come back around to it again, I'm sure, at some point. Another one, giving you two choices that are both shooting you in the foot, right? For example, let's go with an extreme example. That's easy to catch. Would you know which is better for you, Wednesday or Thursday for a trial? Right? Do you want to shoot yourself in the left foot or the right foot? Is basically the question, right?
Yeah.
It's very common for them to say, do you want to give up this right or that right? It's very common for them to say, choose which right. Do you want an extension? Do you want what do you call it? Where you can get a time extension.
I don't even know anymore.
I told you.
Adjournment?
Yes.
It's not quite that.
Adjournment.
It's
Adjournment.
Continuance.
Yeah, that's what it was.
Stay. Stay.
So they'll say, do you want a continuance or do you want to plead here right now?
Wow,
right? Something like that. Where it's like,
right?
because continuance waives your right to speedy trial. It's like, well, you know, no, I want to plead guilty here today. You see, he's trying to get you off of what you really want.
Careful.
Here today. I said here today. I said here today.
I know. I said the same kind of thing. So she took it.
I know. Again, your judge was just basically sticking her fingers in her ears and saying, "I think I heard you say you're guilty. Good enough for me," and running off. That's basically your event. But I had one of those like a bureaucrat thing where she was trying to get me into that. Where do you want to testify or do you want to let him testify first or some shit like that? And she was trying to get me off my point. My whole point was, I want you to go away because this is already a settled matter, you know, or something like that. It was at the time, right? They're trying to give you two choices and saying, which one do you want? No, wait, I told you what I want. What I want is all the way back here, not what two choices you're providing me.
Yeah, they're trying to exclude the option that you would normally desire.
And they're trying to get you to say you want one of the things they just offered you. And that completely obliterates your own desires.
Mm-hmm.
And there's the reasoning between the 1, 2, and 3 when you go in tomorrow, Mark, to keep it basic in your mind, the desires you want, and to ask them questions of how their desires that they want apply to you.
Yeah.
Yes. So if I were to say to you, do you want Wednesday or Thursday trial? Do you want a continuance or whatever? You have number 1, number 2, number 3. You should be thinking, okay, which one's best? Well, number 1's kind of best. Ta-da! You know, I have a plea of guilty. I just have some clarification. You know, or if they say, how about we give we need to give this the lawyer another week to get this in. In the meantime, we're going to schedule your trial for Thursday. What's best? Well, number 1's pretty good. Number 2 is great. Number 3 is even better.
Okay, that's
Number
what I
3,
thought.
the prosecu's failures. Right as of now, the prosecutor's failed to state a case. Why are you giving him additional time to state his case?
I heard that clap.
Yeah, you're kidding, Max, dude. Listen. If you do what you fucking what's his name did, Paul, or this other new cat, dude, I about shit my pants. Both these guys, I went in 3, 4, 5 times, get my ass kicked, but I still sort of. I mean, I used their time, but I was a fucking idiot. Gary ate a lot of hats, believe me. Anyway, but dude, this is really a concept. It is a concept. It's not a script. It's nothing but understanding that this fucking guy and his minions are trying to produce or make you pay them.
Here's a good one. Here's a good one. If he's no longer answering your questions and he's fighting you about clarifying things, here's the question that comes to my mind. Do I still have the right to be informed of the cause and nature of these proceedings, or did I lose it at some point in the last half hour? And if so, where did I lose it? What happened?
So you
did I just lose it because...
before?
No, I've never asked this question before.
Good tip, right or no?
Well, here's the thing. I have sworn to myself I'll never set foot in one of those fucking buildings again.
Okay.
So I fight things in a much different way.
I've had my client. I was going to say I've had my client ask that question, and it was interesting because we had a recording, 7 minutes in. It says yes, you're entitled to understand the cause and nature. 5 minutes later, they're entering a plea regardless of what she's saying, and she asked that very, very question. Man, they closed that court, got her out there very, very quickly.
So again, I would then use that as a grounds for vacating that bullshit plea that was just for the prosecution's benefit, right? And then the topic isn't whether or not you pled, it's the fact that they shit can your right to be informed. And over here, it might be a language difference. If you say I don't understand, they don't give a shit. It's about I'm not informed. Yeah. I have clarifications, right? Because if you just go about saying I don't understand, they'll say, well, get a lawyer to help you fucking educate yourself or whatever, right? Right?
Reset therapy.
Yeah, the shrink thing, there's a more advanced topic on that I certainly hope you won't care about, but if you come back to something about that, I sadly have not personal experience, but I've worked with that threat of a shrink thing, and it's interesting. But hopefully
I would bring up quantum neuro reset therapy, and that kind of makes people that have been deemed crazy by other people to not be so crazy.
Well, and again, the competency hearing is not competency. There's 2 reasons you can be incompetent. 1 is that you don't have mental capabilities. 2 is that you don't have information. They want to pretend that the second one doesn't exist.
Nah.
And they want you to proclaim that you are competent, which confesses both. So you're basically confessing that you've been informed by saying you're competent. And that's what it's really about. And in fact, oddly enough, in Florida at least, the forms that they submit don't say anything about mental competency. It's about that he understands the charges. Well, they do say something about mental competency, but one of the big things that they have is about he understands what he's charged with and the cause and nature of these proceedings. And it's like, holy shit, they're basically getting an expert to say the opposite of what you're saying.
Hey, my buddy was in Florida, and he was going through a divorce, and his ex-wife Baker acted him. So I know what you're talking about.
Yeah, that Baker shit down there is horrible.
And so I know exactly what you're talking about.
And the funny thing is, it's known as just a way to get back at people down there. It's like totally known just a way to fuck with people.
Yeah,
they have an act where you can basically throw anybody you want in a nut house for like a weekend.
Yeah,
and people just abuse the shit out.
Yep. So shit can happen anywhere. Sorry.
Yeah, yeah. And then it's a common phrase to Baker Act somebody as a revenge. It's like, oh my god, how thinly veiled is that shit, right?
Anyway, sorry to get you off topic.
No, I think that was the 1, 2, 3 segues back, ways of taking bullshit and getting back to the question at hand.
And the right to be informed.
And, again, you have a list of a couple questions. The easy ones they'll answer, like, am I presumed innocent? They'll answer probably.
I got that one down on the same page I'm writing on right now.
sometimes they'll fuck with you even on that one. You know what I mean?
Yeah.
Sometimes they'll give you like, well, until you're found guilty.
I think that I'm probably going to be one of the first people that's ever walked into this courthouse and done anything like this.
It's funny.
Oh, wait a minute. Well,
you're right about that.
Hold on. Is this a small rural area, Max?
It may have been in the last 10 years, that's for sure.
Well,
he's in Arizona.
Hold on. What's the population where you're at, brother?
Well, in 2002, I think, it was 50,000. I don't know how much it is now, but it's way bigger than it's supposed to be.
Okay, that's not bad. Because I've seen the rural judges getting absolutely more brazen and more cruel than even the city judges. The city that sounds you're in, it sounds like mine, and they're not real nice either. But they're not like some of the real.
Yeah, it depends, I think, on how their bosses are. I mean, the whole goal is
Yes, you're right, Gary. It depends on what their accountability is.
Yeah.
And when you got, like, right now, I'm in a city where there's going to be elections for mayor and such and council, and there's no opposing mayor. Isn't
the thing. Wow.
And
the
judge I went in front of, no opposing judge. They're king.
Troy, for example, was in one of those fucking steamroll courts too, and he was effective because he made it clear. It's like, listen, what you think of as your chain of command, I don't really give a shit about because I know that I can go above them. I'm taking this all the way. This is a conquest for me, or whatever, a cause for me, and I am going to make this an issue forever. This is going to go up until I am out of chains that have nothing to do with you. And he made that clear to them, and that's, I think, a big part of why they were just like, you know what, go figure it out. Go out into the hall and come up with a settlement. And the settlement was a couple hours of whatever, community service and shit like that.
So is it bad to threaten other actions to these people? Like, for instance, a Rod class driver's license suit?
Yes.
It is? Okay.
I would say don't do that.
The goal is to make them aware that you're going to bring in someone that they look up to and make them look like they did a shitty job. Their job is to make you stop your blasphemy, is to make you knuckle under and take it like a bitch, is to make you go along and get along, and they're not doing it. You're making clear that they're doing a shitty job, not because you're flying off and coming up with these religious assertions about God's law or whatever, but rather because not because of distraction and bullshit, but because you're just trying to get them to do what they supposedly are supposed to do anyways. I mean, this is all shit that they're supposed to have done before dragging you into court. And you're not even getting an answer about, did you do it before court? Judge, did the prosecutor give you any evidence of jurisdiction, or did you bother to ask him for any? Because they were supposed to do that before they dragged your ass in, and they know it. They know that, and so they can't say, well, we didn't really worry about it. They can't contest that, and that's what really you're trying to focus on it, and get that baby steps confession towards. It's like, by the way, do you have any evidence of jurisdiction? Well, yeah, somewhere here,
That's all over the place. You can't go past jurisdiction, you can't go past arraignment. Once you step into trial, you are now in their rules. Well,
I've actually got another method for if it goes to trial. Have you all ever heard of the Dario Boots donkey kick?
No, there is no trial.
There is no effective method. Now Mark has some very, very good ways to embarrass them further, which is through voir dire of the witnesses and of the jury, right?
If it's not that far.
See, this way is my most preferred because it's the most authentic way to go about this. You know,
what authentic? You mean like it's sincere?
Yeah, exactly. Well, you know, you're actually defending yourself, and you're not using any loopholes to get out of it. You're just not submitting to them, and
you're challenging every point that they
yeah,
have.
yeah. You're not just letting them say something and then be like, all right, like.
Yeah,
let me explain the difference. Hold on, let me explain.
The other that's actually.
Yep, I love it.
Okay, let's go over that.
Give it instructions, and then when it does not follow the instructions, you keep firing your public defender until your 70 days is up. Basically, is what
except that, in order for you to fire a defender that you've chosen, you need the judge's permission.
I don't know. This is like a 16-page document that's got all kinds of crazy shit on it.
I understand you make the argument, but see, he knows that. Well, again, you have to make a very, very good argument that prosecutor or that defender violated your conditions of his employment and so forth, and that's kind of the point. I get it.
I'd rather do this first, though, obviously.
Fair enough. And again, you can always get an attorney later. You know, and again, you should know the cause and nature of the proceedings before you shop for an attorney. Even if they put a gun to your head. Wait, I mean, that's a very good point, don't you think?
Yeah, it is. I mean,
how can you shop for an attorney?
What you want and what you need, unless you even know what's going on. Like,
unless you know the cause and nature of the proceedings, I'd say you're hindered from finding an attorney effectively. Even.
You know what, Jared?
I've actually discussed with people.
You said that one a year ago to me.
Yep.
That's exactly right. Your Honor, did you want me to hire an attorney? Well, how would I know what kind of an attorney to hire unless I understand the cause and nature of the proceedings?
You fucked them over with that question, right?
That's awesome. That's awesome.
Beauty.
and because he's trying to say you should hire an attorney blindly.
Yep.
Pick one with the best advertising. I don't know. The fact is, he doesn't give a fuck what you choose. He doesn't care shit. You're the one who needs to live with that choice. He doesn't care. So it's like great idea. You know, that the idea of hiring an attorney is one I'm going to give due consideration here. Okay, in light of that, back to my question.
Am I hiring an attorney to? What am I hiring him for? I need to explain.
Does this guy need to specialize in cases where I'm permitted to know the cause and nature of the whatever the question is that you have?
No,
right?
Really, that's a good one.
That's amazing. It really is. Yeah.
Yeah. Exactly? Is he required to be specialized in cause and nature, or not like a crime? That's a good one, man.
It's a really good base question right from the off, and where you can take it in terms of, you know, should he specialize in, you know, cause and nature, or, you know, jurisdiction, or, you know, disclosure. It's you know, it's a really, really quite powerful one, that, Gary. I'm going to have to make sure I tattoo it on the inside of my brain.
And do you see how the 1, 2, 3 can keep going forever? Max, you're getting the fucking absolute crash course on the 1, 2, 3. This thing can go forever if you can be creative with your questions.
It's a Mexican standoff, and very few people have. It is, because the judge knows that the stress is on you. He's just at fucking work. He's getting paid. You're the one sweating, right? So he knows that you are predisposed to turning first, to dropping it, and by George, I'm tired. You know, you can't take the stress anymore for the day. So I tell you what, we'll just come back to this in a week, and I'm willing to even plead not guilty if that's what it takes to get the pressure off me for right now, so I can get some to breathe, right? And people do that all the time. I hear it sadly, where it's like, I just didn't have anything else in me. I pled not guilty just to get a break from it.
Damn. Well, I mean, I can understand that, honestly, but
Yeah.
still, what if I was in that situation? Would you say it's just the last thing I should do?
Well, it is. And it's sadly one of those things where you're begging, you're making an agreement with them, so to speak, and not to use an agreement too lightly, but for them to let you get a breath of air, you're agreeing that they can drown you tomorrow.
Yeah.
It's like, and that's horrible. I mean, I've heard of it going against them before too, though.
So if there was just like one spot in my notes I could turn to tomorrow that was like, damn, I'm about over with this shit, and I can just like look at, what would it say? What would it say from Gary?
I don't understand. Ask that again.
So if there was one spot in my notes that I could turn tomorrow when I was just about to give in totally, what would it say?
Oh, okay. Okay, I understand. I understand what you're asking now. And sincerely, at some point you will feel that there's
I'm sure.
Okay. And this is sincere. I mean, you will sincerely feel forced to do something, to let them just go with it, to let them do what they're going to do. Okay, here's where you are at that point, sincerely, and this is the truth. You'll understand once I said it. It's just that you'll feel afraid to even say it, and part of your mind won't even face it.
All right.
If you're at the point where you feel there is nothing left that you can do that is safe to do, think about simply stating that.
There's nothing left that I can feel like I can do?
Safely do.
Oh, that I can
Very important.
Oh, okay. That's all the duress and coercion.
Not that I'm out of maneuvers, not that I'm out of legal bullshit, not that I'm out of strategizing tactics. I'm out of safe actions. I don't feel safe.
The bailiff's got you in the handcuffs and he's starting to escort you off. That's what he's talking about.
Well, I don't know what. I mean, again, you'll have to.
It's sort of if I just felt like not dealing with it anymore. You know what I mean? Like if I just...
well, again, there's nothing that you can safely do. Otherwise, you can't safely walk out of the building, right?
Yeah.
You can't safely have a seat and do nothing. I mean, that's the closest what you're.
So what was that you said again?
That's really put well, Gary. You can't walk out of the building and you can't have a seat and do nothing. Whoa. That's a great one.
Well, yeah, but there's nothing that I feel I can safely do at this moment.
No, he just made a really, I mean, dude, this guy cuts it. He cut out again. The thing I love about Gary is that fucker is so raw and to the point with things he talks about.
Well, he seems like he's very, very simple when he explains it.
Yeah.
You know, if you can't walk out, you can't sit down. I want to be informed.
You have to do something.
But I can't ask. I don't feel safe to ask the questions.
It just makes sense, doesn't it?
Then you know, actually, if you're halfway up shit creek without a paddle, then that's a pretty damn good, clear thing to have on the record, isn't it?
Yeah. And that's the danger he's talking about.
And by the way, the what really just happened then is you fucked them. You have just basically fucked them out of the appearance that they're morally persuading you to move on.
Yeah, that's amazing, though, really. I'm glad I asked that.
Very important. It's an extremely important point to this concept that you're getting it in one night.
The truth is a very powerful thing, right? Because I've not told you to lie. I've just told you to be truthful.
Yeah. Yep, that's awesome. See, that's what I like so much more about this than that Dario Bush donkey kick kind of crap, because this actually gets to the heart of communication, you know, and what's happening.
Rational discourse, yeah.
Yeah, exactly. I mean,
what is an objection? An objection is you're pointing out that a logical fallacy just happened. That's all an objection is. You don't actually object. In theory, an objection isn't supposed to be, I don't like that. I mean, granted, prosecutors do that shit all the time.
Yeah.
But an objection is, there was just a logical fallacy, and I have an objection to logical fallacies being introduced. Or there was just a vagueness problem. I object to this vagueness because it could be misleading. So the objection is, point of clarification. What which of this is, true, or what specifically are you saying, or whatever.
So I'm kind of young. What was the word? I mean, what does the word fallacy mean?
Okay. It's similar to folly. It is an error in logic. It is something that, so if I told you, here's one called the non sequitur, okay? And it's a real important one for what we're talking about. So if I say, okay, you're wearing shoes, so you owe me $40. Okay, you understand that there's a logical problem there, and you inherently know, hey, there's some kind of a logical problem with that. It's called a non sequitur. It means the shoes doesn't follow that just because of shoes, $40 is owed. There has to be something else in between that's not mentioned.
Like an agreement?
So, if Gary, you were driving at 60 miles an hour, therefore you owe me $100.
Exactly. That's the same exact thing, right? And it's like, well, it's obvious. Well, the same thing is, hey, you're wearing shoes, you owe me $40. It's like, well, explain further. Well, we made a bet that you're forgetting that if you were wearing shoes today, you'd owe me $40. Oh, fuck. Okay. You know what I mean? Right? So there is a possibility that it's true. The fallacy isn't about it being true or false. The fallacy is that it doesn't necessarily follow. There's missing steps. Okay. You were driving 60, so you owe me $100. I don't know if that's true or not. I'm objecting not to it being true or false. I'm objecting to a fallacy being there.
Yeah, and if I was going to steamroll you, Gary, I'd say, come on, give me my $100 or else you're going to jail.
Yeah, that is an argumentum. That is an argumentum ad baculum fallacy.
Yeah,
I am correct because I'll punish you either way.
Yeah, and also a false choice as well.
Yeah, well, yeah. There's
you either pay or you go to jail. Actually, that's a false choice.
Yeah, there's usually a bunch. Yeah, there's usually a bunch packed in, but it's I am right because I'll punish you if you disagree with me. It's not. The question isn't. The question isn't, does the government have the power to imprison us or take our money? The question is, does the prosecution have justification and logic on its side in the assertion that it's making? If the question was just, does the prosecutor have the power to throw you in jail, it'd be an easy answer. We know they have the power to. We know they have the might. The question is, is it rightful to do so? And that, the court isn't there to decide if they have sufficient resources to throw you in jail. Otherwise, it'd just be like yes, we have 8 officers right here. Well, gavel, done, And they will throw shit like that at you. Well, we have jurisdiction because we have the power to punish you. Well, the question isn't about power. Sorry, go ahead.
How do y'all see the transition of the world from the way it is now to the way it should be?
Should draws in ethics, right? If you use the word should, you're talking about ethics, right? I mean, there's no other definition of the word should.
By should, I'm going to imply that we should just leave it the way it is and try the non-aggression principle,
Yeah, non-aggression principle is a good way to start. I think another one which was quite interesting with the use of the word should is judgment. Often we prejudge things by the labels that we put on things instead of actually observing what is without a definition of good or bad or evil or right or just or any of those filters on, and just actually look at what is, and then in the area with which you want to quantify it, i.e. is something productive, is it something that I'd like to encourage, is it something I'd like to avoid, then you can view that in a more rational sense. So I think the more people can remove that kind of judgment, I think, along with the non-aggression principle and the non-initiation of violence, causing no loss, injury, or harm to another, and voluntarily, engaging in agreements would be a good one to start. But that judgment one is quite an interesting one to meditate on.
Hey guys, just real quick, I see Travis just joined in here, and I could swear Travis was one of the guys who just recently got on here and had an interesting expedition in court, and he may be on. Yep, and he's going to be on here very shortly. So I know a couple. I believe, if it's not off the top of my head, it is off the top of my head. He was able to get a second arraignment, and that's the first one I've seen yet.
Bullshit. Well, I mean, it's not the first one we've heard of. We know people have been through 30 and 40 of them.
I got a second arraignment right now, and I didn't even do any of this stuff last time.
Okay, well, wait a minute.
I think they're trying to overcome their problem with that whole timeliness problem.
Hold on. Max just said he's got a second arraignment, but what he meant to say was he has a second arraignment because he didn't show up to the court date after his first arraignment.
No, I did.
Incorrect. No. You got the story wrong there,
all right,
Tom.
Okay.
Those were two separate incidences, basically.
Yes.
The headlight was totally different than my arrest from getting a suspended license after, what is it? Something about not showing up at court for the headlight. So, there we go.
I said that. Now, see, I was right. He didn't show up, so it's not a second arraignment in the sense.
No.
Yes. Wait.
He at his first arraignment for this, supposedly.
And I had to pay the headlight ticket to even get my license back after my first arrest. So I've only been arrested for this once. I've been tried for once already.
But what I'm saying is, you went through the typical thing where you pled not guilty, correct?
I guess so. Yeah. I was fresh. Yeah.
My point to you is, this new guy here, I could swear Travis is one of these guys who walked in, has never done this before. I think it's him.
Oh, yeah, no, I wasn't saying that I was like that. I was just saying that somehow.
I'm saying to Gary, this is a newbie that has actually got a second arraignment. So he has not forced past arraignment. I believe this is
I understand what you're saying now. Okay.
That's all I'm saying. If you can get that
at least
still down, you're doing something, brother.
Yeah, he has got a push.
Hello?
Hi, how's it going? I'm Travis.
Hey, Travis.
Hey, Travis.
Yeah, so Tom's right. I went to court. I went to court before I was supposed to be arraigned, and then they tried to arraign me, and then I kind of put a stop to that. So then they rescheduled me for another arraignment. So I've had, this will be the second arraignment attempt, but I haven't even had to enter a plea or anything.
So what do you mean you put a stop to it?
Well, basically what I did is I filed in California it's called a demeanor, but basically it's just a motion to dismiss or provide evidence.
All right.
And then I allowed him to say why he denied my demeanor, and then once he gave me the reason, I poked him about it and kept poking him about it and kept poking him about it until he asked me to leave.
Nice. Cool.
Oh, arguing your motion. We didn't do that one, Tom. Yeah, sorry about that, Max.
I got my motion right here. What's up?
No, I touched on it. I said you don't want to argue your motion. You want them to argue against your motion. You presented your argument in your motion.
Well, I'm basically waiting for them
you did
to
go over
deny
that. I was
grounds do you base your denial upon, right?
Well,
no, I'm saying this is a different scenario. The scenario that we're talking about is where the judge says, all right, you have a motion. Go ahead and you want to argue your motion?
It doesn't
I
even
don't
matter.
want to argue my motion.
No, let's go right from the fucking gist.
Why are you changing my hypothetical, Tom?
No, because let's just bypass that. Let's go from the gist. Let's go from the gist because this is what they all do. I've read your motion. It's denied. Now it's up to you to bring it back up on the table. Let's just
that's
really
a different
get to
hypothetical. That's a completely different hypothetical than I was trying to discuss, but okay.
All right. Well, you're going to go the easy way, and you're going to say the judge says, "Okay, Mr. fucking Max, argue your motion." Fuck that.
Okay,
He's going to go. You know what? Deny your motion.
I was trying to address the hypothetical, which we've heard actually happen.
All right, go ahead.
When I pulled out of my ass, where the judge tries to fool you into re-arguing your motion, right?
Yep.
So instead of saying I deny it, he's trying to first get you to shit can your motion. He says, you want to argue your motion. All right? And he puts it on you. Do you want to argue your motion? Now, what did I just assume? I'm kind of
arguing,
saying,
right?
No, I'm basically telling you there's no argument in your motion that I read. Maybe I skipped that section. So what I would ask maybe is, I'm sorry, did you miss? Are you missing the part of the motion that is the argument for the motion? Because you just acted like you didn't see an argument.
So he almost put the burden of proof on me, right?
Well, the burden of proof is on you for a motion, but you already did so. In the motion, you have an argument. Then it goes to the defense, the prosecutor, I should say, to oppose your motion and provide his opposition. And then it comes back to you to argue against the opposition. The judge is trying to fuck with that order. He's trying to say, you had a motion, you presented an argument, I'm going to pretend you didn't. I'm going to skip the other side having an opposition, and I'm going to tell you to take your last turn.
Yep, that's it.
I
literally
if you start arguing your motion, you're basically amending what you said in the motion. What you said later overrides what you said earlier, and he's hoping you fuck up, and you will. If you're talking off the cuff, and trying to just jabber your way through it, you're gonna fuck up.
Gary, I have a question.
Yeah.
Seriously, I'm unclear about this because I've never had to argue a motion.
You've never had a motion?
No, I filed a motion, but I never had to go.
It had arguments, but it had arguments. But it already had arguments in it, is what you're saying.
Yeah, well, it was Mark's motion to dismiss. What I'm asking is, for those that have experience going into court with a motion, I've seen people that the judge denies it and the person fails to ask the judge, "What's wrong with the motion?"
That's a different hypothetical. Yes, that is an important hypothetical, but it's different than what we're talking about now.
So I'm sorry. Where am I misunderstanding?
Okay, we're talking about the different hypothetical.
I was just going to say, basically, what Gary's trying to tell you is just don't argue your motion. When the judge says, "How do you want to? Is there anything you want to add to your motion or anything? How do you want to argue it?" You just simply say, "Your Honor, I believe my motion speaks for itself. Is there anything that you're not clear about in the motion?"
Yeah, that you need clarification on. Okay.
Yeah.
And
you can ask if there's opposition.
Well, my experience is similar. They just override the whole motion, say it's denied.
90% of the time, they won't give a fuck. They'll just deny it out of a knee-jerk reaction. Fuck you, move on.
And that's why I did what I said. When you brought up your hypothetical, I said, let's cut to the chase. Mr. Max, you walked through the gate. I read your motions. They're denied. And how do you plead?
90% is not 100%. It happens relatively frequently that they'll say, argue your motion, and you say, I don't want to. Or something like that, and that fucks up your whole motion. And that makes them look good for denying your motion. That's my point. And then when you say, what's your reason for denying my motion? He can say, well, you didn't have an argument.
Well, he's not going to walk up if the judge doesn't say that and do that. But I'm just telling you in general that he's going to walk up and the judge is going to go, I read your motions. They're denied. Yes. He's going to open the gate coming through. If he doesn't say that, you go at it with a different tactic. Okay.
Well, or if he says, I'm just preparing him for the 1 in 10 or whatever it is possibility of the judge saying, do you have an argument for your motion? Because I know of about 2 or 3 people for whom that's happened.
Okay, yep, and that has happened to me too. All right, so he has asked, and hence what Mr. Travis just said. That was for a newbie. You're that Travis cat here is one of the 2 guys like Paul Mosina. I believe Travis and Paul are like in my record books the top 2 guys I've seen yet.
So he did this. He actually said, you know, I believe there's already an argument in my motion. Is there currently an opposition?
You just heard him, Travis.
Is there an opposition?
I just posted a link to the court case, to the actual audio from the court.
I'm on a phone.
Hell yeah,
I'm on a phone. I can't listen to that right now. But yes, good. Thank you.
But yeah, basically in a nutshell, I went up there. He said, "Okay, I've read your motion. Is there anything you want to add to your motion? How do you want to handle this?" And I simply just told him, I said, "Your Honor, I believe my motion speaks for itself. Is there anything you're unclear about?" He says, "Perfect. Well, no, I've read your motion. I've read the complaint. I find that there's a valid cause of action, and I'm denying your motion." And I said, "Well, what I should have said was present the evidence, but I didn't. I went the other route, and I said, okay, well, can you please clarify something? Who is the injured party?" And once I said who is the injured party, I mean he just kind of just flipped. He didn't flip out, but his demeanor, everything just changed. You could just see him backpedaling.
Yeah, right. Good move. See, you're thinking there was better maneuvers. No, they're all great maneuvers. I mean, you know, there really isn't a better one because they're all damning.
Under pressure.
And you could have, yeah, you're perfectly right.
I ain't gonna lie to you guys, man. You may not be able to hear it in the audio, but I was nervous as hell, brother.
Oh shit, we know it.
I swear in my folder, man.
Again, you know, I mean, you know, every step of the way, you're thinking it's like, man, I'm going to be thrown in jail for the next week, and I'm going to lose my job, and you know, it is.
Yep.
Wow.
You know.
But if you stay calm and you just stick to what you practice, it'll work. You don't need a lot of things to say. You only need 2 or 3 things to say, and they're going to throw you out because they can't get past the first 2 or 3 things you throw at them. They just can't. There's nothing for them to do.
Right. Hey, Travis, I want you to be the judge, and I want Max to be the defendant.
Wait, I was just about to ask
before that.
I'll be a
horrible
down when he
before
said
that.
I couldn't
get guys. He remember when he said, "I found cause for jurisdiction" or whatever. I found cause to move on or whatever you said. Where the judge said, "I found cause."
Yeah.
I mean, again, the thing that comes to my mind is, great, you found the thing I've been looking for. Where the fuck is it?
Awesome.
Right?
Yeah.
And I wanted to say that after I left court.
Well,
I was
obviously not saying literally that, but that should be where your heart is, so to speak. Where it's like, hey, I've been looking for this for since this began. Great, where is it? Because
that's the beauty of the motion that I presented is because that is in my motion that he denied. He denied my motion. It was unopposed. I have him on audio saying that it was unopposed and that he denied it on his own opinion. And he could not or did not provide me with the facts that was requested in the motion.
Yeah. Yeah, he basically was in denial of reality.
And when they do that, now once that happens, let's say you're standing there and that's brought up and you got that far and you're still in front of this judge and he's made it quite clear that he's made his decision on jurisdiction. Now what do you do, Max?
That he's made his decision on jurisdiction?
Yep. He says, listen, I've had about enough of your questions about jurisdiction. Now, how do you plead? We've decided it. Now what are you going to do?
We.
We.
They do, though. They do. They say that.
Yes. And this is my point about these other avenues that we were just discussing. All these different directions we can go to.
Yeah, like, am I presumed innocent, right?
Yes. And then when he says, of course you are, then you say, am I presumed innocent of all the elements of this charge?
Every element of the accusation.
And they'll go around and around, and they don't want to answer that one. And then when you say, is one of the elements of this charge the code, and is jurisdiction
applicability of the code.
Yep, applicability and is jurisdiction an element? Well, yes, it is.
Well, again, if he's already gone on about how jurisdiction isn't something he cares about, applicability of the code is a different way of saying the same fucking thing.
Well, but Gary, am I right? We go around and around and around with different perspectives. Just keep them there all fucking day long.
Because you're clarifying, because they don't want to clarify, and you're asking simple yes or no clarification questions, and they're refusing to answer them.
Right.
And it's like, let's say they go on about, listen, you've wasted so much of our time, blah, blah, blah. Wait, I didn't waste, I've asked a total of 3 yes or no questions so far, and it's taken you an hour to answer them.
Yep.
So, it's like, I can recap right now the 3 questions I asked. The first one was blah, 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 and you answered yes. The second one was blah, 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 and you answered no. And the third one was blah, 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 and you didn't answer it yet. Or whatever the case is. I mean,
one more thing that I'll add I was going to say, one more thing that I'll add is they do weird shit too. Like, they put me in this tiny ass little courtroom where it had nothing to do with actual cases and shit. People that were in there already, their cases were already decided. They just didn't pay or whatever. So they were like, basically,
you were in the sentencing room.
And then they like to do shit like the guy made me get up and sit down like 4 times.
What?
Yeah, he called me up and he's like, you're the dude with the motion. Okay, sit back down. I'll get to you later. And then he called up some more people, and then he'd come up and he asked me a question or two, and then he'd tell me sit back down. And then he talked to some
what are they doing? What are they doing when they're doing that? They're training you to obey.
Yeah. That's amazing.
They're training you, and they do that. And they'll do that. They'll ask you questions just to get you answering.
And Travis still kicks their ass.
Woo! Oh, and if they ask you a question that isn't clarifying your question, what do? If they ask you a question that isn't there, that doesn't just clarify your question, it's a whole new topic. Right?
And
what do?
Travis, so keep talking, Travis. And
all right, so in that case, would you just simply say objection, sir? I'm sorry, I didn't get the yes or no in the clarification I just asked.
Yeah.
You just bring them right back to the question. It doesn't matter what they say or what they do. You just bring them right back to the question in a polite way.
It's like, that's a great question. We'll get to that as soon as I understand a couple things here. My question was blah blah blah.
When they try to distract you, yeah.
When they ask a question that's not relevant to clarifying your question.
Yep.
They're trying to change the topic.
Yep. Well, Travis, so when's your next date, Travis?
Do you have a driver's license or whatever the question is, right?
Travis.
It's the 13th.
13th. Okay. And that's your second arraignment, right?
Yeah.
Attempt. That's awesome, man. That's awesome. Like I said, waste as much of their time. Just keep hammering them with the exact same fucking questions. And I mean, think about it. You're pulling them away from.
And now you can bring up the point. The number 2 becomes different. It's like, now I've been here twice. I've traveled here twice, trying to get rid of this threat of violence, and here you are still not answering my question.
Oh no! The best part was he started going off on a spiel and some shit, and I was like, "Sir, I'm trying to take care of this today. I just want to get this done. I just want to ask questions." And he was like, "Oh, okay. So you wanna take care? How do you plead? You've been charged with the objection, sir. You still haven't answered my question."
Yeah. Okay.
Cool.
And you got away with the word question? That's a good one.
You know what? I actually, honestly, if you listen to that audio, dude, I kind of got away with a lot of stuff.
No, that's good.
Tom, I think you get away with a lot less than some other people do. I think it's just because they see you coming.
Because I'm a dick. I told you.
Yep, I know it. They know it too.
It blew my mind. I mean, under 5 minutes, I was thrown out of court. I was asked. He pretty much said, "You are free to go. You are free to go," and then the bailiff came out and fucking walked me out of the courtroom.
Well, and again, I know this is not to armchair quarterback, but it's like, well, I should be free to go until the prosecution has provided some evidence of jurisdiction. We shouldn't reschedule this until after that happens.
You're still trying to find out what's going on, like.
It's like we shouldn't even tentatively schedule this until that's happened. There should be no scheduling of anything until that's occurred.
By your own rules.
Yeah.
By their own rules. That's the thing. We're trying to hold them to their own rules.
You know, logic and justice and everything dictates it. Hell, even their own rules dictates it, right?
Yep.
I knew you'd have an argument for their own rules. You had to supersede that a bit. I got you, Gary.
I don't care about their own rules. Logic and justice and all that kind of stuff. If their rules happens to coincide with it, more power to it. And if their rules goes against it, fuck them.
Right. Yeah.
But when you know it is their rules, sometimes it's good to ask the question because, again, it just increases the leverage to get you out of there, to show you're bad for business.
It does. It does. They have use to understand them, but you shouldn't internalize them. You know what I mean?
Yeah. That's for sure. I mean, I think that's why it's good, you know, if they do try and zip off to another topic or to throw you a curveball. It's just to go, I'm sorry, was that a yes or a no? And draw them always back to the simple question.
I sometimes have hearing problems. I sometimes mention hearing problems. You know, it might be a good thing to mention there. It's like, I'm sorry, there was part of that I missed. Was there a yes in there? You know, or it's like there's part of that I didn't quite hear. Was that a yes or a no, or was there a yes or no in there? You know, it can throw them off their game a little bit if you're saying there was part of that I didn't catch, but I don't care. I care about the yes or no.
It's like what Mark says when you take notes and repeat it back, and they realize how stupid they sound. They're like, "Whoa, do I want to say that again?"
Yeah, right.
Hey, Travis, it sounds like you really unnerved that judge.
Yeah, thank
you. You know, I thought I did a lot worse than I did when I first listened to CD today. I was like, man, you know, I didn't sound too bad, but
cool.
I was trying everything to be as calm as possible.
Yeah, it sounds like you did it, man. Very cool. I can't wait till the next one.
Oh shit, I can.
Man.
Oh, you mean his next one? All right, yeah, fuck
well,
him.
His next one. If I would get off my lazy ass, I would file this on demand again to be heard as that one word that you're aware of, Gary, where the judge heard the words guilty and took it 10 minutes or 15 minutes. Right. And I heard the word guilty. Okay, I'll take that. So I could bring that back. It's still not out of what do you call it? Time. So
I see.
If I wasn't so lazy, I would have some fun too. And I'm having time, fellas. I think I might bring this one around too and have a real practice at it again.
And as far as that one goes, you cannot appeal something that never occurred. I would bring up the point that you were never arraigned, so you can't appeal the guilty plea that was entered supposedly for you.
Yep, and not only that, there was never a witness. No cop had ever testified against me on record.
They didn't need to. They had a guilt. They pretended to have heard a guilty plea.
Yep. So
that
I'm
is
tempted,
so
man.
weird.
I want to bring that back. It sounds like fun, and it can't cost me anything. I'm already being bent over with my insurance. My car insurance went from
the fees are for an appeal. I would file a request for an arraignment, not for an appeal.
Right.
I would put that turd right in that punch bowl and say, hey, by the way, guys, I'd like an arraignment for this issue. And they'd say, you've already had one. And they have then asserted that you've already had an arraignment. And it's like, oh, all I have record of is this bullshit that has nothing to do with an arraignment.
Right.
Yeah. And then you're making the argument about the fact that wasn't an arraignment.
Yep, I'm real tempted, man. I told you I'm 3 for 4, Mark or Max, and that one is really sticking in my craw because I'm 54 years old. My insurance was peanuts, and I'm paying like $1,500 every 6 months now because of this ticket that he fucked me on. So it's been sticking in my craw pretty regularly every month. Anyway. Well, guys, I'm crashing out. I got to start a little early in the morning, and I'm going to let this recorder go. And it was great talking to you tonight, Max. And you, what time are you doing it in the morning?
I'm doing it at 9 a.m.
And what end of the country?
Don't expect
Yes,
to get anywhere until about 3:30. By the way.
Yeah.
Eastern Standard. Okay, that's
Thinking
where I'm
about
at.
11, but yeah.
Okay.
Oh no, they'll put you off. They'll make you sit because that unnerves you, and they know it.
And
you know, so they'll just make you sit and stew.
Just
for a psychological tactic, you know.
And just to get up to speed, because I do tend to remember people. You said you have not filed any of the motions yet, right?
I filed the motion for discovery. That's it.
When did that happen?
Friday.
Last Friday. Today's Monday. And your court date's tomorrow?
Yep.
They're going to argue they didn't have a chance to look at it, or they're just going to shoot it down. But, okay, that's fine. Just take the other ones along.
And again, one of the questions you might have after you've asked if you have the right to know the cause and nature of the proceedings is what is timeliness? And how is a year, almost 2 years, timely for this issue?
Oh, yeah. Yeah.
Wow, yeah. Damn, that's awesome.
Yeah, don't forget to scribble that one down, Max, because that would be useful
I'm doing it
to
right now. What is timeliness?
Well, I mean, again, how is two years timely for this prosecution of no action whatsoever? You know. And what what is the cause of this delay or whatever?
Well, hold on. Has there been a warrant out this long?
No, not at all. I mean, that ended really soon. Because as soon as I got out of jail, I got a real license. You know, like.
So. Okay.
Well, yeah, and ask them. It's like, how long do they have to complete this whole ordeal and still be timely?
So what is timeliness, and how is 2 years?
Well,
timely?
Again, you're not asking them to define timeliness for you, you know. But you're the one that brought up the word. You can't ask them to define a word you brought up, you know. But you can say, it's like, well, how does this satisfy like timeliness? You know, how does it satisfy justice when there's this timeliness issue or something like that? And you know, you just kick it around and let them kind of justify it, you know, and what just so that they can't pretend that they didn't notice that it'd been a year and almost 2 years, you know. We didn't notice it had been 2 years almost, you know, and you know, it's like, does that mean now that they have several years to get through this?
Yeah, and it all helps because it's just another hook that draws them over to the side of, you're bad for business, and actually we just want you to get out of here, you know.
Yeah, and it gives them an escape.
Yeah,
and it gives them a scapegoat because they don't want to say that you're being let go because they couldn't prove jurisdiction.
Oh, wow!
That
so giving
what
them
they
a
want to do.
reason to let me go is a good idea. Wow,
that's a
good idea.
And the judge, you know, after some fighting and so forth, let's say you've played the tug of war for a while with them. It's like, all right, the next question I have is, how is this timely and what's going on here? And the judge might think about the arguments that you've had over the last 5 minutes or 6 minutes and say, fuck them.
Yeah.
You know,
this I put right next to, there is nothing I can. Nothing I feel that I can safely do right now. That's what I put right next to it. So.
It's right up there, huh? Oh man, one evening of this is a lot of mental like prep. There's a lot of mind shift.
I'm gonna have some dreaming later on.
Yeah, because I mean, it's a whole perspective.
But, you know, I so appreciate this culture that you guys have going on right now. You know, like, it's amazing that people are even willing to talk about this stuff and ready to take some action about it.
Well, to be fair, we're only willing to Skype about it. It's not like we're coming to fill your place, right?
And I'm only willing to say thanks, but you know.
You speak for yourself, Gary. I've been in there and done a couple of politicians, and you know, even had the opportunity to question a couple of cops about it without endangering my life. So
and don't get me wrong, I this is a huge part of my life, and you're aware of that, I'm certain.
yeah.
But what I'm saying is, it's tough. It's tough to just be too much. We're just guys on the internet for the most part,
Yeah.
The small part is, I mean, I feel bad. I mean, I've had a couple of guys in the local area, but how do I take off work of a new job to go sit in the pews?
I was about to say, I had to take off time from work to do this kind of thing.
Right.
And it's just amazing that people are available on the internet exactly when I need them to be, Like,
they totally count on people having real lives and things to do rather than show up in court.
And because they're there every day.
Because you get a ticket, and if you really want to fight it, the cost and time and/or money is going to overwhelm the people that took it off.
Off work.
Well, to me, the cost just looked like, per an hour. I could probably spend about 8 hours to pay for my charge. And
in reality, it's going to be cheaper financially for you just to pay the ticket, right?
Well, I'd just rather not pay it. Just so
right.
Well,
money, like.
But if you were to take this through court, you're talking about probably 2 to 3, maybe 4 visits down there.
Yeah, well, exactly. I know. My mom was trying to tell me, like, it's going to be so, like, you're going to have a lot of time spent in doing it. And, I have spent a lot of time and energy besides just manifesting jobs and business work. But,
it's too much fun.
I still would, it really is. That's what it comes down to. I mean, what other time in history have we ever had to, I want to say, revolt like this than now?
Yep. It's a way to do it. It's a way to do it.
Right now, yeah.
Tie them up from fucking somebody else over. Take so much of their time. Hey, it's a win-win situation, man.
That's the thing. I'm 54, almost 54 years old, and my entire life the system has been this way. Back in I believe it was 1986, I beat a red light charge the conventional way, right?
Yeah.
I cited code, and it was just me, the judge, and the cop in the courtroom, and I got acquitted. I don't know how it happened, right? But I did it. But had I known this stuff back then, I would have approached it this way.
Yeah, I'm sure.
Absolutely, and I would have gotten the same reactions.
It's interesting to note, for instance, that probation has only been around since the 60s, Like, where did that come from?
You know what? The funny thing is, you go too much further back than that, people would send their children to serve the prison sentence that they got.
No way! I never heard of that.
Absolutely. You never heard of that? It was most common. It was most common that the eldest daughter would be put in jail, so that the father could still provide a living and stuff like that. It was completely normal. Like, because they were the least or eldest daughter or youngest daughter, I forget which, but
because the father had to provide.
Yeah, stand in punishments by the children and shit like that. I mean,
and where does punishment help this all anyway? That's honestly where the discussion needs to go.
Well, you had the gall to drive without a driver's license. Can you imagine how many people you put in danger to drive without that driver's license?
Well, none, because I wouldn't do too bad, right?
Are you telling me that you don't need a driver's license, sir? Everybody in this courtroom, right now is paid for their driver's license, and they have one. You're telling me that you don't need one, sir?
I don't have a driving license.
Maybe all these.
They'll try this shit on you, man. They'll try to. They will try to get the people behind you on their side and laugh.
Oh, I know.
It's part of the game.
What Tom was just doing is taking your challenge, where you're saying, "Do you have any evidence of what you just said?" and turning it into what's called a counter assertion or a counter proposal, counter opposition. Whatever. Anyways, where he's trying to say just challenging what was being asserted is the same thing as saying the opposite is true. Like if they're saying it is true that blah blah blah, and you say I don't see any evidence for that, and they say, well, you're trying to say that the opposite is true, and you don't have any evidence for that, and it's like no. The difference between a counter assertion and a challenge, okay, is a challenge is just a neutral position where you're saying, I'm still investigating. Do you have any evidence of what you're saying being true or not?
Yeah. One of the most common times we get that over here is when you mentioned that you haven't received any evidence of jurisdiction. The magistrates, especially at magistrate level, they nearly always reply, "Are you saying we don't have jurisdiction?" And so, just by asking for it, they're saying, actually, no, are you saying that we don't? And also taking that quite personally. And so, the automatic reply is, I'm not taking a position. All I'm saying is that I haven't seen it yet. And therefore, until it's presented, does this court have to proceed as if it hasn't been established yet? Yeah, but otherwise they'll try and force it down and say, well, what have you got to say that we haven't got jurisdiction? You prove we haven't got jurisdiction here with all our guns or with all our things. You prove you don't have to have a license.
That's called shifting the burden of proof.
Yeah.
That's called shifting the burden of proof.
Is the burden of proof on the prosecutor?
Well, and that's what a challenge leaves the burden of proof on the prosecutor. If you make a counter positive assertion, if you assert that they don't have jurisdiction, that burden of proof shifts on you because you made an assertion. And now they're waiting and looking at you and saying, okay, you got any proof of what you just asserted? No? Well, then fuck off. Time to flip a coin. Time to go to trial, whatever.
Yeah, Mr. Max, are you saying the codes don't apply to you?
Is yes a wrong answer?
Yes, it is a wrong answer.
Yes, it is wrong.
You got to be very careful.
A better answer might be, I see no evidence.
That's right.
That would lead me to believe that the codes apply right now.
Because
but I'm trying my best. Yes.
When you answer that word with yes, then she'll ask you for evidence of your assertion because you made one.
Yep.
You got to remember that. And I just got asked that when I was asking. What's that?
Or she won't ask you. She'll just let you hang on it.
Well,
because the record will show that you didn't prove squat, right?
Right. All right. Either way, don't answer that question with yes. That's for sure.
Even though it seems so natural.
Yeah, because she's trying to say either you agree with us or you oppose us. And that's not the only choices. The default position is called skepticism, where you are skeptical of all assertions and challenging them and looking for evidence of their truth.
Well,
this is.
I'm sorry, Judge Tom. I'm sorry, Judge Tom. That's what I'm trying to find out right now. If you could just answer these clarifications, then I could make that determination and we could proceed.
Well, Mr. Travis, I've heard your arguments and I've read your motions, and I told you I denied them, and I really need you to plead. The charges are quite clear.
Well, I would love to give you an informed plea, sir. I just need these clarifications answered. You said you found a valid cause of action. Can you tell me who the injured party is?
Well, prosecution, I believe it's the state. I believe the prosecution is representing the state, so the state is the party that is charging you, sir.
I'm sorry, sir. I'm sorry. Give me a moment. You're saying the state is the injured party. Can you define the state for me, please? I'm not sure I quite understand. What do you mean by the state?
Sir, it sounds like you have some political argument, and I'm not. I can't go there. I really need you to please. I've had really enough of that.
Again, sir, I apologize. Please, I'm just trying to get this straightened out. Okay, well, let me put it this way: if I subpoena the state, who would come to court to testify?
Sir, I'm not here to have arguments, arguments or anything like that. I need you to enter a plea, and I'm getting very impatient. We have people waiting behind you.
Again, sir, I apologize. I'm trying to give you an informed plea. I intend to take care of this today. If you can just give me these clarifications so that I can understand what's going on, I'll be more than happy to get this taken care of today.
Very well.
Can you please, again, can you please explain to me what you mean by the state?
Sir, I'm not here to answer your questions. I really think you may want to hire an attorney, but I need to get a plea. You know, it sounds like you really want to go to trial, and I think we'd really like to be fair, and I can appoint you an attorney if you need one.
Like to be fair.
Again, sir, I apologize. I'm not seeking legal advice. I'm seeking legal intent, and I just need to know what you mean by the state.
Sir, I'm not going to have a ridiculous conversation like that with you, sir. I really need to know how you plead to your ticket.
Again, sir, I'm trying to give you an informed plea here. I'm trying to. I just need to get this clarified. I just need to get this clarified so we can proceed. Again, sir, what do you mean by the state?
Sir, I've heard these arguments before of you sovereign folks, and this is my court.
No.
I run my courtroom. You don't run my courtroom, sir. And if
Objection.
Yes, sir. Yes. What's your objection?
Where do you come off calling me a sovereign? Did I ever give you any indication that I'm a sovereign?
Sir, you've been asking questions about political questions that I can't answer, and it's really not in my my bounds or my purview to do so. All I know is I have a ticket here that you've been given for such and such, and how do you plead? That's all I need to know.
Is that a legal determination?
Yeah, are you legally determining I'm a sovereign?
I don't know, sir. That's not my concern. I just want to know how you plead on this ticket that you have right here that this officer gave you.
Are you practicing law from the bench, sir?
Sir,
bad advice.
Or comment like that out of you, you'll be going to jail for contempt. I'd like your plea right now. I've had about enough of you.
Can I please see your W-9 forms? What is your identity? What nationality are you?
Yeah, you'd be in jail.
Oh my God! Yeah, you'd be in jail.
Yeah, I guarantee you'd be in jail.
Are you a citizen, sir?
Yeah.
See, you got way off track. Travis was on the right. I mean, the bottom
this is good. I'm sorry,
Mac.
Yeah, you should really stick with the Mark Stevens Socratic type thing, not get into
the idea, Mac.
How to get the Freeman movement stuff.
Yeah, stay away from that. Just keep the questions going and just hammer on those things that you have in your motions. The jurisdiction.
Sincere, honest. They are sincere, honest questions. You're really these clarifications are things that you would like to know, probably, right?
Isn't that
now
crazy?
The nationality, right?
What's that?
No. I'm trying to contrast that with questions about like nationality, for instance, because that's an abstract concept. You're asking somebody to clarify an abstract concept of what nationality they are and citizenship and things like that.
Oh my God.
And it gets you open up a big can of worms because they want to get off on those topics. If they get you all riled up about nationalities, if I were a judge and I knew where you were heading with Marcratic type things, I could totally rip you apart with a nationality question just by screwing with you, by goading you around with it. If you ask me, because again, why are you presuming that nationality is relevant here? Nationality was not brought up by the opposition. The accusation includes no interest in nationality, and you brought it up. How is it a relevant and unanswered question? Right?
They have to identify themselves if asked.
They don't. They don't have to identify themselves. They convict people day in, day out without doing so.
It's like,
so that's clearly not true, right? I mean, it's clearly not true that they have to identify them.
A judge can't make a belief. Only a man can have a belief, not an actor.
Okay, so that's clearly not true either because they do it all the time.
Well,
right? You're saying something can't happen that happens day in and day out. So obviously there's a problem with our language is a little different, right? So you don't really mean can't.
Yeah, Travis was really on the point.
It seemed for me. Sorry, Scott. It seemed for me when Tom was having most difficulty as a judge fielding the questions and trying to get the defendant back on the plea was when Travis was holding him to defining the simple questions, the evidence of a complaining party, and thus any evidence of jurisdiction, and that was making it really, really difficult for Tom. So it seemed to get him onto the plea without it exposing the fact that he hadn't been informed. Yet as soon as you diversify away to anything like the judge's oath, the judge's nationality, that seems to be where that I know in this country they love to counter on that. If you give them three simple questions, if you give them three simple questions about jurisdiction, complaining party, and applicability of the code, and whether a piece of paperwork arrived on the 10th or the 12th, they will argue the toss about whether that piece of paperwork arrived on the 10th or the 12th and nothing else, just to get away from those three questions.
Right. I love that.
The best advice that I could give you from a newbie's perspective is when you go into court, when you ask the question or clarification, that's the thing. I ban myself from using the words answers and questions. I completely just punished myself if I used either one of those. It's clarification and response.
Huh.
Because they're not there to answer your questions. They're there to make sure that you're informed before you enter a plea. And technically they don't even have to inform you. But if you're not informed, they technically can't take a plea from you.
Technically.
That's a great point. Can I elaborate that point? That's awesome because it brings up
please do, Gary.
Okay. So I've heard people say they wanted a motion to force a prosecutor to clarify his case, to state his case, right? Things like that. It's not a problem. You actually want him to not state his case. That's fine by you. If he doesn't state his case, great on him. You don't want anybody to be forced to answer these clarifications. You don't want anybody to be forced to clarify these things. A failure to prosecute is a good thing for you. I understand that in between that, the judge is going to shovel over that failure to prosecute and push on anyways. But that is the problem, is that he's pushing on even though there was a failure to prosecute. The problem isn't the failure to prosecute. So you don't object to the failure to prosecute, you object to the shoveling on and the steamrolling. So if nobody clarifies your question, if you ask a question and damn it, nobody's clarifying this point, you don't get all pissed off and say, damn it, somebody needs to be ordered to clarify this. It's okay, this isn't being clarified. It's a failure to prosecute. I'm, again, raising my motion, demurrer or whatever. This failure to prosecute keeps coming up. How long do you intend to ignore this failure to prosecute? Again, I might not phrase it like that, but but that would be that would be the what I'd be trying to convey. Not make him give me discovery. It's rather, hey, if he hasn't given me discovery, it's a failure to prosecute. And a failure to prosecute should lead to a dismissal.
And so I guess all the time you're increasing the pressure for them to take that option to throw it out, to take your motion to dismiss. Okay.
Well,
so wait, if nobody clarifies the point, if he hasn't given me discovery, then what did you just say?
You don't even have to worry about that. That's neither here nor there. Basically, what I was trying to get at, and maybe I wasn't explaining it very well, is when you go in there and you say, sir, I just have a couple of clarifications, am I innocent of all charges, yada, yada, yada. When you get to the damning question, you just stay on that question, no matter what. You just stay there. You just stay there until you get the yes or no. And then if you get the yes or no, then you write it down and you moved on to the next question. And you're not going to get to the end of your questions. It's just not going to happen, because if you did, they would be like, oh, fuck, I have no case. You're free to go.
Right? and we're only talking about at most, what, 6 questions maybe?
Yeah, dude, it's super simple, man. It's super simple. And even if you don't even remember all the questions, you can get by with 2 questions. Just go back to it. When he starts to try to sidestep you, you come up with one of 3 segues, right? And you go right back to the question. Well, I need a plea from you. Sir, I intend to plead guilty today. I just need this clarified. Do you have jurisdiction, or whatever the case may be? I mean, and just right after that comes out of your mouth, you hit him with the same question. Just don't let up.
Again, it's the knowing. It's a mindset. That's why there's no script needed.
So, did you notice, by the way, Max? Now,
What?
Travis hadn't been here when Tom and I were doing our role play. Travis wasn't on the call yet, right? When he did that role play, he did exactly the same thing I did. Did you notice how parallel that was? It was very much the same exact conversation. It's just oh, that's great. About my question. Oh, that's great. What about my question?
Yeah. It's pretty much 20 minutes into the recording. I think I've got Gary doing that, and pretty much 3.5 hours later, Travis doing the same, and it really
Right
shows
off
the
the
questions stand, don't they?
Right off the cuff, and a newbie. I mean, that blows me away. Travis and Paul Mozina, man, I'm telling you, that is so fucking cool to see 2 people just grab it just like that. It just takes a few people like that to spread that information around, man. Guys,
Absolutely.
I got my hopes up for people. I really,
you know, it's crazy. Literally at work, there's a pool of whether or not I'm going to be held in contempt.
No way.
It sounded like hammer time to me. Not a lot of people have the ability to do that. Everybody can't do that. Some people. You were good, Travis. I was blown away.
Hey, Travis, where'd you work?
No wonder the judge was nervous.
Where'd you work, Travis?
What's that? I work for a bus company. I fix buses.
Excellent. Nice.
Well, you see, Travis's recording there proves that it's necessary to at least unnerve the judge and or piss him off. You can't get by it. You just can't do it. I mean, they're not going to. You're not going to give them a motion or ask them a question, and they're going to go, "Oh shit, you're absolutely right, dismissed."
Unless they don't care. As soon as they don't care, then they'll just shovel it on the prosecutor. If a judge doesn't care, they'll just shovel it on the prosecutor. Say, hey, you timed out. Do you know what? You didn't have all your stuff. Next case, come on, let's get on with it. I have somebody who I'm going to fleece in half the time.
Everything that I've ever heard anybody ever say, it's exactly like they were telling me the same shit that happened at my court hearing, right? The judge didn't look at the fucking ticket. He didn't look at shit. And when I questioned about it, he was like, oh, well, let me forward your case over to the prosecution. And I was like, wait a minute. You're telling me my motion is unopposed and you're denying it on your own opinion. And he said nothing.
And you haven't read dick about this case.
Travis, you got this shit down, man. I mean, really, it's too bad that we can't be more Mackenzie friends to people, It would, man. Once you understand this, once that the light is on and you see this, it is really simple. And when you go to court and you watch the sheeple, you get so fucking pissed every time I've been there and I have to wait. I get madder and madder. The one time I walked up, I called the magistrate by her first name when I went through the gate. I was so fucking mad. So,
hey, I did. Whoever recorded this, if I would really like you to send the recording to me, because I want to post it on my YouTube channel.
Are you talking about my court case?
No, not your court case. No, not that. Just this role play session. I think it's gold. I want to put it on.
You mean the Skype?
It is gold.
Yeah.
Somebody typed that in there before. Somebody said that earlier. That's good idea. But it's got to be edited.
Yeah, I've got a recording of it, which I'll post in the chat box as soon as we finish. So, yeah,
okay, great.
Yeah, and you're damn right, Dan. It's a real prize quality 4+ hours at the moment.
And there's a good 2 pages of amazing notes, and that's in short.
You know, if anybody does get this and takes the time to put time markers on it, please bounce them back to me, because that really does help for a resource. You know.
Yeah, I want people to run across it on YouTube and go, "Hey, did you hear this shit?" I mean, even if it's 4 hours, I think people will listen to it. You know.
Anyway, I don't think it's easy. Somebody that was just commenting, the judge guy, you said it's easy. It's not easy. I'm sorry, I disagree with that. It's not easy.
What's easy? Oh, the concept
not
is
for everyone.
or execution is.
The fundamental principle of the Mark Stevens method may be easy, but what he's playing, it's not easy by any means, any way, shape, or form. It's
no,
not
you're absolutely right, Scott. It's very unnerving.
By yourself.
Absolutely.
The only thing that's not easy is when you're standing in that courtroom and the pressure of the guns.
Yeah.
But the actual concept of it, it really is. I mean, think about it.
It is. I
tell
as
you what,
as it can be.
The Mark interviewed on Fabrice's show, and I'm telling you, that show was the narrowing of this Marcratic method really down. It's getting to be tighter and tighter and easier to see it and apply it. All you got to do is understand it and have the balls to apply it under the pressure. That's it.
Yeah.
Okay, easier and easier is not easy.
I said
no, but the question's
not by any means, man.
Okay, so one question just for tomorrow: if nobody clarifies a point, if he hasn't given me a discovery, blank is where I left off in my notes. If nobody clarifies a point, if he hasn't given me discovery, something.
I think that sounds
How
like
could I make a plea?
I was saying.
That's Max. Max is getting ready for court in the morning. He wants to go to bed.
9 a.m.
Yep, I agree, brother. You need some rest.
Okay. Like the discovery and all that other stuff. I mean that stuff you keep in the back burner. That's like Plan D. If you're going to an arraignment, the only thing
is Plan E on my last resort page, but I'm just.
No, listen,
I understand that, but seriously, you're going to wind up confusing yourself. Just take it one step at a time. You have time to deal with it once you get out of court. Once you get past the arraignment appearance, you've got time to file motions. You've got time to do whatever it is. It's not like they're going to schedule you for your trial the next day.
Well, we want to try to avoid getting past arraignment, but I don't know if he's got the skill. Let's not get past arraignment just yet.
And Tom, that's what I'm trying to get him to focus on. I'm trying to get him to put all that other stuff that he's thinking about aside and just focus on like 5 questions and practice them. Go over them, say them like 1 billion times in your head out loud, however it is you have to do to submit them in your head, so that they come out naturally. They come out instinctively. If you can get them to come out instinctively, no matter how nervous you are, they'll come out because they're cemented there. I swear to God, dude, I must have fucking practiced like all day, every day for like a week straight.
But he doesn't have that.
That's how, okay.
Yeah. And I think Travis, you nailed it earlier when you said, a knowing plea. You know, if you haven't been informed, you can't enter a knowing plea. And putting those 2 words together, that seems like a pretty heavy retort for a judge to deal with. Wouldn't you reckon, Your Honor, Tom?
Yes. I mean, it's
okay. And the other thing,
quick question, Travis. Travis, I have a question. Travis, how many times did you have to counter them entering a plea on your behalf?
How many times did I have to counter them entering a plea on my behalf?
Yeah, like how many times did the judge proclaim to enter a plea on your behalf?
None.
Or did you have any? Really?
None.
Well, that's a little surprising.
Yeah, he kept blocking it left, right.
Well, normally one of the things they do is they just start trying to plea on your behalf and shit like that, right?
Well, I think a lot of that has to do with the way I present myself as well. I'm kind of a vindictive, passive person. I'm gonna get you. It's just you're not gonna know I'm gonna get you, kind of thing. So I come in with a very, very different attitude, and I'm very people oriented. I love talking to people, so it's kind of easy for me not to come off as a dick, but kind of seem somewhat genuine in the questions that I'm presenting. I don't know if that makes sense to you guys or not, but
yeah, I guess they just didn't see any, but they knew that you'd fight it instantly. I guess maybe they saw that wouldn't get them anywhere.
Sales.
Yeah, that was it. I was respectful. I didn't get in his face, but I made it clear. I said, "Look, dude, I'm not giving up. I know you ain't got nothing. You know you ain't got nothing. So we can either sit there and drag this out in front of everybody, or you can just kick me out and we can come back later and do it again."
Now everyone in the Skype room knows you got nothing.
Right on, Travis.
Oh man.
Yeah, they go for the low-hanging fruit, and you ain't the low-hanging fruit. You got to snap it at. Come on, reach.
That's why I thought I'd never get a response from these people, but
you will. You just got to be patient. You have to be patient. You have to act like it's a conversation. It's not. Don't go in there and just fucking guns blazing and I need to know this and I need to know that. I mean, that's like the old saying goes: you get more bees with honey than you do with vinegar, and it holds a lot. It holds a lot of truth, man.
You know what, Travis? I hate to admit it, but you're absolutely right. Because I can't stand these people. I like to go in. I dream of going into a court and just telling them exactly what I think of these people.
Yeah, no, it's almost like if you do that, it almost seems like they know what to do. That walks right into their hands, and they like that. When you go in there, Max, you look like you could be fully equipped with a big smile. The innocent your questions stand, so you can just be innocent and charming and polite and well dressed and assertive. That's very clear and concise.
Every time I've ever gone to court, it's a suit and tie. I don't care what anybody says, man. You got to go in there. You got to look good. It's a whole mindset perception thing. I mean, if you come in there with some raggedy shorts and your hair all wild, out of bed looking, they're gonna just not take you as seriously.
Yeah, I entirely agree with you there. It's like if you're gonna go drive a racing car, you're gonna have a crash helmet and a racing suit. If you're gonna go skydiving, you're gonna have a skydiving suit and a parachute.
Exactly. And I mean, if you don't have a suit and tie, just wear a nice shirt
and t-shirt, and a diamond ring, fucking $10,000 diamond ring.
You know what really pisses me off every time I've been in court? Everybody always says, "Are you a lawyer?" And they want to sit down and talk to me because I got my briefcase, and I dress like, and I'm a
lie every time. No lie.
I'm a long-haired freak from the past, but I got my hair cut a few years ago, and I keep it nice and trimmed now. I'm 54, and I look like a fucking lawyer. Can you believe that shit?
I can. Just the other day I walked into the courthouse, and people were looking at me like, maybe I should ask him for advice, like...
Well, if you're getting that kind of reaction, then you're obviously suited up, well enough. If you kind of, like I say, you go down the racetrack and people think you're a hotshot driver, then at least you're putting out the right kind of energy, the right kind of assurance. Whether you are or not probably just depends on practice or firing your mechanics or.
Keeping my anger under control seems to be my tough thing.
Yeah, that pays huge dividends. Every time that I've seen people who dress well, who hold their anger, and like Travis was saying, they're able to keep it like a conversation, without any extras. It's almost like ego attachment. So it's like if they can provoke you into an emotional reaction, then. They can pull out all the basic psycho tricks. I'm so offended by what you've just said that I'm not going to engage with you anymore. I'm just going to push right through it.
All right.
Well, I honestly believe they set that whole place up just to unnerve people. I mean, from the time you walk into the door, I mean, it creeps me out that the place looks like a fucking chapel.
Oh, you know what, Travis? That's absolutely true. Everything about that place, everything. is to intimidate people and make them feel exactly like that.
I entirely,
And
I can't agree with
I know,
you
'cause
more.
normally you wouldn't even ask questions to something like this, you know? You would just say, "Well, they're saying it. It's got to be right, huh?" Like,
well,
I mean, for everyone else, you know, everyone that's not in this chat room right now, millions of people sitting around in these different states and locations, they all just think it's real and they think it's right, just because it's been said so.
well, you know what, man? Ever since I discovered this, I've like nonstop told people about it. I mean, and you'd be surprised, more than I thought would take to it.
Absolutely.
Yeah, well,
And it's
if you make it an option that people can engage with, people will engage with it. You know, you don't have to. It doesn't have to unnerve people. You don't have to, you know, say this is the right way or this is the wrong way. You just show them an option that might well work for them. You know,
Yeah, I know.
and that's, you know, that definitely, you know, helps things along. I think in that way.
It's like, so I can pay $1,000 to get all this stuff released, and me still have to suffer the consequences anyway. Or I can just pay like $50 and have Mark Stevens help me out. Like,
yeah, and
well, I mean,
you know, and learn that, you know, touch of what it actually is in terms of really engaging with the system. What really are the answers to some of those questions?
yeah.
And you know, also the thing that Travis was saying earlier. I mean, here in England we have some really old courtrooms, and those places are set up in a very, very, very religious, mind-altering, environment-altering way, to project different energies at different locations if they're activated. And you being in the dark and the judge being high up on his podium and the other people being placed around, it's, you know, it is designed for that intimidation, but it's a little bit like a subliminal advert. Once you see the subliminal, it doesn't quite work like it used to. You know, once you've seen the man behind the curtain.
So, what evidence they have that I even know what they're talking about in the first place?
well, see, that's the beautiful part. You don't have to know what they're talking about. You don't have to be a legal expert. You just have to know that you have 5, 6 simple yes or no questions, and you can't even get through it. They won't get through it. And me personally, I listened to what a lot of people were saying. I listened to what a valid cause of action was, and I went out and, you know what, I Googled it. I saw what the elements are. I went out and I went to see what corpus delicti means. I mean, these are just basic, simple things that you should, if you're hearing the terms and you don't understand them, you don't feel comfortable asking, just Google it, man.
They're in your motions. That's what I'm saying, Max. If you read the motions that you filed, you will have all the ammo you need right in front of you.
Awesome.
Here's something to keep in mind in line of that. It's not that you have the right to inform yourself of the cause and nature of the proceedings. It's that you have the right to be informed of the cause and nature of the proceedings. So that's an important difference, because
except
theory, they're on the hook. They're on the hook to answer all of your questions, no matter how long they go, in order to prosecute you. And if it's a relevant and unanswered question about the cause and nature of the proceedings, they're on for it. I don't see a way for them to get out of it other than to persuade you to drop the question.
I know Mark told me not to use the second criminal script because it was too long and people were getting it dropped. But
yeah, because again, they start getting upset and really putting the screws down. Why have a list of questions that you're never going to get to because they didn't answer number 3?
You're not going to get questions. I'm telling you, you're not going to get questions. They have to be points of clarification.
Clarification, there you go.
Well, they have to be. They have to.
Seriously, man, you got to break that, dude. Like I said, there's only clarifications and responses. There's no questions. There's no answers.
Well, right. But they're clarifying themselves. You're asking them for a clarification on a point, and they're providing the clarification in a response.
Well, yeah, I understand that. But what I'm trying to avoid is I'm trying to avoid saying to the judge, I have a question,
Exactly.
or Judge, can you answer this for me? That's all I'm trying to do is get away from
Can you
me
clarify
seeing
this? Okay. Yeah, you're
Yeah.
unprogramming your. Very, very good point. Very,
Yeah,
very
it's
good point.
it's an excellent one. I mean, I think I might end up using a bridging term. I can see myself saying, I just have a few questions of clarification. And you know,
by that even more. Your Honor, I have a few clarifications.
Yeah.
Hey, Travis, who'd you get that from?
I don't even remember, bro. I'm sorry.
It was me, brother. I got shot down. I got shot down so many times. Every time I had a question, she said, "Nope, I'm not answering it." That's the judge. She said, "Nope, cops not answer it." She said, "Nope, prosecution's not answer it." I'm sitting there going, "What the fuck? You can't ask questions. They have
Nobody's there to answer your question."
And they'll use any play on words they can to get away from the question you're asking.
Exactly. A question would include all of the above. It would include points of clarification. It would include questions about their mother's whore. It would include, being a whore. It would include questions about legal advice. See, the word question, I guess, the point is it's too broad. It can include tons of irrelevant and things that they're not obligated to provide. And the thing that we are discussing here are points of clarification. Yes,
you said it was a legal objection. There's a real important one. Every time you say the word objection, if a good judge, he'll go, "What are you objecting?" And if you don't have a reason, he'll say, "That's not an objection." Gary said, if he's right, point of clarification. Objection, point of clarification. If that's an objection, that's the best fucking thing you could fucking use.
That is, isn't it? Because then they got to clarify. Damn.
I'm surprised. I'm surprised, Tom, that this hasn't. I mean, I guess it's just been missed in our conversations, but I'm sure the verbiage has been there. It's just, I guess you didn't understand what I was saying, and again, sometimes I suffer from that.
Well, I got lucky and I just stumbled at it, I guess. Because I noticed it started working. Every time I started saying that rather than having a question, I was getting answers. I'm like, well, this is working pretty good.
That's great.
But yeah, man, you know what? It's the hardest part is getting the nerve up and keeping yourself composed. Try not to sit there and shake. If you have to, like what I did, dude, I couldn't stop my hands from shaking, man. It was ridiculous. So what I did was I went up with the judge. I had my little folder, and I held on to it with both my hands, so they couldn't shake. He couldn't see me shaking.
That's a good point.
These are just little tricks that I did for myself to give the judge the appearance that I am cool, I am calm, I am ready to play. Let's play. And
I can do this all day, kind of thing.
Once they get that perception that, hey, this dude, I'm not going to get him fired up. I'm not going to get him to yell and scream. He's just going to stay on point. They can't do anything to you. Let me rephrase that. They can do whatever they want, but legitimately, whatever they do to you will have repercussions.
Mm-hmm.
Yeah.
So we've heard of people being thrown in jail for contempt, unquote. But then after they got out, the judge would backtrack and say, "Well, I'm finding you guilty, and the punishment is the couple hours you just spent in jail, and that's already served. So we're done." And it's like, okay, so you weren't in jail for contempt anymore. He's backing that out and saying that was his punishment for.
But what about the ransom, right? The bail. Ransom bail.
Okay, so be honest about it. What is it? Factually, what was just done?
I was kidnapped and held for ransom.
Okay. Gave them money because you needed to cover the injury that was done to them, and you wanted them to have money to make sure that they were covered for their injury, right? Is that why you gave them money?
I guess so, but they didn't have any injury, right? No, I gave them money just to get out of jail. Yeah.
Okay. I was gonna say I didn't. I was being sarcastic a little bit. Okay. So the truth isn't like they would have it. The truth isn't that you gave them money to make sure that their injuries were covered while you were being accused. and so that you didn't flee and that their injury was left, in their lap. You gave them money for quite a different reason than what they're pretending you gave them money for.
Yeah.
You didn't give them money to secure justice. You gave them money for your safety.
Yes.
Hugely different. So they're calling it bail, but that is absolutely not what it was, right?
Ransom?
Fair enough. Fair enough. Why go with labels? It's money you gave them, so to get out from under some threat of violence, right?
Yeah.
And so it's meaningless, and it shouldn't have been taken, and as such, it should be given back to you.
Ah, okay. Well, yeah. And that's where I go with, should I be suing these people?
Okay,
Like,
so suing them where? Where can you find an impartial judge?
Hold on a second. Dude, that's like trying to say you're going to sue the mob for extortion.
Exactly.
It just
I was
doesn't.
getting there.
That's exactly what I'm saying.
Exactly.
That's exactly what I'm saying.
Have you ever heard of the bar being sued? Ever?
No, but it sounds like a great idea.
Well, I don't mean to come off like a dick or anything, man. But
Yeah.
you got to change that mentality that you have.
Yeah.
That's just
I'm not actually going to use that mentality in court, but honestly, that's what I feel.
Oh no, I understand that, but you just have to look at it like you're just trying to give them as little as possible to leave you alone. Yep. And even going simpler than that, if you go to court, you pop off a couple of questions. They're like, hey, you know what? Talk to the DA. I don't want to deal with you right now. The DA says, you know what, dude? We're going to cut your fine in half. We're going to drop this down to like a 1-point infraction, whatever the case may be. Think about taking it. Just think about taking it, because now you're done. You're done. You don't have to deal with them anymore. You don't have to spend any more time going to court. You don't have to take time off of work or out of your life or any other bullshit. And you've got away far less than it could have been worse.
Yeah, and if you got the attitude that you think, you'd like to go sue them, you'd like to go and hunt out some unicorns. Sorry, an honest judge. And that may be a way to go. I'd seriously think about, actually spending some time getting a video camera, going and videoing yourself, asking some of the representatives some of those questions, and blowing their cover. Because people like business, when it's quite efficient, quite extortion racket, if you start, blowing it up and drawing attention to that, then it doesn't make it look so good, and that's, that's a lot safer than trying to go to court and speak power to so-called authority when that so-called authority has a monopoly on violence. You're much better off using the 21st century tools of the revolutionary, like a Canon camera or a Samsung phone, and or a Barry cam, and getting in there and showing them up to be what they are. The emperor's got no clothes.
Here's a point that I made. Someone brought this up a long time ago about countersuits and so forth, and he thought I was actually joking and being sarcastic and belittling, but you would actually be better off going on a spree of stealing tires and gasoline from police cars to get your money back than you would be. It'd be safer. It'd be safer. It'd be more likely to get you money back than court. And it'd be safer.
Yeah, if money was no objective and you just wanted to end this shit as quickly as possible,
okay,
what would
you were
do?
talking about talking about countersuing. That's obviously not the quick route, right? You're talking about suing them for the injuries they're doing to you. And my point is, you'd be better off if your true goal was to get money for the injuries and get compensation. It's safer. It's probably ethically better, and to go on a spree of stealing tires, wheels, and gasoline out of police cruisers, as risky as that obviously is, it's less risky than finding yourself in court with a bunch of judges who are just
Hey, well, wasn't somebody on here that I remember someone saying something about a dude who like tried to sue some politicians and some judges?
Yeah, we
And
talked about that earlier too. I mentioned him again.
Oh man.
Yeah,
I mentioned him a little earlier. So
yeah, I got a guy coming on the radio show that I do on Wednesday evening in the UK, who's filed private prosecutions against the police force in this country. And that's the first time that's happened in 100 years. He's also got a High Court injunction against the Archbishop in London, in Westminster, so they can't destroy documents that they were intending to destroy, which is also linked in with the same case. And he's a hell of an arse kicker. And a really nice guy, because he gave me and Helen the hand when we were fighting some speeding way back in the day. So I'm looking forward to that. But he got a lot of harassment. It's like quite a lot of other people here when they, when they go and seek to hold people to account who are, supposedly being transparent and honest in positions of public responsibility. That actually, when you hold them to account, it can be a very, very hazardous thing to do to your private life, your family, your peace of mind, and your business. So, yeah, it's very, very different from defending yourself or, going and embarrassing a politician, I think.
yeah, difficult road either way. It's see, going on the offensive. It's a difficult road.
Well, sorry
Well, I'm sure, and that's why it's taking me so
that's why I'm
much
studying law, boys.
Good for you.
I'm going to hold someone accountable. They always
And you
get
think the
down
law?
low.
You think that law is an avenue for that?
I think the law is a really good way of ensuring your own peace of mind and your own ability to defend yourself. I think to go on the offensive, I think it's more transparency and being able to shine a light on things and carry people's attention with you.
So where is the militia police at?
Well, maybe they're the guys standing out there with
the
Canon
police
cameras
that I called
asking the
when I
question.
got kidnapped from the police, like.
Well, maybe the 21st century militia is the guys who are filling up YouTube with what's really happening on the streets.
Right.
Yeah.
Right. I know the cops around here seem to fear cell phones a lot more than they do switchblades.
Yeah.
Yeah, it's the same here as well. I help run the Cop Block UK stuff, and same goes. There are more and more people here now who know, if one person takes out a phone, that other people will automatically take it out just to focus on them to make sure nobody takes their phone out. And so people know how to do that. That's fast becoming a cultural thing on the streets here, and it's making a difference.
So you're vying for the video of the cop taking away the camera.
Yeah, well, it keeps everybody safe because, if they snatch one camera and it's caught on another camera, if there's just one camera, they might think about going for the snatch. They go for two. It's not going to happen, so you've equalized the odds, and that's all you want to do is, if they're doing what they're supposed to be doing and it's above board, they won't mind you having a camera there. So it's a great way of, equalizing out the odds, making sure that everybody behaves well. That's why it's good to have people supporting you in court if you can. Just helps equalize the odds.
All right, so before I found Mark Stevens just this past week when I got my letter, I found the International Tribunal for Natural Justice. Has anybody ever heard of that?
Yeah, I've heard of it. They got some interesting ideas. I think it's probably more effective as a public relations than anything that's going to have too much of a structural difference.
Is that the Rod Class bunch?
It's not the Rod Class bunch. I mean, I don't know. Actually, Rod Class is what I was looking up first before I was looking up anything else. So,
is that where you're trying to bring in the whole postmaster thing?
Huh?
Is that where you're trying to bring in the Postmaster General?
What do you mean Postmaster General?
There's a obviously not the case, but there is also a legal idea. There's a legal idea where there's a whole international law way of administratively handling things over the mail systems, as long as you do it in a certain formality or something like that. Never mind. It's obviously not it.
Huh. I don't know. I mean, I was just looking at post office stuff the other day after I got a call from my local post office saying I couldn't tape shit on mailboxes. Like,
Yeah.
Who's Rod
the idea
Class?
being proper.
Who's Rod Class?
He's
Rod
the guy
Class.
that he was
Physical contracts,
arrested for
right?
gun charges in Washington. He had like 3 guns and cases and lock boxes in his car.
No, I
I don't
think
know, I never
he
heard of
means
that,
in the sense of the legal ideas,
it says Rod Class
accepted for
driver's
value,
license
creditors in commerce.
I think.
Yeah, he's doing the
It's
private
administrative
attorney general
like,
stuff.
yeah,
But I thought
yeah,
it was the
the
website. I
government
thought it was
private
what he
funding.
said it was. I thought I was only on like 1 call from him once.
He sounds like that Canadian guy. What's his name, Gary?
I don't know where he's from actually.
Menard.
No, Menard and the other guy.
North
Menard and the other
No,
guy.
that's Freeman stuff. Yeah.
Yeah. That's what it sounds like.
Rod Class is from North Carolina, I believe, and
Rod.
he proved that
You'll
the
recognize
police
his
and the
voice.
government were private contractors through his
Well,
driver's
again,
license suit, and that they were.
what is the physical differentiation between public and private? You're talking
I
about
don't
one
know.
type.
It sounds
another.
like private. Sounds like anybody can do it, right?
Foreign and
Well,
domestic. Foreign
again,
and domestic is another word for public and private.
Well,
Yeah.
but there is no. But these are things. These are referents without a physical thing. They're abstractions with no physical referent. They're.
No, they
it's
have
not blue,
DUNS
yellow.
numbers. They have DUNS numbers if they're foreign.
No, I mean, but you're saying that nothing domestic can have a DUNS number, and that's not necessarily true, unless you have proof of it being true, I guess. But
they have the zip codes. There's a few,
right?
but they're foreign. It's all foreign. But
you're making an assertion again. You keep making assertions that have no physical referent. It's Bargelfarg. It's like, okay, what is Bargelfarg? Well, it's Gragelfarg. It's like, wait, what is the physical thing that you're referring to? And you're not tying it back to something evidence based. No physical.
I don't know, but smoke 2 of them and call me in the morning.
Right? But you're saying you're saying something is something versus something else.
Well, if you're in violation of the Hague, it's because you're mixing the two. It's foreign, and yet you're going where you're not supposed to. It's like,
okay, but you do accept that this is a legal abstraction without any physical anything, right? This is a purely concocted thought, right?
Yep. It's all bullshit, just like he was saying before.
Okay, so we're in agreement that it's a purely mental concoction, and you're saying it's one way, and they'll say it's another way, right? That a judge will probably not have the same concoction that you do on this issue, correct?
I would say yes.
Okay. Who has more guns to back up his concoction?
Yeah, well...
So you're saying I have a better legal interpretation and a legal system. I have a better one than you do. It's like, okay, that's like arguing about whether Batman or Superman has a bigger dick. It's not, there is no argument. There's no factual thing that you can base the decision upon. It has to be arbitrary. And foreign versus domestic has to be an arbitrary distinction.
I don't know, Gary. Lois Lane might have something to say about that.
Ha 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 ha. But you see, my point is that you cannot be anything but arbitrary in determining a completely concocted A versus B. There is no factual thing that can make it domestic. There is no factual thing that can make it foreign. It is purely legal concoction. And so if they say, well, prove that it's foreign, and there's nothing you can offer as proof because you made it up. Right?
Well, that would be private. You wouldn't be mixing the two in there. You wouldn't be. You can't. They don't mix the two. We can't mix the two.
You're still you're using your own legal concoction to assert.
No. This is a private business that we're in. It's not actually like the Constitution.
Okay.
That's public.
Prove
Okay,
to
that's
me
why you
the
don't
difference.
talk
Prove
about
to
it in
me.
this private for-profit corporation. It's
Prove to
private.
me.
It's their rules. It's not. You can't mix the two.
How do you prove to me that something is private as opposed to public? That's what I just got done asking and kind of clarifying there.
Because it's registered. If it's foreign, it has to be registered to be in this country. That's why
your
my
assertion.
question
I don't see any.
before,
I don't see
I was
any reason
asking
that.
if the judge is a citizen, because a citizen
Hold on.
can't sit a bench.
Before you introduce new assertions, let's go with the one you just finished. Because it has to be registered, and if it's registered, it's foreign, and if it's not, it's domestic. Okay. Prove to me that that's true. What evidence do you have that that's true?
Well, you show me the DUNS number for the.
It's not proof to me. The answer to prove to me that that's true isn't you prove to me that it's false. The proof, you see, I just challenged.
Yes, you're the one making. You have to prove the truth, not me.
No,
You're
you made
the
the assertion. You made the assertion. I'm asking about your assertion. See, you get it switches on you. You asserted that public and private exist, and I'm saying prove it, and you're saying you're the one with the burden of proof. No, the person who made the assertion has the burden of proof. You are the one that asserted that public versus private is relevant to anything, and that's why the burden of proof is on you about public versus private being relevant.
Okay, these courts that you were calling them a judge, it's not really a judge. It's a magistrate. It's a pro temp. They're lawyers. They're not judges. But we're giving
your opinion, right?
You're making it come to life by giving them the credibility. It's like all of a sudden the flat piece of paper jumped up and it's a cartoon moving around dancing.
That's not literal. That's not literally true at all, is it? I mean, you're being allegorical right now.
Yeah,
literally, they're just men and women, correct?
The literal sense is it's business. It's either equity and it's contracts,
literally
or it's something else.
Stop again. You keep saying literally and then talking about figurative. Literally, they're just men and women, correct?
Contracts are not figurative; they're literal.
What do you mean?
There's elements to a contract.
No, contracts are abstract.
It's not. I'm not
talking
pulling out the hat.
Are you talking about the paper that the contract is, what we call a contract? Is that what you're talking about, literally?
I'm talking
Or are you talking about the abstraction?
I don't know. So what's all the point is? I got lost where we were coming from and going to.
Because, again, you kept asserting the difference between opinion and fact and kept shoving opinions down into factual, and I kept trying to push them back.
Okay.
Factually, people are just people. Okay, in an abstract sense, you can call them judge, you can call them magistrate, but those are abstractions that have no physical thing. It's not like everybody who is colored blue is a judge. A judge is just an arbitrary title, right?
Yes.
So there's nothing that causes somebody to be a judge other than the fact that somebody labeled them as such. It's an arbitrary label from somebody. A contract is a concept unless you're talking about the physical paper. Okay, if you're talking about the physical paper, a contract is a physical thing. It can be lit on fire, burned up, whatever. But the abstraction of the agreement is a whole conceptual thing and isn't a physical thing at all.
So an oral contract is not physical? It's just sound? I guess I see where you're drawing, where we're crossing.
Part, there is sound that communicates the contract, but if you're saying the sound is the contract, the sound no longer exists after the fact, right?
Yeah, but we shook on it.
Yeah, that was a physical action that happened.
Sound, yeah.
But the idea that some kind of an obligation persists isn't physical, right?
Yeah, but it doesn't matter the facts because it's all presumptions and assumptions. So the facts and the evidence are really irrelevant because we're believing this bullshit that these guns are real, and they are real guns.
So you're conceding to me that everything you were talking about is an abstraction and is just an arbitrary abstraction at that, correct?
I can't answer that because I didn't know what one of those words were that you said.
Oh, okay.
Abstraction.
Arbitrary?
Hey, Scott, can I ask you something?
Yeah. Uh-huh.
Can I ask you something, Scott?
Go ahead.
All right. Let's say I come knocking at your door and ask you if I can mow your lawn for $50, and you say okay, right? So we have an agreement, right?
Well, I don't have a lawn, but okay.
We'll say you do. All right. Go that far for me, will you?
All right.
So we would have an agreement, right?
That would be an oral agreement, correct?
I would mow the lawn, and you'd give me $50, right?
Uh-huh.
Let's say you had, when I said mow your lawn, you wanted me to cut a ½ inch off the grass, but my mower only did a ½ inch, right? And then you would say to yourself, well, he didn't uphold his end of the deal. I'm not going to pay him the $50, right?
Until he mows it to the right length, and then I think he'd be motivated to cut it again.
So you would convey that to me, and then I'd say, well, okay, I'll either do it or I won't. But one of us, if I don't do that, or if you pay me the money and you're unsatisfied, you get screwed. If I don't,
well, you wouldn't get paid till after you did it, or at the end of the week, or the end of the month, however that would work.
One of us is going to get screwed until we work this out, right? But the point that Gary's trying to make is bringing in third-party interlopers that don't give a shit about us in the first place, right? And using all these legal abstractions to screw one of us, probably the one that doesn't have enough money to pay them. Does that make sense to you?
Well, it would actually depend if you really were meaning to screw me, or you really didn't know that cutting the lawn meant to cut it so that it looks nice. But I don't know. I wouldn't know your history. I would ask for references. Can I see some pictures of other lawns you cut?
You're trying to add shit to the hypothetical. The hypothetical was only about the miscommunication.
You know, like a before and after picture.
You're trying to retroactively solve the problem as if you knew ahead of time that the problem would come up. And that's not fair. You didn't know. You disagreed about what cutting the lawn meant.
Yeah, but right? I have the ability to renegotiate, and I think if you did it while I wasn't home, I would think you were a moron, and maybe I would just pay you $50 to make you go away. And if I thought you just were in air, then I would, say, well, this isn't really, sufficient. I came here for you to fix my brakes, and I still don't have brakes. So you don't expect me to give you the $50 until you fix the brakes. Is that correct? So I would bargain and renegotiate that. Come on.
Okay, so you're saying that contracts don't exist.
Look at the guy across the street. Look at here, and look at yours. Now, don't you think something's wrong with this picture? And I would clean it up right there because I didn't pay him yet. That's why they don't give you card that until you pay him.
So you then
go to a mechanic.
Are asserting that the concept of contracts. You're asserting that contracts do not exist because they can be renegotiated at any point, even after performance.
Well, they can exist in our mind. They can exist on paper, but
if there's any disagreement. Okay, so basically, it's just a suggestion. It's nothing binding. It's just it's just something to kind of guide our thinking a little bit. Contracts aren't binding. They're just tentative.
And another little sideways point here, just to bounce in there, that contracts are also open to interpretation as well. Because when Dan said,
kind of where it was going.
I'll mow your lawn for $50, how did he know that he wasn't gonna, Scott didn't think that, he'll come and mow my lawn and he'll pay me $50 for the privilege. Because actually what he said could be reinterpreted in both ways. And, I mean, that just brings back, again, right back to Gary's point, that, with a lot of these constructs, they are arbitrary, whether something is public, private, foreign, or whether it's a contract or binding. A lot of those are arbitrary in terms of the necessity to define terms.
So therefore, you would have to get $50 anyway, even if he did a shit job. And that's why I would say then I would pay him to make him go away and I'd get someone else. Yeah, but there's many ways to handle.
I was Scott. I was just trying to point out how wrong it is to bring in third-party interlopers, i.e., the government, to solve disputes.
I agree with that. I wouldn't bring in a third party in Thorpe. I wouldn't then take it to small claims court. I would simply just pay him the $50 and get someone else for next month.
Well, no. Well, the analogy notwithstanding, I was just trying to point out that what Gary was trying to say, these are all abstractions, all these legal abstractions, is people believing that they can take third-party interlopers to solve their problems between other people. That's all.
Yeah, I agree with that. That's the cause of a lot of these problems. Nobody does anything. Although people are learning now not to call the police. I don't call 911. When we had this crazy guy here, I didn't call the freaking cops. If I was going to have him arrested, I would have written something down and brought it to the prosecuting officer, the cops or something. I wouldn't have actually called. But that's what people believe is the proper thing to do. They tell you if there's a burglary, you call 911. Yeah, and then the police come and shoot your dog. And then you realize, oh, I should call 911. Calling a third-party interloper maybe isn't the problem, it's the solution.
One of the defining characteristics of Bitcoin, for example, and all cryptocurrencies, is that it's permanent. A government or a court cannot intervene and undo the expenditure. And that's one of its strongest points, is that no one can forcefully undo money once it's spent.
The Federal Reserve will. You watch. They'll be just like Kennedy. Bullshit. I don't agree with that.
No, wait a minute. Right now,
they'll wipe that out overnight if they want to.
Right now,
I don't want to discuss the constructs of cryptocurrencies and why they safeguard against that. Really, but again, you might be right. But it's a very difficult conversation to have. Let's put it that way.
Yeah, and that's not something. I'm not a money person. However, I actually am doing this more so to get someone fired and removed from power than to get restitution. But I'm really telling you, some people go to these courts for restitution. If they can't get your restitution for your property being stolen and broken, well, who needs these courts? So I'm trying to take my case 10 years ago to these courts for the purpose that you're saying is put you in danger in this. I've been in danger since day one this happened. I don't care. But my legacy is I found something that's not acceptable, and it's not something huge and bigger than me that I can't handle. It's a bunch of local dirty freaking cops here being protected by all their other dirty cop friends.
And why is it you feel that the court is the place to go for this?
Because that's what I learned with Mark Stevens. That was the principle. You can actually ask questions of these people. I never knew that until I found Mark Stevens.
Wait.
Wow.
I never knew that you could question what these people with the guns were doing until I found some video from Mark Stevens. It's in a green T-shirt. This man's a genius. And that's how I found Mark Stevens. And that after about a couple of shows, I realized that you can actually question these people with the guns that are out of control. And I've been studying and doing due diligence, and I see some remedy in, because they're pretending to be government.
Mark Stevens, I've never seen Mark Stevens stuff be associated with getting remedy as a complainer in a court, as one bringing the suit.
Yeah, me neither, Gary. Me neither.
You're not me. I'm a visionary. I look at the world differently.
I understand. I understand what you're saying. I have, things like 1205, 1215, and stuff like that. That kind of stuff I've seen.
That's a Rod Class thing.
No, Rod Class isn't 1215. That's
his website.
No, 1215.org is not Rod Class. I can guarantee you that.
And who is that? I'm mixing them up. There's so many gurus, I mix them up. Who's 1215? I know it's his website.
It's, the guy with the big beard. Hold on. I'll get it in a minute.
I don't even know them from look. I'm on every freaking call there is. I've been on hundreds of these calls. And I don't know half of them.
I've successfully used this stuff, and I don't even remember.
Hey, Scott, do you think Mark Stevens is a guru? Do you see him as a guru?
No, I don't look at him as a guru. That's not a name that I use. If you actually look up the term what a guru is, it's nothing like that. However, no, I don't look at Mark Stevens as a guru. I look at Mark Stevens as an inspiration that across the board, universally, he can show people how to ask questions that can expose things that they don't want people to know. in a nutshell, he's a freaking genius, just like that video says.
Bill Thornton. Bill Thornton.
Oh,
is
Bill
the word.
Thornton. That's it. I get them all mixed up. Yeah.
Now, here's the thing. Bill Thornton, if you try to imagine that he's not just treating this as a legal abstraction, you'll think he's an idiot. But he is basically saying, you know, you have to take the attitude that it's like, well, okay, if you're proclaiming that you get to be the tribunal, I'll proclaim the same. And then you get to argue with me about why I don't get to be the tribunal, but you do. And that's really the center of Bill Thornton.
I like that.
Well, but again, that is on the aggressive side.
I've heard.
Does it work? How does this work? I mean, again, you're trying to goad them into an argument that they can't win, because their idea that they get to be tribunal and you don't is arbitrary, and you're pointing that out as well.
Yeah, the difference between Mark Stevens and someone like this guy you're talking about is Mark is using their rules and their proclamations against them. Like everybody knows.
Yeah, exactly. That's why it gets me right in my heart. Yeah, exactly.
Everybody knows that you're supposed to be innocent until proven guilty, correct?
Yeah.
Everybody knows that.
Exactly. Yep.
But that's not the truth.
But there's no such public relations on the prosecuting side. If you're the moving party, there's nothing you can do to stop them from simply dismissing your case for dismissing you for failing to state a case. There's no defense against that. They'll just dismiss you for failing to state a case, and you're done. And there's nothing, and the appeal will uphold it, because they'll say, yep, you failed to state a case. Guess what? Why? Because everyone fails to state a case. There is no such thing as a case.
There is once we plead not guilty.
Well, you're acting as if there was one, and you've dropped the issue. But that doesn't mean there was a case. And again, if you're trying to use Mark, it's almost like trying to use a block in order to damage someone. It's a blocking maneuver. It's a damage control maneuver that really has its roots in questioning, Socratically, challenging. But as the one who's suing, you can't stand back and question them. You can't be neutral. You can't be skeptical. You have to be on the motioning side.
You have to.
How can you be a skeptic? Yeah, you have to be taking the position. You can't be skeptical and suing somebody. It's not possible. So that's where I'm having a little bit of trouble. You're saying I'm taking this Marcratic, I'll use Tom's term, Marcratic approach to suing somebody, and I'm like, well, how do you take skepticism and make an assertion? That's
are you saying I'm skeptical? Are you saying I'm skeptical? I don't know who's being skeptical.
This approach is based upon.
Oh, are you just saying that saves you from being able to make an assertion by being skeptical at the same time?
You can't be skeptical and assertive. They're opposites to each other.
Well, I know. So if you claim to be skeptical,
oh, so you mean someone making a suit is being assertive and Mark is skeptical? Correct. Is that what you're saying?
The whole thing we're talking about, this challenging jurisdiction and challenging a burden of proof, is skepticism. That's what it is. And okay. when you're suing somebody, you cannot be skeptical.
Yeah, I didn't realize you were saying Mark was skeptical.
I'm sorry.
I got you now. Now I got you. Yeah, okay. But I took it a couple of levels up. I only started with Mark. That was the first thing I ever found.
There are no levels up from Mark.
Oh, yeah, there are. Oh, yeah, there are.
Now, and I've been at this for a lot of years. I've used Bill Thornton's stuff to actually get myself out of a huge suit between huge companies.
Yeah, I've heard a lot of people give him credibility, and I've heard a lot of people rip him apart and even tell what his bad stuff is. There's a lot of credibility in him. I've heard that from many people I deem reliable. And I've never looked at any of his stuff, though. Never saw even one video from him.
I could care less if he's Hitler or Mother Teresa or what. The point that he makes is either valid or not valid. And the reason he's made some good points.
Is he valid? You're saying he's valid, right?
There is. We can have a discussion about the validity of Bill Thornton.
Even a little. It doesn't have to be either. He's totally bad, or he's got a little bit of validity, or a lot of validity.
There is a huge point to be made in
Why
arguing
are you asking
that
him for validity?
You have the same right to be tribunal as the.
Don't ask him for validity. Figure that shit out.
Yeah.
Well, I understand your point you were making before, because if you're bringing a suit or a claim or any kind of thing, you can't ask questions. There's no questions in a suit or a claim.
Yes, you make your assertion.
There's not one question in there.
You argue your case, and it's up, and you present your evidence as to why you're right and why they're guilty and why they owe you money, and then you sit back, having proven your case, and wait for them to show fault in your case, right? And the Bill Thornton centers, and I'll probably in the rough sense, around the idea that you override the judge when he acts as tribunal instead of judge, and you say, no, you're not the tribunal. I'm going to act as the tribunal in order to goad him into the argument about who's the tribunal. And then when he starts arguing about, I'm the tribunal, you simply ask, why are you the tribunal instead of me? I brought this suit, and the defendant didn't request a jury yet. Why are you acting as tribunal? It's either me or a jury. Those are the two choices, not you, the third party, the judge. So you're saying the tribunal is independent of the judge, and that's the point he's making, is if the judge tries to pull to himself the powers of tribunal, you slap him down on it, because there is no such concept. He's just trying to do it. And you say, what is the reason that you have for trying to make a tribunal decision as judge? And then you just reverse his order, and things like that. You ceremonially vacate his order and do whatever you feel is right, and you provide due process and all this stuff. Now, conceptually, this is just as valid as the bullshit that they're doing, but that's the problem. Is it's all conceptual, right?
Yeah, and we're giving it credibility. Everyone.
Okay.
And each year they take that credibility we gave them, and then they increase and turn it up a little further, and they added some new thing and a new thing and a new thing.
Okay.
It's going to be $4 to pee. As in January, they're going to make it $4 if you got to pee. Yeah.
I can't even keep up with you add assertions while we're still discussing earlier ones, so I don't even know what to do with that. It's like, man, I'm trying to nitpick, I guess, about an earlier point, and you're off 3 points later. It's like, you're way out on the branch that I'm trying to kind of establish the root of,
Yeah, well, my mind's wandering. We've been on this call for hours. It's 11:30. It started at 6, 7, 8, 9, 10. It's been about 5 hours, I'd say.
Yeah, that's been a good call. It's been a good call.
Yeah.
I understand, and I'm not faulting you for it. I'm just pointing it out. It's like, wow, it's if you. And in court, you got to keep those baby steps. You got to make a small point.
Oh yeah.
Small confession. You don't want to be all over the place with with judges and lawyers where it's a formal setting and it's supposed to be like a formal, highly constructed, rational discourse. Oh, excuse me, I can barely say that. There's a weird metal taste in my mouth.
I think you managed to spit that out just about okay, Gary.
But where that's the pretense, at least. And you're pointing out, of course, that they're sneaking in arbitrary opinions, they're sneaking in biases, they're sneaking in presumptions, they're sneaking in all these logical fallacies and all this stuff. And that's the point, is they're building their mess upon logical fallacies and misdeeds and presumptions built on presumptions and crap like that.
And also silence.
and
when
and
you're
a lack
silent,
of information.
you're reacting and assumptions.
Well, yeah. And again, you can counter that if they said, well, you were silent. You can say, I had objections, but it was not safe to voice them. And I was only silent because of the threat of violence.
I don't remember.
That whole silent acquiescence is out of the water. You've just blown it up.
There is nothing I feel I can safely do now.
And they'll probably jump up and say, there's no threat of violence here. No, we're just doing this. We're providing you a nice, fair service, and your day in court, and blah blah blah. I mean, it's funny, but that's almost predictably how they react.
Well, we're getting benefits. These are benefits and privileges they're providing for us.
Okay,
Jail is a privilege.
Hold on.
3 hours in a cot. Come on.
Yeah,
Where do you get that?
And they will phrase it that way. They will phrase it that way. The benefit of jail. They will phrase it the benefit of prosecution, because the presumption is
benefits, right? Can't you just waive the benefits? Like
waive the benefits? Yeah, well, you can waive them, and they'll, it's like, well, no, you can't waive their benefit for them. You can waive your benefits, but the benefit the prosecutor won for himself, you're not going to waive for him.
Well, if I waive my own benefits, then there's no longer apply on me, right? Because that's part of the contract. But
well, you've already given them bail. I used the wrong word of bond earlier, and
I know, right? They wouldn't even
give them bail.
In jail.
So
where there are
you already accepted them.
Well, where there are threats, where there are threats of violence, there are no benefits, there are no agreements, there are no bails, there are no bonds. Where there are threats of violence, there is nothing but violence. So all these terms that we are using, again, we use them commonly. I understand that, but all these terms we're using are actually improper.
Yeah. Okay.
Where there is violence
in the first place, yeah.
Where there is violence at the outset, okay. Where a mugger put a gun to your head, you didn't gift him your wallet, right? You didn't give the mugger your wallet; he took it.
Well, these are their terms, and they're patented. Whatever the word is.
Again, so the terms also have an English meaning, and when you say agreement, and when you say bond, and so forth, I'm clarifying that we aren't talking about the plain English language. We're talking about violence here. And if you say that rape and lovemaking, I'm defining them as equal, and so I just made love to that woman there instead of raping her, that doesn't hold water in a conversation. You've just undefined what we're talking about. You know what I mean?
Well, try to get the woman you raped to make you dinner the next day.
Well, and what I'm saying is the thing formerly called agreement has nothing to do with what we're now calling agreement, if violence is okay. Right? So how do we talk about the thing we used to say is agreement? If you're absconding with the word agreement and contract and all this stuff to include violence and to include mugging and this subjugation that these bureaucrats are doing, then we need a word for what used to be called voluntary, right? So just like with taxes, if taxes are voluntary, we need a word to talk about what used to be called voluntary, because they just screwed the word up to mean the opposite.
Yeah, I get that. So
there we are.
Well, they do that with all the words. It's not just that word; it's all the words. That's why it's called code. It's the legal language. Freaking word. It's a complete opposite of what we think it is.
Yeah,
one word at a time. They did it too. They didn't do it all
the legal language has
one word
nothing
here,
to do
another
with
word
English.
there, another word.
The legal language has nothing to do with English, and if you try to interpret it with English, you're going to be wrong, and they're going to bitch slap you about it, because, again, that's why you want to be informed of the cause and nature, not inform them of the cause and nature of the proceedings.
Yes, absolutely.
Hey, would y'all repeat to me what you just said, in terms of something about the English language, and I don't actually know how to interpret it, so I need an actual dictionary full of that crap before I can even inform myself rightfully, right?
It's not that you have the right to inform yourself of the cause and nature of the proceedings. So get that out of your head.
Okay.
You have the right to be informed. If you ask them,
the right to be informed.
If you ask them, do I have the right to be informed of the cause and nature of these proceedings? And they say yes, you've got them. If they say no, you're fucked. But then you go down a different road entirely. Because then it's like, okay, well, I'll go home then, because obviously I'm not here to do anything, but except be punished. But it's not that you have the right to inform them.
Okay, we'll do
Well, you
one now.
could make sure that gets onto the record so that you can hold them against them later if they do. You know, you're setting it up for,
right.
you know,
They
it's
say
all the
yes.
procedure.
If they say yes, you have the right to be
wrong,
informed. Then, by George, if by the time I was done being informed of even the most mundane charge, let's say jaywalking, if they said you have the right to be informed of the cause and nature of these proceedings, I'd be like, awesome, we're writing a book. It's going to be a bestseller. I have so many questions that are yet unanswered in history about the cause and nature of even the most mundane proceedings. And we're going to write ourselves an encyclopedia about the nature of precedent and when precedent, when justice gives way to precedent, and when what is contempt. Let's clarify all this. We have chapters to write on the topic of contempt. That is all that he just got done in saying. You have the right to be informed of everything related to what's going on, and all you can come up with is, can I plead guilty now? Or you know what I mean? Not you, but most people.
Yeah.
Right?
That's a good
most
point.
People, yeah. And then when you come to an appeal and so forth, you know that panel's looking at going, you know what? That motherfucker didn't give a damn about it when they read him the charges. They said he stole a car. He didn't care about what color the car was. He didn't care about what the procedure were. He didn't care about nothing. He knew what the score was. He knew what the color was. That guilty bastard should be in jail. He didn't do nothing but plead not guilty. He was just hoping to be lucky because he didn't care about nothing. Same thing. If I came up to you and said, buddy, you stole my car last night, and the first thing out of your mouth was, you can't prove it, I'd smack you in the face, right?
Dude, that just happened to me last week, basically. But with a camper, not a car.
But if I'm watching this happen, if I'm watching two people have this discussion, and the person who was just accused said, well, damn, what color was this car that I'm accused of stealing? And the guy who just accused him says, you know what fucking color? Pay me. It's like, wait a minute, why did you just say color? Why did you just give a big old speech about how he knows what color it is instead of saying blue?
Is in the Crayola 64 colors? I've never seen that one, sir.
But you understand the point I'm making is that
you have no questions.
Yeah. When you have no questions, that means that shows how guilty you are.
I know, right? So that's part of the thing about getting stumped.
That was the same fallacy ad, like and whatever you said before, right? Wait, hours ago? Oh, that wasn't me. That was the judge dude.
Tom.
No, I was discussing policies. I don't know.
Yeah, somebody earlier. This call's been a while. It's been a long call.
Yeah, non sequitur was one of them.
Which is unusual for this group. A lot of the calls I'm on are long, but never Mark Stevens calls. They're always short, comparatively.
Oh, well, depends. We got somebody under the gun here. Usually I would wrap it up and let him think about it, but he's got a one shot, so he's got a lot of adjusting to do before morning. Normally, yeah, we'd give a little intro. I'd send him off with some videos. We'd have some group calls more later, whatever. We'd make him be defendant, make him be judge. A little bit would be nice if we get there.
Huh.
So the judge's role, though, right? You know what the judge... I mean, Tom demonstrated
to
it very
assume me innocent?
No. What his real job is. What's his real job? To keep you from blaspheming their system, right? It's just like a priest. Priests keep you from blaspheming against God. That judge is going to keep you from blaspheming against justice, against the legal system.
He's going to make justice look good. That's his job there, is to make justice look good.
Should I write
and
that
hopefully
down?
Take your money as well.
Well, okay. And you're going to see it, the judge. He's going to try to, you're going to say something that upsets his concept of justice.
His job is to polish a turd and convince you it's a diamond. That's his job.
That's what's getting written down right now.
Yeah. To feed you that shit sandwich and get you to call it a sandwich instead of calling it shit. Never call the shit sandwich anything but shit. It's not that you don't like the sandwich. It's that it's shit. It's not an, you know, it's not this is not a, what are they, something I'm going to call it? This
It could
not
be
a fair
good shit. It could be shit with corn in it. It doesn't matter. It's still shit.
Matter. It's still shit.
Okay.
No. People sometimes say it was an inadequate hearing or something like that, or it's like it wasn't a hearing at all. It was just crap. You know. You know, it was a flawed arraignment. It wasn't a flawed arraignment. It wasn't an arraignment at all.
Okay, well, I'll definitely be back. It's about 11:38, and I'm gonna wake up at 6. And I thank y'all so much for being up with me. But
it was fun, boy.
Let us know.
This is an awesome community y'all have going on, and I'm glad that this kind of
know that you're not in jail.
I will.
Know that, you know, that is one of the biggies. You know, say, hey, you know, it may not have gone great or bad or whatever, but I am not in jail.
And if you're in jail, you could tell everything to everyone in there. You know.
Absolutely.
A heads up.
Yeah, I super appreciate it.
Sure.
All right, kids.
I had fun.
All the best, mate.
If you have
angles.
We are only here on the I was going to say I'll stick the file in the chat box after we signed off. But all the best in court tomorrow, mate.
Yeah.
Awesome.
Yeah.
Thank you very much.
We'll be thinking of you. I'll be thinking of you. I'll roll over and think about you in the morning.
I appreciate it. 9 a.m. y'all Eastern time.
I go to sleep around 7 a.m. All right.
Thanks, you guys. This is a lot of fun.
Yeah, it was really fun. I really had a good time. This is my first Mark Stevens thing. All right, cool.
We'll chat again. Take it easy.
Yep. Good night.
Good night.